Rules Committee will come to order, and thank you very much for joining us this afternoon. Yesterday there was an announcement that we would begin the process of the rules to make sure that we began the discussion of the NDAA with today following up where we would take the amendments, a series of amendments, and I see a group of members that are prepared and ready. By the way, our microphone system is working today. We may have it tuned up a little bit too much, but I'll let somebody figure that out. Gabby, can you hear me? Cannot hear me. Can you all hear okay? Or is that too much? That's too much. This is a test, I guess, is where we are. Okay. Thank you for joining us. Our Rules Committee will meet to consider amendments for H.R. 4435, the National Defense Authorization Act for fiscal year 2015. This year, the committee has received over 300 amendments, and the Rules Committee is in the process of looking at these 300 amendments. And I will tell you that every member that has shown up today is very serious about not only the things that they intend to present, but the committee is equally eager to hear from you, to know the ideas that you have, and to make sure that we diligently consider these issues. We have a very important job in this process, and that is to make sure that we understand what you're talking about. So the committee, as you may be aware, is interested in probably some questions, making sure we know enough information to the extent that you have an opportunity to clarify what you're about in specifics. It gives us an idea about why that is important. So I would like to, before I move further, to yield to the gentleman from Massachusetts for any opening statement that he chooses to make. Gentleman is recognized.
Just want to welcome you all here and hope all your amendments are made in order. You're back my time.
Great. Thank you very much. All right. At this time, I'd like to call the first panel in. It's my understanding that all of you sit on the Armed Services Committee in the first panel that we'll have. We'll come on up here in any way. Tammy, I'm going to let you get up there first so that we make sure that you position yourself properly. And Jim, I'm going to let you do that also to make sure you're in a comfortable position. And we're delighted that you're here. Jim knows me well, Tammy, and he knows I try and do the things that we want to make sure that he's up here and situated. Is that good, Jim? Tammy, you good? Good. I'd like to also join in the in this panel the gentleman from Colorado, Mr. Kaufman, and Jackie Spear. I saw Jackie right there. And Tulsi, I'm delighted that you're here with us today and would ask that you pull up a chair next to Mr. Kaufman, and Doug will help you do that. Got an extra one. And it's my understanding all 5 of you are members of the Armed Services Committee. And the way we operate here is that we're delighted that you're joining us. We hope if you have anything in writing that you'll be pleased to enter that into the record without objection. Anything you have in writing will be entered into the record. And then to give us ideas about why you're here, what we need to do, and how we can better understand your amendment. With that said, the gentleman from Colorado, the gentleman, Mr. Kaufman, is recognized.
Thank you, Mr. Chairman. You know what? I don't have numbers associated with these amendments.
Well, we'll try and work through them. You really bring up a good point. As I always state, please tell us the number that you've got. So why don't I ask staff real quickly to look up here. Mike, I see 33, 34, 35. So I'm going to ask Doug, can you come get this and make this available? And then I'm going to put a pin with this. And Doug, you need to get a highlighter so that people can then highlight it. Let's give that to Mike first. Next, I will be going to Jim. You will be second. So when Mike goes through and marks his, we're going to get a yellow pen for you, Doug. That way you'll be able to highlight your amendments and see what number they are that corresponds with your piece of legislation. Next will be Tammy Duckworth after Jim. Next will be Jackie. And then last will be this young woman who's from Hawaii.
Yes, we are a state.
Oh, yes, you're a state, so yeah.
Thank you.
Territory of your own, right? The land of milk and honey, is that right?
True.
All right.
Aloha.
Yeah, and aloha. So, Mike, as soon as you've identified those amendments and put some number
Sure.
on them, it will help us out. Thank you
Okay.
very much. And then Doug has the marker there, and then Jim will get that list next, and then you'll be prepared. Gentleman's recognized.
Thank you, Mr. Chairman. So number 34 is my First Amendment, Kaufman Waltz. And what this amendment does is we've had a big story back home in United States Army in Fort Carson in terms of giving less than honorable discharges for soldiers coming from Iraq and Afghanistan that we believe have PTSD, and they're discharged with no access to mental health care from the VA. And what this allows them to do is to be able to review those discharges if, in fact, that service member feels that their PSD should have been a factor. And usually there's been a pattern where these are really minor infractions, and it seems that it feels as a former soldier that this is really part of the downsizing and it shouldn't be occurring this way. So that's number 34. Number 35 requires the Department of Defense to consider the closure or realignment of DoD facilities located outside the United States. This isn't looking, if we do a BRAC, a base realignment closure process, and this doesn't say we should do a BRAC, but it says if we do a BRAC, that we ought to look at overseas installations. Right now, the way the BRAC has been, when we've done it historically, it only concerns military bases within the continental United States. As a retired military person with 5 overseas assignments, when I look at, I was in 1st Armored Division in Europe, when I look at the permanent bases that we have in Europe, they ought to be part of the mix, as are in other places of the world where we have housing for dependents, we have commissaries and schools and all those things that we have in bases back home in the United States. So I just think, and particularly when we've got a significantly better capability in terms of deploying troops in a timely basis to different regions within the world. 36. 36, I know that there's I think a budgetary point of order may have been raised on 36, but 36 would allow undocumented young people who were brought into this country oftentimes by the parents, grew up here, went to school here, know of no other country, an opportunity to serve in the armed forces of the United States and earn a path to citizenship through their military service. 37, I think there's been a requirement for almost 2 decades for the Pentagon to have auditable financial records. There just hasn't been teeth to that requirement. This, in fact, says that if you do not have auditable records, I think by 2018, that in fact the DFAS, the people that are responsible for doing the financial management, would come under the Department of the Treasury. This is what occurs in other departments of the federal government, and they in fact other agencies of the federal government, and they in fact have passed clean audits historically. Let's see. And I believe that is it, Mr. Chairman.
Great, Mike, thank you very much. Was that 4 amendments?
4 amendments, sir.
4 amendments that the gentleman from Colorado has, and thank you very much. And does any member of this panel have any problem sticking around for questions, not competing against anything else? Thank you very much. The gentleman from Rhode Island, Mr. Lanchin, is now recognized.
I believe I have 2 amendments. I believe they're 289 and 290 are what I have on my notes here. But, Mr. Chairman, members of the committee, I do have some formal remarks, but just to put it in context, my 2 amendments focus on cybersecurity We have a real problem. Clearly, cyber issues are a growing threat and challenge to our nation's security. I've been working at this issue for many years now, including chairing a Homeland Security subcommittee that's your jurisdiction over cybersecurity, as well as serving as one of the 4 co-chairs of the CSIS Commission on Cybersecurity for the 44th Presidency, which put forth the blueprint of how best to do cyber.
Excuse me just a moment, gentlemen, please suspend. If we've got somebody I know is listening on with this, if we'd be aware that the gentleman, Mr. Burgess, who sits on the outside, cannot hear, and so I don't know whether I'm not blaming you at all yet, Jim. I'm simply saying we're still tinkering with this, and so I've got staff that's listening to me at this time. Mike, would you do me a favor and punch your button and see if we can hear you properly? Sometimes we've got individual systems.
Sure. Can you hear me?
Not now.
Okay.
So
it's a problem?
We could hear that. So, all right, your system is working and on, so we'll be aware of that. If I could have you to ensure that you speak loudly or into it. Once again, we had some outside networks in here a week ago, and so it messed up our system just a little bit.
Good enough. I just brought the mic closer, so
I hope that helps then.
Okay.
And Dr. Burgess, if you'll let us know if that's a problem, and Jared, if that's a problem for you. Otherwise, gentleman's recognized.
Thank you, Mr. Chairman. Just to continue, as I said, my 2 amendments deal with cybersecurity. One of the problems that we have, first of all, we don't have anyone that is actually in charge of cyber. We have silos, and certainly among the best areas where we're protected and organized is in the protecting the .mil network with NSA and Cyber Command. But the closest thing we have to someone in charge, certainly on the non-military side, is the cybersecurity coordinator in the White House. And the problem with that position, although Michael Daniel has a great skill set and the toolbox to do the job, and he's doing the best he can, he doesn't have any real authority. It's more of a coordinated position, but doesn't have any real authority. One of my amendments would change that. The other challenge that we have is that much of the damage that could be done to our nation's economy and potentially even to loss of life, leading to loss of life, would be an attack on our critical infrastructure. And again, no one is really in charge there. In fact, many of our agencies that oversee critical infrastructure do not even have regulatory authority over those various areas of critical infrastructure. So my amendments would address those. First, with respect to, it would establish a director's position. The First Amendment would establish a director's position in the White House that would be Senate confirmed. That would put somebody in charge of cyber. The Second Amendment would do both. It would establish a director in the White House that is Senate confirmed, and but also would give greater coordination between DHS and critical infrastructure and those entities that oversee critical infrastructure. So with that, Mr. Chairman and Ranking Member Slaughter and Mr. McGovern and other members of the committee, I do want to thank you for the opportunity to speak on my amendments, number 289 and 290 to H.R. 4435. Similar language has passed the House before during NDAA consideration without objection, but was unfortunately removed during conference with the Senate. Amendments 289 and 290 would coordinate efforts to secure federal networks and develop smarter cyber policies by establishing a national cyberspace office in the executive office of the President, and empower that office to require that agencies have strong information security policies. Not only would this office ensure coordination during a serious attack, it would also have budgetary oversight powers backed by pay-performance authorities, and would be accountable to Congress through reporting and Senate confirmation. These authorities are essential for any administration to deal with the poor federal coordination experts have lamented, and provide valuable additional oversight to Congress. Amendment 290 goes a step further and implements additional reforms that have been suggested many times by various groups, beginning with the recommendations of the CSIS Commission on cybersecurity for the 44th presidency, which I co-chair with my friend Congressman Mike McCall, the chairman of the full Homeland Security Committee at present. In addition to the creation of an executive office, Amendment 290 would increase coordination of DoD and DHS cyber efforts. It would close gap in authorities to protect critical infrastructure, implement automated and continuous monitoring of agency networks, and require more secure federal acquisition practices. The passage of similar language to these amendments 4 years ago helped spark renewed action in the Senate. I hope its passage this week will do the same, as these amendments simply build on successful action from previous Congresses, and I respectfully ask that you again rule them in order. And while I firmly believe that the full language of Amendment 290 deserves renewed consideration in the wake of past legislative gridlock, at the barest minimum, I ask that you allow the full House to vote on the provision to establish a national cyberspace office to deal with the myriad of increasing threats in cyberspace. With that, Mr. Chairman, I thank you and the members of the committee for your time, and I'll yield back.
Congressman, thank you very much. Most insightful, and I'll have a question for you when we get to you. Congresswoman Duckworth, welcome to the Rules Committee. It's not your first visit, but we're delighted that you're with us today representing your committee, and the gentlewoman is recognized.
Thank you, Mr. Chairman. It is my first time here, so it's
Oh,
great
it
to be
is?
here. It is.
Well,
Yes,
I've been wrong before. Can you tell me being wrong?
It's my first time. Mr. Chairman, my amendment is number 240. It comes out of some of the work I've done both as a new member of Congress, but also through my military service. My first and only codel as a member of Congress was to visit Afghanistan for Mother's Day. And I heard firsthand from many of the military men and women about the hardships that they face. And one of the hardships that they face has to do with maternity leave. What my amendment would do would be to give the option of 6 additional weeks of maternity leave, unpaid, to this female service member and her commander, so that instead of just the 6 weeks that they get now, they would actually get as many as 12 weeks total. The additional 6 weeks would be unpaid. It's called the MOM Act, Military Opportunities for Mothers Act, and my amendment has no cost to taxpayers, and the Congressional Budget Office also agrees that it will not have a cost. I think this is a good bill, this is a good amendment that at a time when we're trying to support our military men and women during budget constraints, it's a way that we can help them, but also to keep an eye out for costs. Civilian women and federal employees get 12 weeks under the Family Medical Leave Act, but the FMLA does not apply to military women, and they are currently limited to 6. Their commanders, if their commanders wanted them to take more than 6, could not allow them to do so. And all this bill would do would be to provide the option of 6 more weeks. There is a clause in the bill that the commanders can recall the female service members during the second 6 weeks should the needs of the unit arise, and that the leave can be declined at any time, the leave can be denied, they can be recalled. But this at least gives the female service member and her commander the option, if both agree that they can do this and that she can afford it, for example, to do 6 weeks unpaid, and the unit can handle it in terms of having her gone for the additional 6, that then they can do that. And I think this would be really important for the morale and the retention of talented women in our military at a time when our military simply can't function without the participation of our female service members. Members of the Rules Committee, I urge you all to make this amendment in order and give our military mothers a chance at a healthier, stronger future for their families and our country. They invariably face separation from their families, but this is a way that we can allow them and trust in their decision and their commander's decisions to allow them to have that additional 6 weeks at no cost to taxpayers should it be needed. Thank you. I yield back.
Yes, ma'am. Thank you very much. Ms. Spear, Congresswoman Spear, welcome to the Rules Committee. I'm delighted that you're here.
Thank you, Mr. Chairman. I am going to speak on just 2 amendments. Number 181, which is the issue of chain of command. Many of us are well aware of the crisis really in the military with the number of sexual assaults on men and women, and it's important to underscore the fact that the majority are to men. because they represent such a high percentage of the military. But of those 26,000 a year who are sexually assaulted, only about 5,000 report. Of those that are unrestricted, meaning they name names, that's 3,700, only about 800 of them actually go to court-martial. And less than 270 of them actually end in convictions with jail time. So the issue is chain of command. The issue is one of conflict of interest, and it has been, I think, well documented that by taking these cases out of the chain of command, that we will have better results in that you will have legal expertise determining whether or not a case should move forward, not a commander who really has no legal training. Now, what's interesting to point out is that the majority of the members of the Rules Committee have taken a position in support of either the Military Justice Improvement Act, which was introduced by Congressman Benishek and Congresswoman Gabbett, or the STOP Act, which I introduced. So the majority of this committee has already gone on record of wanting to see these cases taken out of the chain of command. This particular amendment is co-sponsored by Congressman Kaufman and by Congressman Jones, along with Ms. Gabbert and Ms. Duckworth and Congressman Inyard. And I think it's important to point out that of all the members who have served in the military, Congressman Inyard probably put it the best because he has served, he's the only member of Congress who has served as a defense counsel in the military, as a prosecutor in the military, as a commanding general in the military, and as a staff advocate, judge advocate in the military. And he believes very strongly that these cases need to be taken out of the chain of command. So this change would strengthen our military, not weaken it, and restore, I think, the trust that we owe to every member of the military who swears to serve on our behalf, that they will serve and not be the subject of violence within the ranks. So this amendment would just relate to taking sexual assault cases out of the chain of command.
Thank you very much.
And then I have one other amendment to speak to, and that is Amendment 183. 20 years ago, we set a government-wide goal of awarding 5% of federal contracts to women-owned small businesses. 20 years later, we still haven't met that goal. In fact, women now own 30% of America's small businesses and are one of the fastest-growing sectors of small business owners in the country, contributing about $1 trillion annually, but we have yet to meet that goal. Now, what's really interesting is that we do have a sole source set-aside program that's available to disabled vets, to hub zones, and those are historically underutilized businesses, and to 8A individuals. But unlike these other set-asides, women-owned small businesses must find other small businesses owned by women in order to seek federal solicitations. So there's an extra obstacle placed in front of women-owned businesses in this sole source venue. And this particular amendment would treat women-owned businesses just like these other businesses that have access to sole source contracts and give them that same equal setting. And with that, I will yield back, Mr. Chairman, and hope that these amendments will be made in order.
Thank you very much, Congresswoman Spear. It's my understanding that Congresswoman Gabbard would wish to include part of her testimony support of at least some of your amendments. And I want to thank you very much. Well, now, Mike, do you want to be recognized? Gentleman's recognized.
Thank you, Mr. Chairman. I just want to speak in support of the Spear Amendment. Having served, having been a unit commander, having been in two branches of service, I just think that this is an issue that's very sensitive to a command, and it would be better taken out. I think our military would be better served if this one aspect of the Uniform Code of Military Justice procedurally would be taken out of the chain of command structure, and I rise in strong support of the Spear Amendment.
Thank you very much. Gentlewoman from Hawaii is recognized.
Thank you very much, Mr. Chairman. Aloha. I'm really proud to be here to speak in support of the Spear Amendment as well, and recognize that many of the arguments have been made for and against taking this approach to addressing the issue of military justice reform and sexual assault in our ranks. So I just wanted to share personally a little bit about why I'm here and why I feel so strongly about this issue. It's because I love the Army. It's because I love being a soldier. And it's because I appreciate the necessity of the command climate and culture that requires there to be trust and integrity in the system. Serving as a private, a platoon leader, and a commander are all jobs that I have cherished, and there's been no greater honor than to hold that job of taking care of and serving our service members. The reason why I feel strongly about ensuring that we have a system in place that is immune to the strengths or weaknesses of any commander at any level of the chain of command is because it will set up our troops for success. It will build stronger cohesion and integrity within the unit, and it will help to address a problem that has existed for decades. Many people say this change goes too far. It's a reform that is not necessary at this time, and just give it time. A lot of time has passed, and a lot of troops' voices who have been victims and survivors of these violent sexual crimes have not been heard or addressed. There are a lot of arguments that are brought up with regards to saying these cases are complicated. There's issues with collection of evidence. There are issues with being able to examine that evidence and build a strong case that will allow them to go to trial. All of these arguments actually speak strongly for why this is necessary, because as a company commander, we are not trained in interviewing and collecting and examining evidence of violent sexual crimes, nor should we be, and why in this instance this examination as well as this decision really should be put into the hands of trained military prosecutors who can ask the right questions and who can build the strongest case possible to build that confidence in our service members that they will receive justice. So I appreciate the consideration of this committee in ruling this amendment in order so that we can have an up or down vote on this, giving voice to the survivors of these violent crimes, empowering them, letting them know that we hear them and that we have their back. So I hope you'll consider this. Thank you very much.
Thank you, gentlemen, very much. We'll now begin the questioning. Everybody's had a chance to bring their amendments. Did you show up in support of an amendment, or did you have your own? This was a...
I'm in support of 181, Spear
Support
Amendment.
of 181. Thank you very much. Congressman, I'm interested in your ideas. Today, that jurisdiction, by and large, resides in the Secret Service on these types of cyber security crimes. Is that true?
It runs
Across the board.
Yeah, across the board. It depends. There are various agencies that have a piece of it. Homeland Security has some of it. FBI has some of it. Certainly, Secret Service has some of it, and the Pentagon has some of it. It just depends on what area would be attacked or be.
I guess I was thinking from a law enforcement perspective of collecting data, reporting information, jurisdictional elements of referring that for prosecution, doing things like that. It's really across the board?
It is across the board.
Interesting. Okay. Thank you very much. Let's see.
And that's the challenges, of course, both whether it's in time of an attack going on or even in prevention, making sure that departments and agencies, for example, are doing what they're supposed to be doing with respect to maximizing the cybersecurity protections that are out there. There is no one in charge, per se, that can compel compliance. There is coordination that goes on. We have a coordinator, but again, not with the skill set, not with the authorities that that individual needs to do the job of making sure that we're doing everything we can to protect the nation in cyberspace.
Interesting. Thank you very much. Mr. Kaufman, I had not known until today that the base closing BRAC, as it's known, exempted, or was about just a basis here in the United States, and I think that's very interesting. So I will look at that. Great.
Mr. Chairman, if I could take the opportunity to speak in favor of Ms. Spears' amendment, I voted for.
Gentleman's recognized.
Thank you, Mr. Chairman. I voted in favor of Ms. Spears' amendment in committee after hearing testimony and the arguments on both sides of this very compelling and important issue. And I've been convinced that on this particular issue that it does warrant having this taken out of the chain of command and put it in the hands of legal professionals that would make a judgment based on the facts and legal training as to whether a case should go forward or not.
Great.
Thank you, Mr. Chairman. I yield.
Yes, sir. Mr. Bishop?
Yeah, I don't have a clear memory of that day in armed services because it was only 78 hours that day. I don't remember all of these amendments being addressed in that committee somewhere. So just yes or no, of your amendments you're proposing here, were they presented at the full committee markup or at the subcommittee?
Mr. Kaufman, we'll go to you first. We'll go in the order in which you were
Mr.
addressing.
Chairman, I think the one on the audit, Pentagon audit, was in fact voted on in the full committee. The others did not and arose really after the fact. I'm trying to think. No, the BRAC one did not.
I don't remember talking about the BRAC one in the committee.
No, it did not come up, and the mental health did not come up, and the My Enlistment Opportunity Act did not come up as well.
Mr. Langevin, were yours brought up in committee?
No, they were not.
Ms. Duckworth?
No, they were not. We just finished the final data we were collecting after that day.
Mr. Spears?
The chain of command amendment was taken up in committee. I would just point out that between the Benishek and Spear, there's over 220, I believe, members that now support this.
Okay, I didn't want more support, no more testimony, just yes or no. Were they in there, Ms. Gabbard? Yes. Yours was done in committee as well. Let me ask just a couple, Mr. Langevin, especially because I'm interested in your area. Why was it not done in the committee? You're one of the ranking members.
Mainly the question of sequential referral issues. And additionally, I think that this is an issue that the full House should have
Actually,
the opportunity to hear.
If it was a sequestration referral problem, whatever the proper name should be, I understand that. That's a good enough answer. Why was the BRAC one not presented to the committee?
I think that Congressman Abner Smith actually, well, he had a version of it, but then he withdrew it. And but I just didn't have it ready by that time for the committee, and so and within the priority of the other things that I'd put forward to the committee, this was not quite as high.
Besides the ones from Mr. Langevin, were the others that were not presented to the committee, was there a referral issue on any of them?
Yes, Mr. Bishop, the women business owner amendment had a sequential referral
To which committee?
To small business.
Thank you. Yours did not have? All right. Yield back.
Chairman yields back this time. Gentleman from Massachusetts recognized.
No, I
Mr.
don't
Montgomery.
have any questions. I think they're all important issues, and whether or not they were considered in committee or not, I think we ought to have a chance to debate them and vote on the House floor, and I look forward to supporting them in this committee. Thank you.
Thank you very much. I'd like to ask a question of the committee or of one of the witnesses, and I'm sorry. When you evidently made a trip that you alluded to over Mother's Day that was done to Afghanistan with other members, was that when you came up with your idea and then filed it?
No, I came up with the idea and sort of finalized things after the NDAA markup day. It was a combination. This was one of the things that came up. I've been talking with folks, and then the final thing that I was waiting for was the costing from the congressional
CBO.
budget, the CBO.
Yes, you were looking for more data and information.
I was looking for more data, and
It
then
wasn't a delay. It wasn't something you did on a whim. It's something that you've been thinking about.
Correct.
You just had not prepared yourself.
correct, and then I had a final. I'm like Ms. Gabbard. I'm still serving in the National Guard, and the weekend after the markup, where I actually have National Guard doing, and that's when I gathered the final bit of data, talking with the service members there to see what their situation was.
Great, great. I wanted to make sure that we took very carefully the consideration where you do recognize it was a very good question, but one which was sustainable from your perspective. Thank you very much. Gentleman from Florida, Mr. Nugent is recognized. Gentleman has no question. Gentleman from Florida. Gentleman is in support of the amendments. Gentleman yields back his time. Gentleman from Orlando, Florida. Gentleman, Mr. Webster is recognized. Gentleman has no questions. I want to thank each of you for appearing and being with us today. The committee is going to have to look at a lot of amendments. Your precision by which you offered us the numbers and the substance behind them will help us to do this. I want to thank you very much for taking time to be with us. This panel is now excused. The next panel will include the gentleman, Mr. Castro from San Antonio, Texas, member of the Armed Services Committee, and we just got too many people up first. I'm delighted that you're here, Mr. Castro. The gentleman from Michigan, Mr. Amash. The gentleman from California, Mr. Denham. The gentlewoman from North Carolina, Mrs. Elmers. And the gentlewoman from California, Ms. Lofgren. Ms. Lofgren, thank you very much for taking time to be with us. I'm going to put you in the center since you will be going first as the senior member of this panel. Thank you very much. We'll get these done. Mr. Amash, we'll make sure you get a chair. Mr. Castro. Doug will get you there. Renee, thank you very much. Mr. Denham, little bitty fellow that you are, will fit you in somewhere. I'll let you decide. You're big enough to fight for yourself over there. Mr. Denham, I'm delighted that you're here before the committee today.
Ms. Duckworth was also with me to testify on my bills.
That would be great. I will let her. I completely understand that. If she'll wait for a minute, I will allow her to come back at the appropriate time. So I'll get you at the table. We'll fit the 5 in. As always, each of you are welcome before the Rules Committee. We're delighted that you're here. Your information that you bring to the committee represents thoughts and ideas that you have from people who you represent. We're extremely pleased that you're here, new member or older member. This process is very important, and the Rules Committee is the appropriate place to do it. With that said, Ms. Lofgren, I'm delighted that you're here again, and the gentlewoman is recognized without objection. Anything you have in writing, any of this panel will be entered to the record. Gentlewoman.
Thank you very much, Mr. Chairman. I have Amendment 228 and Amendment 229. Let me start first with 228. This is an encryption funding amendment. It is sponsored by myself, Congressman Rush Holt, and my colleague on the Judiciary Committee, Representative Doug Collins of Georgia. The amendment would prevent funding of any intelligence elements, program, or related activity that mandates or requests that a device manufacturer, software developer, or standards organization build in a backdoor to circumvent the encryption or privacy protections of its products, unless there is statutory authority to make such a mandate or request. Now, we've seen in the newspaper that the NSA paid the RSA $10 million to set as the default a deliberately flawed encryption method, which gave backdoor access to any message encrypted with the RSA program. In March, we saw another report that another flawed encryption tool was given to RSA by the NSA to increase the speed at which to access message is encrypted with a flawed standard. The recent Heartbleed SSL bug shows that even when backdoors are created unintentionally, the cost to business to repair them are tremendous. And I think the important thing to remember is that if there is a flaw in encryption, eventually somebody finds that flaw and they exploit them. Now, intentionally adding a backdoor to security or privacy systems or standards not only makes us all more unsafe, it comes with huge economic costs. These costs are more than what we lose to bad actors exploiting the backdoors. It also costs tech companies the goodwill and trust that they build up over the years with foreign consumers. It just doesn't make sense to spend money on a program that results in greater harm and costs than would exist without the program. Now, since the NDAA's purpose is to authorize appropriations for fiscal year 2015 for military activities of DoD, and since the NSA is within this department, we have been advised that this amendment is germane. I think it's important that we give an opportunity to the members of the House to speak out on this item. It is a matter of tremendous concern among Americans in both parties, and there is support for reform among members of the House from both parties. And I think it's important that the House have an opportunity to express its will. The second amendment has to do with 702 of the USA Patriot Act. The amendment would prohibit the use of funds for searching for the communications of Americans that is collected under Section 702 of FISA in a manner that's inconsistent with either the probable cause requirements of the rest of Title VII regarding U.S. persons or the Fourth Amendment. This amendment is offered by myself, Congressman Massey, Congressman Amash, and Congressman Paulus. Again, this is a bipartisan amendment, and I think it's important that the members of the House of Representatives have an opportunity to stand up and take a stand on this issue. This amendment comports with the structure of Title VII, which requires probable cause in all of its authorities that directly deals with the communications of U.S. persons. Now, how does this actually work? 702 of the Act provides that you can collect information in bulk about people outside the United States and also communications between people in the United States outside. As a practical matter, what that means is not just phone calls from me to my great aunt Tilly in Sweden, but also because phone calls as well as emails and other internet communications are routed along the internet backbone, that information flows in a way that is just easiest to flow. Further, we have servers that have the information of U.S. persons that may be located outside of the United States, even though they have the information of U.S. persons. For example, some companies have servers in Iceland because of their geothermal energy and because it's not that hot in Iceland, which is an issue for server farms. They might have all of your information, Mr. Chairman, if you have a Gmail or a Yahoo or MSN account, but because it's located outside the United States, all of that could be obtained. The point of this amendment is that if you're going to query that database that has been lawfully collected for information about Americans, you should get a warrant to do that. You should have probable cause. And probable cause is the standard in the Fourth Amendment, and it's the standard throughout the rest of the bill. Now, this is germane because the NDAA's purpose is to authorize appropriations for fiscal year 2015 for military activities of the Department of Defense. NSA is an agency under DoD, and we believe that although there are efforts underway between the Judiciary and the Intelligence Committee to come up with a compromise bill relative to the USA Freedom Act, this is not addressed by that compromise, and it needs to be addressed by the House of Representatives. Since I'm here, I'm going to take just a moment, if I may, to comment on two other amendments that are not in the Fourth Amendment category. One is Amendment 126, having to do with environmental cleanup, which obviously we all favor. The problem, however, is that the funding would be taken from the stockpile stewardship program at the Lawrence Livermore National Lab. This program at the ICF has had tremendous reductions already. They have laid off hundreds of people, including 60 scientists. This additional cut would be a disaster. They would not be able to perform their activities under stockpile stewardship. And further, Amendment 164 by Mr. Brooks of Alabama, which relates again to the National Ignition Facility. I would note that although I think I know what Mr. Brooks intended to do, as the amendment is drafted, it would actually destroy the stockpile stewardship program, because all of the science that is done on the NIF has dual purposes. In order to understand the stewardship program, you also generate data that is of value to the fusion inquiry. And if you could not actually look at the data for fusion or create information that was useful for fusion, you wouldn't be able to do the stockpile stewardship program either. And therefore, I hope that the committee will not put these two confusing amendments before the body. And with that, I thank you very much for your attention.
Thank you very much. Ms. Elmers, welcome to the Rules Committee. I'm delighted that you're here. Chairwoman is recognized.
Thank you. Thank you, Mr. Chairman, and thank you to the Rules Committee. I am very honored to be here to speak to you about two amendments that I have to the NDAA, number 300 and number 302. The first amendment I have is to preserve Pope Airfield's 440th Airlift Wing. Because of the incredible support that they provide to our military and the necessity of its mission in maintaining readiness. The Department of Defense repeatedly says that they need flexibility, certainty, and in a time of to complete the mission and maintain readiness. The 440th provides all of these, yet the Pentagon is attempting to inactivate the very unit that provides these three crucial elements. Fort Bragg is home to the airborne and special operations forces. The proposal to remove every C-130 from this base contradicts its important mission. As even President Obama noted, we will shift more to our focus to special operations forces. The 440th carries out numerous training operations with the Joint Special Operations Command, or JSOC, and the United States Army Special Operations Command, USASOC, not to mention their daily training missions with the 82nd and the 18th Airborne. Over the last 4 years, the 440th has delivered more than 33% of the Joint Airborne Transportability Training, also known as JAT, for Fort Bragg's paratroopers, providing both accessibility and certainty that is unparalleled and unavailable in other installations. Because the 440th is co-located with the Army, it has this unique capability. The Air Force claims that the C-130s from other bases will fill this void, but I believe this is short-sighted. Because of the joint mission capability and the on-site access of the 440th that this 440th provides, commanders at Fort Bragg have the flexibility and accessibility for immediate action. Just this year, the Air Force itself, through the National Commission on the Structure of the Air Force, called for more partnerships between active and reserve components. The 440th is a model unit that has proven its benefits to that partnership. All of these things that make the setup of the flying mission at Pope Airfield efficient through both total force and joint partnerships and a model for the future are being dismantled in the name of saving dollars. I do not believe the readiness of this nation's foremost rapid deployment forces should be jeopardized. My second amendment, Mr. Chairman, is very brief. This amendment will simply address the lack of timely notification to beneficiaries of system-wide changes to TRICARE coverage. It is imperative that military and veterans' families have adequate time to understand and replace the changes made to their coverage. I have worked with the DoD and HASC throughout the drafting process to ensure this amendment will work for both DoD and TRICARE beneficiaries. This amendment has been scored by CBO and does not require an offset in discretionary spending. This simple and non-controversial measure will protect our service members, veterans, and their families. And with that, Mr. Chairman, I thank you for allowing me to speak today to the committee, and I welcome any questions.
Thank you very much. I appreciate the gentlewoman's clarity on these amendments, and it helps us. The gentleman from California, Mr. Denham, is recognized.
Thank you, Mr. Chairman. I have three amendments today. Number 58, the Enlist Act, number 124 and 125. And if it pleases the committee, I would ask that Ms. Duckworth be able to testify first to accommodate her schedule.
The gentlewoman would be added to the panel and would be recognized at this time.
Thank you so much, Mr. Chairman and Ranking Member, for the opportunity to speak on this bill. I've served proudly in our military, the greatest military in the world, for 23 years. And during that time, I have found it to be an institution where young men and women from all backgrounds can come and make their way and can become leaders. They can defend our nation and receive equal pay for equal work. It's an institution that I love, and I want others to love it and benefit from it as well. So I'm so passionate about the Enlist Act. I believe strongly that American citizenship is a privilege. It is something that should be earned. And I can't think of a better way to earn citizenship than to be willing to die and lay down your life for this nation. In my own unit, we went off to Iraq, and we actually had members of my unit who were not citizens and who were granted citizenship during military service and during the deployment period. Over 100 service members, immigrants, have been granted citizenship after dying in combat in both Iraq and Afghanistan combined. Our service members are asked to deploy around the world to defend our nation. I've seen how the sacrifices of these brave young men and women don't end in retirement. After service in the military, they go on to serve their communities in so many other ways. I think that allowing young men and women to join the military and to earn citizenship through this act will be a way to not only strengthen the military, but also strengthen this nation. We need their skills, we need their dedication, and we need their example of, if you want to be an American citizen, then you need to earn that privilege. And I think that folks who are willing to defend and to travel around the world in defense of our Constitution are really the example for the rest of us. Thank you.
Thank you very much.
Thank you, Mr. Chairman. I appreciate you working with us. I know you guys have a very long night, a very busy schedule. On item number 58, the Enlist Act, this is a change in military code. I want to be very clear. This is military code. It's not an immigration bill, not any other bill. It's not referred to any other committee. In fact, it was ruled in order last year at this very committee. And on the floor last year, I was willing to withdraw my amendment only to be able to work with others to make sure we had something that would have passed hopefully prior to this time. This does fit specifically in this bill. The basic premise of this bill, if you're under the age of 15 and you were entered our country to no fault of your own prior to 2011, this would allow you, if the Department of Defense, you can meet their criteria, would allow you to serve in the military. You still have to pass background checks, still have to graduate from high school, still have to be able to speak English, and a number of other requirements that the military puts on them. It leaves it up to the Department of Defense and military readiness where it should be. This amendment absolutely would eventually lead to citizenship. You enter the military, you put your life on the line, you're willing to serve the only country that you know, you become a legal permanent resident. But on completion of honorable discharge, there would be an opportunity, if they so choose, to apply for citizenship. I want to be very clear about the issue. But this is nothing new. Prior to 1840, over half of our military was made up of immigrants. After 1840, over 660,000 immigrants have gained legal status and citizenship through serving in the military. During World War II, my grandparents met during World War II, and we were recruiting over in Europe. We did it during Vietnam. When I served in Desert Storm in Somalia, we had Filipinos who were gaining citizenship by serving in the military. I believe that this is not only an issue of national security and military readiness, but those kids that are here, that have gone through our education system, why wouldn't we allow the Department of Defense to pick the best and brightest that can meet all of their criteria, leave it up to the military to decide who's best to serve and defend our country? And I believe in earned citizenship. But there is no better way to show your patriotism, your commitment, your sacrifice, and the willingness to earn that citizenship than being willing to serve in our military. So I've obviously debated this bill a great deal. I think it's a very important part of our heritage. And as a military veteran, serving with a number of veterans that receive their citizenship while on active duty, I feel a great deal of pride in dealing with this issue on my own. I have two other amendments today. Item number 124, there have been a lot of concerns about this amendment, even though it's nothing new, even though it came up last year and was ruled into order, that the NDAA is no place for anything dealing with immigration. That's the position that this conference, that this body, that this House is going to take. Item number 124 is very simple. Let's pull out all of the immigration issues. Every NDAA, we have several immigration issues that are dealt with within the NDAA. We have 3 right now dealing with border security. I do not call into question the necessity of these 3 immigration provisions. Just if we're going to deal with them all, let's deal with them all together and bring them all up together. We made a decision as a body that we are going to address some of these issues, then we ought to address all of them. So item number 124 not only saves $69 million, but it pulls all of those immigration type issues out of the bill. We've in the past we've had Iraqis and Afghanistans in the last NDAA that were able to gain citizenship through the NDAA process, through the NDAA bill. This one, once again, there are different immigration provisions, including special immigration visas for Afghanistan and Iraqis, and I would ask that we package all of those together. Again, this would save $69 million and allow us to have a full debate on all of these issues. The last amendment that I have is item number 125. And as Ms. Duckworth eloquently talked about her commitment to service and some of the things that she went through, I also, as a veteran, went through some of those same circumstances, as well as my travels to Afghanistan and abroad. I've met with many commanders. We have had, all the time, we have people sworn into citizenship while they're on active duty. Now, many of them are on visas. Many are coming from other partner nations, and many are undocumented immigrants. This would basically, very simply, require a report for us to define the number of individuals who enlisted as undocumented and were granted citizenship. It's a very simple report, and I would ask that we be able to vote on all 3 of them. Prepared to answer any questions.
Thank you very much. Mr. Amash, welcome to the Rules Committee. We're delighted that you're here with us today.
Good
Gentleman's
afternoon.
recognized.
Thanks, Mr. Chairman, and thanks to the members of the committee. I'd like to start by saying I strongly support Rep. Lofgren's amendment regarding 702 to FISA. It's an important issue, and it's something Congress has yet to address. But I'd like to thank you for giving me the opportunity to testify on my 2 amendments to the NDAA. They're number 32 and 33. Americans were outraged when they learned that their own government had been monitoring their private communications for years. They've demanded that Congress rein in unconstitutional domestic spying programs and that we respect the limits imposed by the 4th Amendment. The amendments I offer today seek to end the government's bulk collection of Americans' records under Section 215 of the Patriot Act. The amendments are similar in purpose to the amendment I offered to the Defense Appropriations Bill last July. I have updated the amendment's language to reflect the version of the USA Freedom Act that unanimously passed the Judiciary and Intelligence Committees 2 weeks ago. So this language unanimously passed 2 committees 2 weeks ago. If the House considers the Freedom Act this week with comparable language, I plan not to offer these amendments to the NDAA. I've written two versions of the amendment, labeled Amash 32 and Amash 33, to ensure that I have language free of procedural issues. After submitting the amendments to the committee, my staff was informed that both amendments are germane and otherwise comply with House rules. If the committee agrees that there are no procedural issues with either amendment, I would prefer that the committee approve Amash 32, and I will withdraw Amash 33. Thanks for your time, and I am available for any questions. Thank you.
Thank you very much. By the way, we're going to, and the gentleman may not be aware of this, but we're going to add in the bill that Chairman Sensenbrenner has been pushing very diligently. The bill will be included, and we will be receiving testimony a little bit later. It was just placed on the Rules Committee website, so I appreciate the gentleman, but I would also advise both of you to make sure that, at least at this time, that your staffs are aware of that, and we'll provide you with that update, and I appreciate the gentleman very much. Mr. Castro, I grew up in San Antonio. It's a great place to be, and I welcome you to the Rules Committee. The gentleman is recognized.
Thank you, Chairman. Thank you to the members of the Rules Committee. I'm here on amendment number 127, which would allow those who have obtained DACA status, deferred action status, to be able to apply to the U.S. military academies, specifically the 3 academies that are under the Department of Defense. And, you know, right now they're ineligible to apply, and the academies even accept international students right now. And the idea really came to me several months back. Folks from West Point met with some of us and talked about how in many districts, including many minority districts, not enough folks were being nominated to the academies, and they wanted our help in figuring out how we could increase that number. And so around a little bit later, actually, there was a young man that I met named Omar Leal in San Antonio in Texas. And Omar is at the top of his class at his high school in San Antonio. And in our OTC, he came up here with his commander. He was my guest to the State of the Union. And his commander was trying to encourage him and wanted him to be able to apply to the academies, but he's not eligible to because he's a dreamer. And so this would allow them simply to apply. Obviously, it doesn't change their immigration status. They've already gotten DACA status. It doesn't mean that they're going to get in. It just makes them eligible to apply to the academies. And so I ask for your consideration on it. It is a bipartisan amendment. Ileana Ross-Layton, Congresswoman from Florida, has joined me on it. We didn't file it. We didn't present it to the committee. Quite frankly, the idea was still in the works at the time, so it wasn't presented to the committee. And also it deals with Title V, Subtitle F, education and training. We've gotten word that it is germane, and so I ask for y'all's consideration on it. Thank you, Chairman.
Thank you very much. Ms. Lofgren, your insight into the specificity of the cyber world is interesting, and I will tell you that I'm intrigued by your testimony. I am probably, as every single member of this body, concerned about the laws of this country to protect individual civil liberties, but also to make sure that we have an opportunity to protect this country. But the application through the back door by an organization, any organization, that would allow information to be gamed, what I would call gamed, without proper notice, is serious. I don't consider it a breach. I consider it an application. And I need to go look at this a little bit more, and I will tell you, you being here is very important, and I appreciate this.
Well, I thank you very much, Mr. Chairman, and as I say, this does have bipartisan support. I would note that I was aware that a version of the USA Freedom Act will be coming before us, and it is a compromise. I did vote for it in the Judiciary Committee, but the 702 backdoor problem, which was addressed by Mr. Sensenbrenner in his original bill, is not included, and it should be. It doesn't mean that you couldn't get information, but it is. If you have a warrant, you can you can query it. And here's my fear, that if we don't address this issue, we're going to be back here in a couple years having seen the same kind of, violations of the Constitution that are going to lead our constituents across the country to be outraged, and we have an opportunity to address it now. I understand and support the need for compromise between the two committees, but allowing the House to work its will, if a majority of the House feels that the Fourth Amendment ought to be honored in this way, is not inconsistent with the agreement reached between the two committees. And I thank the gentleman for his kind words.
Well, I remember years ago we used to be concerned about being able to get the bit streams as it would be in a digital format, or at least going through digital areas. And that was a process in 85 and 86 that I was very aware of. And now we can just gather the whole bucket together. So it's interesting. Mr. Denham, I want to thank you for taking time to be with us today. Your amendment is, was it debated in the committee? Your amendments?
We had a, no, sir, it wasn't.
Was not. Okay. Well, it's not new, and it's not a threshold requirement at all. But I did not know what had happened there. Well,
Mr. Kaufman and I have both had different bills dealing with the same topic, and we did have an informational hearing earlier this year, but no action has been taken.
Yes, sir. Thank you very much. Mr. Bishop?
No, thank you for the testimony. Mr. Castro, you answered my question before I asked it. Dude, give me a chance actually to ask the question first. Which one? Before you anticipate it and ask it. But thank you. Appreciate you.
Gentleman yields back his time. Gentleman from Massachusetts recognized. Gentleman has no questions. Does the gentleman from Colorado seek recognition?
Yes, I do.
Gentleman's recognized.
A question for Mr. Denham. Is this issue of making sure that we can attract some of the young folks that your amendment would allow the military? It seems like more of a military preparedness issue than an immigration issue. Isn't it really about making sure that we have the best and most capable young men and women defending our country rather than about immigration per se?
Absolutely. That's been my point all along. That's why this has not been double referred and is a HASC issue. This is only dealing with military code. Why wouldn't we let the Department of Defense pick the best and brightest that can meet their criteria?
And a follow-up question for Mr. Castro. Are deferred action individuals currently not eligible to serve in the military?
That's right. They're not. And so this would allow them to serve in the academies.
Yeah. In the academies, but what about as enlisted? Are they eligible to serve as enlisted currently?
He's got the enlist, so they would be qualified under.
It's just the two different aspects to
I
it.
see it as complement.
Well, in Colorado and in one of the cities I represent, we have DACA individuals that serve on public boards and commissions. Our school districts are hiring DACA individuals as teachers. I can't imagine why we wouldn't want to be able to avail ourselves of the very best and brightest who have legal permission to be here due to administrative action to serve in our military as well. So I certainly am very supportive of both your amendments.
Congressman Polis, I think you're right. I would also point out that they are already eligible to go to other colleges and universities.
Mm-hmm.
So this would also allow the academies to compete for these very bright folks.
Well, I've been on the board of visitors of the Air Force Academy in Colorado Springs for the last 4 years. We've seen a lot of amazing young people come through there, and to know that somehow this whole category of aspiring Americans can't even go to our academies, and as a result, the academies have to go down the list to the next best person. They just have to cross off the candidate they really want and go down to somebody who might be a fine officer, but is, for whatever reason, less qualified than the person that would have had their place. It just seems absurd. So certainly as a member of the Board of Visitors there, it hurts to know we're missing out on some of the most talented young people. So I strongly support both of the amendments. I yield back.
Thank you. Gentleman yields back his time. The gentleman from Florida is recognized. Gentleman does not seek recognition. Gentleman from Orlando, Florida. No question. Gentleman does not seek recognition. I want to thank all 5 of you for taking time to be with us today. I recognize you had to sit through a little bit of the first panel. I always think this should be included as part of your public service to Congress, that where you have to come up here for a few minutes and suffer through the Rules Committee. Mrs. Elmers, you have passed the test before today. Mr. I know Mr. Denham has done that. Ms. Lofgren, we appreciate your service. Mr. Mosh, look forward to seeing you perhaps again, perhaps sooner than what one would have anticipated, but we will be handling matters in this rule that are of germaneness to you. Thank you, Mr. Castro. We appreciate you coming up and recognizing. We recognize your ideas, and I thank you very much. If you have anything in writing, if you'll please make sure that our awesome stenographer has all that information. This panel is now excused.
Thank you, Mr. Chairman. I think I speak for the whole group here. We wish the entire committee a good night.
Well, well, afternoon and evening. Mr. Denham, thank you very much. And Mr. Denham, thank you for taking time to be with us today. The next panel that we'll have, will be a most distinguished panel, including the gentleman from Pennsylvania, Mr. Pitts, a member of my class. Mr. Pitts, Chairman, I'm delighted that you're here. The gentleman, Mr. Jones, from North Carolina, who represents major pieces of the United States military. The gentlewoman, Barbara Lee. The gentleman from California, Mr. Schiff, who I evidently understand has brought his father with him for some bit of support. Dad, we're delighted that you're here. And the gentleman from Oklahoma, Mr. Bridenstine, would please join this panel. Mr. Bridenstine, welcome. You're going to have to pull up a chair somewhere around there, probably next to Mr. Jones. We're delighted that you're here. Each of you bring a perspective, not only from the district that you represent, but your experiences, some of you in the military. But every one of you bring a perspective that is important to the Rules Committee, and we're delighted that you're here. Mr. Jones, we're going to defer to you first. If you could, at the time, I don't know how many of you were here when we started, but to the ability that you have, we've got right there in front, between Mr. Schiff and Mr. Pitts, a list of all of the amendments that we believe we've identified, and there's a yellow pen. If you could identify your amendment as you speak to us and give us the number, it will allow us to understand more readily what you are attempting to get us to focus on. Before you do that, I'm going to give Mr. Jones a second. Mr. Schiff, do you mind taking a minute and introduce your dad? Dad, we're delighted that you're here, and I'll let your son go through this.
Mr. Chairman, thank you very much. I'm really impressed with the homework the committee has done. Don't know how you knew my dad was going to be here, but...
well, you know, we know lots of things, but we're not all wisdom. You do remember I spent a week with you.
Yes.
And you never told me. Although I did know your dad was here, but I'm delighted that he's here.
Well, thank you, Mr. Chairman. My father, Ed Schiff, behind me, is now retired, living in Florida. He's the veteran in the family, joined the Army at the end of World War II, and I'm very proud of him and delighted that he could be here today.
Good. Does the gentleman wish to go through any more family history that I heard about this past week?
No, I think you heard too much already from me.
The association of some past dad was provided during the trip that dealt with President Eisenhower. So we'll avoid that at this time. Mr. Jones, thank you very much, Mr. Schiff. Mr. Jones, are you prepared?
Yes, sir.
Gentleman's recognized.
Mr. Chairman, I thank you and the ranking member that you would give me an opportunity to join my friend Barbara Lee to talk about Amendment 169. This deals with the authorization for use of Military Force Act. In 2001, I made one of the worst decisions I made in my life as a member of Congress when I voted to give the former President Bush the authority to bypass Congress to commit troops to foreign countries for wars. I did at the time regret it simply because I came to Congress in 1995 believing that the Constitution spoke to this issue, that we should never commit our young men and women to wars overseas unless we follow the Constitution and declare war. So I don't blame anyone for my vote on 2001, but I do regret it. I am here today with Congresswoman Lee, we have Brown, we have Slaughter, Yoho, we have Gary Mendy, and myself, who have all co-sponsored this legislation led by Barbara Lee. It is time that Congress takes back its constitutional authority. When you think that the President of the United States from 2001 and now President Obama continues to make reference to this act of 2001, and therefore they continue to keep this country at war without Congress having a say, except when we have appropriations bills on the floor, then we have a chance to offer amendments. I believe sincerely in what was said in 1798 by James Madison, and I want to quote, "The Constitution supposes what the history of all government demonstrates, that the executive is in the branch of power most interested in war and most prone to it. It has accordingly with studied care vested the questions of war in the legislature. That is, we in Congress. It is our responsibility, as Madison made that point, that we in Congress debate the issues of committing our young men and women to die." So I hope that this Rules Committee will grant a debate on the floor of the House on this Lee Amendment, because we have no other avenue of debate, and yet we're not meeting our constitutional responsibility when we allow an administration, be Republican or Democrat, to use this Authorization Act of 2001 to make their decisions to commit further action by our young men and women in the military. And I hope that you and the other members of this Rules Committee will give us a chance to have this debate on the floor of the House. I think it's critical to this institution known as the House of Representatives and critical to the Constitution of the United States that we take back some of this power when it relates to sending our young men and women to die. I yield back.
I thank the gentleman very much. Does the gentlewoman wish to be recognized at this time to speak
Yes.
on the amendment? Gentlewoman be recognized and to speak about any other amendment that she chooses.
Thank you very much. I want to thank you, Mr. Chairman, and our ranking member, of course, for the opportunity to testify on my amendments to the 2015 National Defense Authorization Act. I want to thank my co-sponsors for being here and for your tremendous leadership and for helping to really move these amendments forward in a bipartisan way. I've offered 2 amendments this year, and I respectfully request you to consider them and make them both in order. The first concerns the 2001 authorization to use force, which is an issue that I have consistently brought before this committee. My second amendment would repeal the 2002 authorization for the war in Iraq. Let me focus on my top priority, and that's the 2001 AUMF. This is the Lee Amendment 116. As many of you know, I did not support the AUMF in 2001. It was a very, very difficult vote to cast, perhaps the most agonizing of my career. But as the daughter of a 25-year veteran who fought in 2 wars, I knew that this resolution would commit our brave young men and women into many wars without end, actually, without congressional involvement. When I explained my vote on the floor, I expressed a very sorrowful warning that by quickly pushing through an overly broad authorization, there was that we could be in a state of perpetual war. There was very little debate. Maybe, I believe, Congressman Jones, it was 1 hour. 1 hour on such a broad resolution. And so I think that the time has come for the House to revisit this authorization and have a real debate. Reflecting on the nearly 13 years that have passed since that horrible week in September, that single sentence has essentially provided the president, any president, the authority to wage war against anyone, anytime, anywhere. The fact of the matter is the single sentence of the AUMF has been cited among legal justification for some of the most troubling U.S. policies. Let me give you a few examples. It is in part because of this authorization that individuals can be detained indefinitely in Guantanamo. It is in part because of the AUMF that the government can conduct broad, warrantless wiretapping. And it is in part because of the AUMF that nearly anyone, including Americans, can be targeted for assassination by drone strikes. The Congressional Research Service has documented at least 30-some times, which is public, that this resolution has been used as a legal justification for what no one who voted for that, I believe, would have thought this would provide the framework and the basis for. So, Mr. Chairman and my colleagues, I know that while we do not share a common position on repealing the AUMF, many of us can agree that the overly broad authority represents a major and very concerning deterioration of congressional oversight. Many of us also agree that a debate and vote on the future of the AUMF is necessary, long overdue, and should take place. Earlier this month, Congressman Brown of Georgia and I introduced H.R. 4608, the War Authorization Review and Determination Act, which we call the WARD Act. The text of this bill is reflected in the amendment before the committee. Our amendment, which enjoys bipartisan support, would begin an important and long overdue process to reassert congressional oversight and authority and determination into the use of military force. And so I want to thank our ranking member, Congresswoman Louise Slaughter, for being an original co-sponsor of my bill and this amendment. Also, Congressman Garamendi, Congressman Ted Yoho, who have joined in the support, as well as, of course, my friend Congressman Walter Jones. I know that others on the Rules Committee, both sides of the aisle, also support this amendment. Congressman Alcee Hastings, Congressman Michael Burgess, who I hope will speak or say something in favor of it. Let me just say what this amendment would do very quickly. First, it would direct the President to report on operations and actions carried out pursuant to the 2001 authorization for use of military force in classified and unclassified form. That's a very reasonable request. Secondly, it would give Congress the opportunity to review and determine which, if any, of these activities should continue or be reauthorized. This is our constitutional responsibility and duty. And lastly, it would repeal the 2001 AUMF authority for all activities not specifically authorized. Again, 13 years later, with little debate, here we are, and the public is ready for this debate. They need to know exactly what we have committed to. It's also important to note what our amendment would not do. It would not interfere with the transition of United States combat operations to the government of Afghanistan, which is scheduled to take place by the end of the year. Let me repeat. This amendment would not change the current course of the United States mission between now and the end of combat operations, as the President has declared to be December 31st, 2014. And this amendment would not limit or block the President's ability to respond to or to prevent imminent attacks on the United States, its embassies, or its armed forces abroad. Of course, we know that the President has constitutional powers and responsibilities as Commander-in-Chief to do so. Last year, in a speech at the National Defense University, President Obama acknowledged the problems resulting from our continued reliance on the AUMF, stating, and I quote from his speech, "I look forward to engaging Congress and the American people in efforts to refine and ultimately repeal the AUMF's mandate." And that's exactly what our amendment would do. By reinserting our constitutionality, our constitutional responsibilities, this oversight that we have lost actually as a result of passing the AUMF, we would finally begin the process of working with the administration towards the goal of refining and ultimately repealing the AUMF's mandate. So, Mr. Chairman, I thank you again for the opportunity to testify. As I mentioned earlier, my second amendment, which is Lead 117, would repeal the 2002 AUMF for the war in Iraq. Those operations are complete. This needs to be off of the book. Congressman Walter Jones, Ranking Member Adam Smith, and Congressman Amash have joined me in co-sponsoring these amendments. So I hope that you would carefully look at these amendments and make most of them in order. And I thank you for the time to be with you, and I hope that we can have this debate finally on the floor of the House.
Congresswoman, thank you very much. Did you have another amendment that you would wish to speak with?
In response to the amendment as it relates to auditing the Pentagon?
Yes, ma'am.
Could I speak on that?
If you would give us the number, I would appreciate it.
What?
You may not have received. You may not have received the list.
The Burgess amendment.
This guy Burgess is pretty well known around.
Number 72. Number 72.
72. I'm going to find him. Joan was recognized.
Okay, this is an amendment that is extremely important. I've carried this several times in a variety of bills. It's an amendment that requires us to audit the Pentagon. I'm proud to be a sponsor of this amendment, which would require really some basic stuff, a report ranking all military departments and defense agencies in terms of how advanced they are in achieving auditable financial statements. The American people want some basic measure of accountability in the ways that the Pentagon spend their tax dollars. It's long overdue that we do away with the culture of unlimited spending and no accountability at the Pentagon. So audit the Pentagon right now is an amendment that I hope we pass out of this committee and you would carefully consider.
Thank you very much.
Thank you.
Chairman Pitts, you're recognized. And welcome.
Thank you, Mr. Chairman. Members of the committee, I have one amendment. It's amendment number 189. It's a bipartisan amendment that Barbara Lee and I are offering. We're building really on the efforts of others, including Mr. Schiff. It would increase our government's transparency in the relatively new field of drone warfare. And I'm not here as a critic of drone strikes. As someone who flew in combat missions over Vietnam, I'm thankful that our airmen are less exposed to harm because of this technology. However, I am concerned about the disparity between the lethality and intensity of our drone campaign and the knowledge we have of this campaign. The fact is that it is exceedingly difficult for the American public, for Congress, and many of our friends abroad to have even a general picture of the extent of the campaign. Some independent research groups calculate the number of kills from drone strikes as high as 2,600 people through at least 400 separate incidents. The administration asserts that these strikes occur only when it has, quote, near certainty that no civilians will be killed or injured, the highest standard we can set, end quote. I hope and trust that this is the case. However, our government has essentially no way of confirming this empirically or legally, and rhetoric is not enough. Sadly, the debate being framed around this issue is being set largely by al-Qaeda and its affiliates, governments hostile to the United States, and to a lesser extent, the watchdog groups with only a partial picture of the campaign. Recently, Pakistan drafted a resolution in the United Nations Human Rights Council calling for investigations into the strikes for violations of human rights and instructs the Council to convene a panel on drone strikes. In response, the administration stated that it doesn't, quote, see the Human Rights Council as the right forum for discussion narrowly focused on a single weapons delivery system, end quote. I wholeheartedly agree. Instead, I think it is only natural and international interest to move this debate to the United States Congress. When I was flying missions over Vietnam, it didn't take much self-reflection to see that combat on the ground is inherently different from dropping bombs from 30,000 feet. The use of drones in place of piloted aircraft is yet another step from person-to-person combat. If our government wants to be able to alleviate concerns about drone use, then a full debate in Congress can only help. President Obama stated in a major address last May that he aimed to provide transparency and facilitate debate regarding the use of drones. However, the Senate Intelligence Committee recently removed a provision from the intelligence reauthorization that was similar to my amendment after the Director of National Intelligence assured the committee that the administration was looking for its own ways to disclose more. I am concerned that any unilateral effort by the administration will lack sufficient credibility, and that is why we've introduced this amendment. Our amendment would require the administration in unclassified and classified forms to disclose information about the numbers of combatants and civilians killed or injured by targeted lethal force strikes, excluding in future conflicts authorized by Congress. It would also require that the Secretary of Defense report on civilian protection mechanisms, combatant and civilian distinguishability, and the relative reliability of signature strikes to Congress specifically. It would also require the Secretary of Defense, the Attorney General, and the Director of Central Intelligence Agency to submit to Congress the legal opinions regarding the authority to use targeted lethal force by remotely piloted aircraft. I reiterate that all of this is required under unclassified and classified forms. Let me finally say that I do not question the legal basis we use to strike al-Qaeda and its affiliates. I think such strikes can be legal under international humanitarian law as well as under the law of war. I also do not necessarily impugn targeted lethal strikes as ineffective. They may, in fact, be the most effective way of keeping Americans safe from terrorist organizations. But I do believe we are failing to conduct proper oversight, failing to win the hearts and minds of those populations we're trying to protect from extremists, and failing to assure the American people that we're doing the right thing. I believe our amendment can help preserve these strikes as a legitimate and effective tool, and I hope that we can have a productive debate on these issues on the House floor in full view of the American people. Thank you, Mr. Chairman.
Chairman Pitts, thank you very much. I appreciate your being here today and for your testimony about your amendment. Mr. Schiff, welcome. You had told me in the last few days that you thought you'd be here, and you made it.
Yes, Mr. Chairman, thank you. Thanks.
Gentleman's recognized.
Thank you and your colleagues for your attention to these issues. And at the outset, I want to express my support for Mr. Pitt's amendment. This issue I've been working on as well, and I think very important to add some transparency in a way that I don't think reveals any kind of sources or methods, but would be greatly beneficial not only to our own accountability, but also in being able to rebut the claims of al-Qaeda that every strike is a strike on a wedding. I have a similar amendment that I'm going to be offering to the Intelligence Authorization Bill later in the week. But the two amendments I came to speak about today, the first is Amendment number 262, is similar to the one that Barbara Lee and my other colleagues have offered, and I compliment their work on it as well. When Congress passed the authorization to use military force after 9/11, it provided the President with the broad authority to strike against those who, quote, planned, authorized, committed, or aided the terrorist attacks that occurred on September 11th or harbored them. That authorization no longer properly encompasses the scope of military action that we are taking in the ongoing fight against terrorism. While the AUMF was originally directed at a fairly narrow range of actors, it has been used to sanction targeted strikes against groups and militants with little, if any, relation to the individuals who planned, authorized, and perpetrated the attacks on September 11, 2001. Last year, in a speech at National Defense University, the President acknowledged the problems resulting from our continued reliance on the AUMF and said, I look forward to engaging Congress and the American people in efforts to refine and ultimately repeal the AUMF's mandate. Article 1, Section 8 of the Constitution invests in Congress the power to declare war. It is our most awesome responsibility and is central to the success of our military efforts overseas. We owe it to the men and women we send into combat to properly define and authorize their mission. To fulfill this responsibility, my amendment will simply sunset the AUMF 1 year after the bill's enactment. By sunsetting the 2001 AUMF, Congress can reassert its constitutional duty and authority to oversee the use of military force and to properly define the enemy we face. The 1 year sunset from the date of enactment will allow Congress and the administration to determine what follow-on authorities, i.e. whether a new AUMF, is necessary to protect the American people and our commitment to the rule of law after the original AUMF is repealed. Last year, during consideration of the DoD appropriations bill, I offered a similar amendment with Mr. Rooney that gathered the bipartisan support of 185 members of the House, indicating the strong level of support for bringing our actions into conformity with the Constitution. Since then, the legal tenuousness of certain military actions under the AUMF has only increased, and I ask respectfully that this amendment be made in order. One final note on this. This is not an attempt to legislate away the threat that we face. There's no way that we can legislate away the threat. It is, however, an attempt to make sure that Congress and not the executive alone define the nature of the war that we're in. That's our constitutional responsibility. Setting a one-year deadline upon enactment will force the Congress to face tough issues it really doesn't want to face otherwise. And my concern is without a sunset date, Congress will simply continue to operate under a now increasingly antiquated legal authority. And I think we look no further than the situation in Syria to find out why this is so problematic. ISIL, the Al-Qaeda, formerly Al-Qaeda affiliate, now formally divorced from Al-Qaeda, is probably the most violent faction fighting in Syria. But because it has disassociated itself from Al-Qaeda, it raises a very difficult legal question, constitutional question, whether a authorization to use force that is tied to Al-Qaeda alone can authorize us to use force against something that the now head of Al-Qaeda has said is no longer a part of Al-Qaeda. In my view, we cannot allow our enemies to define the terms of our constitutional authority. And this is, I think, yet another reason why we have to revise, as the President said, the authority we're operating under. The second amendment that I'm offering today is Amendment 306. And this would add the voice of the House to those of many Americans who would like to see the names of 74 sailors lost aboard the USS Frankie Evans added to the Vietnam Memorial. The USS Frankie Evans, a destroyer, was launched near the end of World War II and was recommissioned for the Korean and Vietnam conflicts. After participating in combat off the coast of Vietnam, the Evans was deployed for Operation Sea Spirit training exercises in the South China Sea. This operation involved over 40 ships of the Southeast Asia Treaty Organization. On the morning of June 3, 1969, the Evans was training with the Australian Navy carrier HMAS Melbourne when the two ships collided. The Melbourne ripped the American destroyer in two. The bow sank in just 3 minutes, leaving only the stern section afloat. 74 sailors perished. Although they were in the South China Sea, these sailors' names have been excluded from the Vietnam Veterans Memorial because the Evans was just outside the designated combat zone, which determines inclusion on the wall. Although these men did not die in direct combat, they were instrumental in advancing American military objectives in Vietnam and had participated in the Vietnam conflict just days before the collision. This happenstance should not obscure their valor, patriotism, and ultimate sacrifice for the country, especially as other exceptions to the stated policy have been made, including by Ronald Reagan, who waived the combat zone criteria to add 68 names of U.S. Marines who were killed when a rest and recreation flight they were on to Hong Kong crashed. It's been nearly 45 years since the day, that June night in 1969, and the passage of time has made duller and less distinct boundaries and criteria that may have seemed reasonable and clear back then. The 74 sailors from the Evans belong with the other 58,000 Americans who gave their lives in Vietnam on the wall, where Americans from every corner of this great nation can give our silent thanks for their having given the last full measure of their devotion. I want to add, Mr. Chairman, because I know this has been an issue for the committee with analogous efforts in the past, the addition of the names to the wall is supported by U.S. Navy Secretary Mavis, and there's no financial benefit associated with their inclusion on the wall. This is not an amendment to try to gain compensation or anything else, simply to have the honor and the recognition for their families when they visit the wall. And with that, I yield back, Mr. Chairman.
Thank you very much. I appreciate you bringing your dad with you today, a member of the United States military and a proud person who chose to be with his son today, and I thank you very much. Congressman Bridenstine, we're delighted that you're for the Rules Committee, and the gentleman is now recognized.
Yes, sir. Thank you, Mr. Chairman, and thank you to the committee members. I have two amendments today. The first amendment is number 87, and the second amendment is number 88. I will start with 87. Amendment number 87 is very straightforward, and it's supported by HASC majority and minority. Section 1045 of the underlying bill directs the Secretary of Defense to certify a strategy, validate requirements, and validate a funding plan for aviation foreign internal defense, sometimes called AFID. And I think everybody agrees with the certification of the Secretary of Defense. We all want that. It's part of good government and oversight. The challenge is it fences all AFID-related funding until the Secretary of Defense meets the certification requirement and also prevents all AFID-related aircraft transfers. This has met some resistance from members of the Armed Services Committee. So my amendment does two things. First, it simply lifts the fence on obligated AFID funding to 50% of appropriated money from a blanket prohibition. This gives the Department of Defense more breathing room to keep the program on track while it meets Congress's legitimate oversight requirements. Second, my amendment permits AFID aircraft transfers 30 days after the Secretary meets the certification requirement. The current language would prevent all aircraft transfers. Mr. Chairman, AFID is a Special Operations Command-run counterinsurgency program that trains foreign air forces. In my state of Oklahoma, the 137th Air Refueling Wing is scheduled to participate in AFID and receive 9 MC-12 aircraft. As a Navy pilot, I flew combat missions in Iraq and Afghanistan. I've served active duty and continue to serve in the reserve component. Special Operations Command is following the President's and Congress's guidance by leveraging the 137th and other Air Reserve and Guard units to support the AFID mission. The President's Defense Strategic Guidance calls for, quote, innovative, low-cost, and small-footprint approaches to achieve our security objectives. AFID is the quintessential example. We train partner air forces to do more so that we can do less. Congress's commission on the structure of the Air Force called for shifting more missions to the reserve component and increasing the integration of active and reserve units. The Department's AFID strategy is moving exactly in that direction. I'm proud that the 137th at Will Rogers Air Guard Base in Oklahoma City is at the forefront. Again, Mr. Chairman, my amendment gives the Department a little more breathing space and flexibility to keep AFID moving ahead while it answers Congress's questions. House majority and minority support this amendment. I ask the committee to make my amendment in order.
Thank you very much, Mr. Bridenstine.
I have one more amendment.
Yes, excuse me, gentleman
Okay.
recognized.
Yes, sir. Thank you. The second amendment is amendment number 88, and this is an amendment last year that made it into the underlying bill on the floor of the House, and it got through the House of Representatives. It was taken out in conference, but a lot of things have changed since then, specifically in Ukraine. The crisis in Ukraine continues to confirm the wisdom of the adage, if you control a nation's energy, then you control the nation. Ukraine's dependence on Russian energy provoked the crisis in Ukraine. European dependence on Russian energy is undermining a unified Western response. Russia supplies 1/3 of Europe's natural gas and 1/4 of its oil and coal. Bulgaria, Sweden, Finland, and the Baltic states get nearly 100% of their natural gas from Russia. 7 other EU countries rely on Russia for at least 50% of their natural gas. It's important to deliver, it is impossible to deliver really painful sanctions without the Europeans on board. Frankly, Mr. Chairman, Europe's addiction to Russian energy is undermining U.S. foreign policy. Mr. Chairman, my amendment would highlight a way out. The potential for energy resources and distribution networks in Central Asia and the South Caucasus to deliver security to our NATO allies is not well understood. My amendment requires an assessment of NATO's energy dependence on Russia and the potential for a Caspian Sea-based energy, or the potential for Caspian Sea-based energy sources and transit pipelines to offer alternatives to the Kremlin. Led by private Western companies, production is booming in the Caspian and helping deliver surety of political independence in the post-Soviet space. The Baku-Tbilisi-Ceyhan pipeline delivers oil from the Caspian to the Mediterranean. The South Caucasus pipeline brings gas through the Caucasus to Turkey. Azerbaijan recently selected the Trans-Adriatic pipeline to connect the Trans-Anatolian pipeline to Greece and to Italy. The planned Trans-Caspian pipeline would deliver gas through the Caspian, thus circumventing Russia and Iran. U.S. foreign policy should better understand and promote these alternative sources and transit options. By clarifying the importance of Central Asia and the South Caucasus for NATO energy security, my amendment would increase recognition in Congress of our allies' energy dependence and prompt the Department of Defense, State, and Energy to protect new sources that will diversify supply and increase energy security. The report will also recommend ways in which the U.S. can support continued development of Central Asian and South Caucasus energy to help make our allies independent strategic actors. Lastly, Mr. Chairman, I'd note that the Rules Committee made the same amendment in order last year. The report was included in the House version of the FY14 NDAA. It was dropped in conference. Conference happened before Russia invaded Ukraine, took Crimea, and subverted local governments in eastern Ukraine and massed troops on the border. This type of report is more important now than last year. Thank you, Mr. Chairman. Mr. Chairman, I urge the Rules Committee to make this amendment in order.
Mr. Bridenstine, thank you once again for taking your time to represent the ideas which you believe in and for coming to the Rules Committee. I appreciate it. I would now reverse the order and defer to the gentleman from Louisville, Texas, Dr. Burgess, for any questions he may have. Gentleman is recognized.
Well, thank you, Mr. Chairman. Prior to a question, let me just speak for a moment in favor of Amendment 72, offered by myself and Ms. Lee from California. Certainly, I want to thank Ms. Lee for being here today and for being a leader on this issue. We've teamed up on this. Mr. Kaufman brought an amendment that we heard earlier that asked for an audit of the various departments within the Pentagon, but actually Congress has passed such an audit before. The problem is it has never been performed and never been reported. So this amendment really is not very onerous. In fact, it might be criticized for being too kind to the Department of Defense. It simply says that by 2017, you ought to have done this work that's been in the process for over 30 years, and please tell us how close you are to being finished with that product. So each department within the Pentagon would have to provide a statement to the Congress and to the General Accountability Office that would disclose how close they were to being able to comply with the audit, which has now been postponed several times and is now due in 2017, because otherwise we're going to find ourselves in 2017 in this hearing room having yet another discussion on why the audits have not yet been completed. We are simply asking them to do the work that Congress requested years ago, and I think the amendment is reasonable, and I hope the committee will make it in order. We've heard 3 amendments dealing with the authorization for the use of military force, and I think they are all good amendments. Mr. Jones, I was not here when the 2001 or 2002 vote was taken. I suspect I would have voted in favor of those at that time, but at the same time, I also recognize in this committee we've had I don't know how many discussions on the Farm Bill. The Farm Bill is a 6-year authorization. We will deal with a highway bill soon. That's another 6-year authorization. The FDA was reauthorized in 2012, a 5-year authorization. National Institute of Health, a 6-year authorization. We legislate to a 10-year budget window when we do our Budget Act. It doesn't seem to be too much to ask that we reauthorize the AUMF in a 10-year time interval. So any one of the amendments offered today, Mr. Chairman, I think are a good start, a good down payment. Mr. Schiff's, again, allowing a year from now for the sunset, may be the most appealing of the ones that are offered, but I think this committee would do well to let the House have the ability to vote on this. I think it is up. Again, these weren't even on, these weren't issues on which I could vote because I wasn't here. I would like the chance to be recorded, yes or no, on whether we should continue this policy. I thank the chairman for your forbearance, and I will yield back.
Gentleman yields back his time. Gentleman from Florida is recognized. Gentleman has no questions. I think I have a question. And the question, with respect, would be related to what I believe is Mr. Pitts's amendment. Over the weekend, I had a chance to see several movies that were related to the operations around the capture and or operations related to the killing of Osama bin Laden, the gentleman who was a terrible menace to the American public, to innocent people, and who I believe became the effort of the war, who did not live up to any of my ideas of a civilized person. He, in fact, did understand operational procedures of the United States, including our operational issues of engagement and surrounded himself with children and women. How would your amendment play into this? Would it mean that for a drone strike, would it mean that a drone strike would have to be off the table if he was found somewhere? Or I'm just trying to play out how that would happen. Would it mean that we would have to have men and women, or men who would be on the ground as they did do for the exercise? Would it eliminate a drone strike is my question.
No, it would not. It would require reporting of both combatants and non-combatants, civilians, require the legal authority to be reported, and it can be done in both a classified and unclassified way. So if there are methods and sources that should be protected, that would be provided in the classified annex.
So in other words, Mr. Pitts, what you're saying is yours is a reporting requirement, not a standard of exercise that would be required in the use of drone strikes.
It is, yes. It is. It's an effort at transparency so that we know what the legal authority is and what the numbers are for combatants and civilians, because the reports that are out there from Al-Qaeda and the other sympathizers are grossly exaggerated, I think. But we have no way of really knowing, and transparency would help us establish the integrity. And I'm sure our military leaders are working hard to protect non-combatants, but I believe that the data will demonstrate that we're doing our best to minimize collateral damage.
So in other words, operationally, it would require an understanding of the target, of how many people would be there, civilians and others. And you've broken it down into combatants and civilians. Do you think that you have a good understanding about an American who might be engaged in combat operations? That would you consider them to be a combatant? Is there a line, a designation there?
We do not raise that in our amendment. The legal justifications that we ask for could deal with that, but we don't raise the issue of American versus non-American. We deal with combatants and
right.
non-combatants.
Following a standard, excuse just a moment, sir. Following what you consider to be a standard that they already have established, so you're not challenging a standard at all. You would accept their designation.
That's correct. Okay. Report with transparency to the American public and Congress.
You've thought about this more than I have, and your answers are very clear. You're in no way trying to do anything other than make sure that reporting allows the department and members of Congress and the public to have an idea about
the numbers
what was there.
And legal justification.
And legal justification, yes. Mr. Schiff?
Thank you, Mr. Chairman. I just appreciate the opportunity just to add on this issue that we've discussed in the Intelligence Committee, and an analogous measure in the Senate has also been under debate there. I think the most important aspect of this is the administration has said that we will only take strikes where, to a near certainty, there won't be civilian casualties. Under the present system, there's no way to really hold ourselves accountable to that standard if we can't have any kind of public accounting about how many combatants were killed and how many civilians. I think it's important to have that kind of just a raw number at the end of the year. This is how many combatants that were killed, this is how many non-combatants were killed, and this is how we define a combatant. Both in terms of holding our own feet to the fire to make sure that we're meeting the high standard we've set, but also to rebut the claims that are made by Al-Qaeda, Taliban, and others that everyone who struck is a civilian going to a wedding. So I think it's both beneficial in terms of the propaganda war. We're kind of operating with our hands tied behind our backs, but it's also important to allow us to hold ourselves accountable. Thank you, Mr. Chairman.
May I comment, Mr. Chairman, on this? I
Ms.
think,
Lee.
This is very important, this amendment, and I thank you for offering this. I have amendments and legislation very similar, and what I am reminded of is that by this reporting and by understanding the numbers and what is taking place, it's a real effort, I think, to ensure our national security, because we know, again, the rhetoric and what takes place after drone strikes. Oftentimes, there's more anger toward the United States. We're defined in a way that we don't recognize this country and who we are. And so this information, I think, is extremely important just in terms of ensuring our national security as it relates to the use of drones. We need to minimize the anger and the hostility toward our country. And I think this would certainly give us the facts, and we would know exactly, and Congress would know what the deal is, quite frankly, as it relates to how drone strikes are being operationalized and who are, if there is collateral damage, how much, and who the combatants versus non-combatants are, and what the reality is. I think, again, it's a real national security issue that we need to really look at. Thank you.
Thank you very much. Mr. Bishop, I note that you're here. Does the gentleman seek recognition?
Can I just ask one question?
Gentleman's recognized.
What was the number of the base bill? I think you said units per
Lee, 116?
The base bill. 4608
Oh, I'm sorry. The legislation that I introduced is H.R. 4608, I believe. Is that what it is? Yeah, 4608. It's the War Authorization Review and Determination Act, the WARD Act. Thank you.
Thank you very much. Does the gentleman from Florida seek recognition?
Well, I'd like to just, may I thank?
Excuse me just a moment. Does the
sorry.
gentleman seek recognition? Yes. Gentleman's recognized.
I just wanted to thank the gentleman from Florida for co-sponsoring my amendment, and certainly with his very distinguished background in intelligence and in foreign policy and in military policy. He has looked at this amendment, and I was very proud to be able to report that he is a co-sponsor. And thank you, Mr. Hastings.
I was trying to keep my business out the street, Ms. Lee.
Gentleman yields back sentence. By the way, we feel like we get a 5-for-1 issue with Judge Hastings up here. He's a very valuable and dear friend, but he is an important part of our committee, and I count on him often. Sometimes not so much as often, but we do very, very well with each other, and the gentleman knows that how much we appreciate that. Does this panel believe they've been given adequate time to explain what they were doing? Mr. Jones, it seems like an hour ago since you gave your explanation, but I think that we have a pretty good idea, and I want to thank each of you for taking time to be with us. Mr. Schiff, once again, not many times do we have members that bring their dad up with them, but let me assure him that you are a valuable part of this organization, meaning as a member of Congress, but also your service to people of California is important. And I know any dad wants to show up and see their son do real well. So, job well done.
Mr. Chairman, I thought I ought to bring the big guns with me.
Big guns were apparent. Thank you very much. This panel is now excused. Thank you very much. We'll now engage panel number. Yeah, I'll take care of that. We are now moving forward on a first come, first served basis, and we've moved to panel number 4 that would include the gentlewoman from Wyoming, Mrs. Lummis, the gentleman from Iowa, Mr. King, the gentleman from Arizona, Chairman Franks, the gentleman from Pennsylvania, Mr. Thompson, and our dear friend from Vermont, the gentleman, Mr. Welsh. I recognize Mr. Cleaver walked in a few minutes afterwards. Mr. Cleaver, we promise to get to you, and then we'll have a panel number 5 as quickly as we finish. Ladies and gentlemen, please be advised anything you have in writing, we would appreciate getting a copy of that. Without objection, I'll be entered to the record as you choose. Secondly, we have in front of Mr. Thompson a list of amendments which have been provided, which is being provided to you with the expressed hope that you will take time to identify the amendments that you would choose to talk about and identify those to the committee, allowing us an opportunity to understand the discussion that you would have with us. And because we have a wonderful member from Wyoming with us, the gentlewoman will be recognized first.
Thank you, Mr. Chairman. I really appreciate the work that this committee does and staff as well, both from Armed Services and the Rules Committee. Thank you for your time today. First, I'd like to discuss the fact that in the fiscal year 2013 NDAA, there was established a National Commission on the Structure of the Air Force. Now, their report came out in January of this year, and it recommended increasing integration of our Guard, Reserve, and Active Component Airmen. Yet, the fiscal year 2015 Air Force budget requests doing exactly the opposite of what this congressionally established commission determined would be the best strategy moving forward. Specifically, the FY15 Air Force budget proposed closing all C-130 active associate units and divesting a number of C-130H aircraft, which reside exclusively in the Guard. That includes Wyoming's 30th Airlift Squadron, which is one of the oldest and most successful active associate wings. So, I have proposed Lummis Amendment number 35, it's Rules Committee Amendment number 196. It would prohibit the termination of any Air National Guard C-130 active associate unit until 120 days after the Secretary of the Air Force submits to Congress the report required by the House FY15 National Defense Authorization Act. Now, that should happen in February of 2015. So that is my first amendment. The second amendment I want to discuss is something that you've addressed before. It's a sensitive subject. It's very important to my constituents. My amendment is simple. It would amend the Non-Detention Act, which states that no citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress, to specifically prohibit the indefinite detention without charge or trial as far as a U.S. citizen or lawful permanent resident is concerned, if they are apprehended on U.S. soil. So in other words, even if U.S. citizens and lawful permanent residents are suspected of terrorism, they can only be detained on U.S. soil if they are charged with an actual crime. And that would trigger their constitutionally endowed rights. Now, this amendment passed the Senate in a bipartisan majority by a vote of 67 to 29. Unfortunately, it was not included in the final version enacted into law. Confirming the constitutional rights of U.S. citizens and lawful permanent residents would not jeopardize our ability to detain and interrogate foreign terrorists or to detain U.S. residents on foreign soil, but it would preserve the fundamental principles on which our nation is founded as to U.S. citizens on U.S. soil. And finally, Mr. Chairman, for a third amendment, I am joined by the gentleman from Vermont, and if I might just endorse his amendment and defer to him for a quick explanation.
Your overwhelming generosity to the gentleman will be extended by the committee. The gentleman's recognized.
Thank you.
know, Mr. Chairman, if I didn't have an amendment, I want to come up here just to
be with
benefit
Cynthia.
of your
You know what?
gracious Texas hospitality.
Well, thank you very much.
Really appreciate it.
In this case, it
you
was.
don't get much love around here. You got to come to the Rules Committee.
Well, we're the love committee. If you know, he did have that chance. I don't know what he did. All I know is we miss you. We miss you, Mr. Welsh, and I'm delighted that the gentlewoman from Wyoming brought you up here. You know, she tags around only the best.
Well, that's true. And she and I have traveled to Afghanistan and Pakistan a few times and are good travelers. We have an amendment that has broad bipartisan support. It's about the question of our intelligence budgets and whether or not the top line number should be disclosed to the American people when the President submits his budget to the Congress. And I emphasize it's the top line number. It's not the details. It's not messages below that that might give information that would disclose anything related to ways and means or activities that are engaged in for our intelligence. But here's the issue. National intelligence is obviously of extraordinary importance. Transparency is of enormous importance. And we, each of us, has to submit ourselves to re-election by the voters every 2 years. And we have to disclose what we've been doing, what we're up to. We have to answer questions as to why. And I believe that all of us on both sides of the aisle think that's a good thing. With respect to our entire budget outside of intelligence, it's subject to kind of the same scrutiny. And while it's absolutely the case that the intelligence budget is going to be and must be treated differently than other governmental functions in order to preserve the secrecy, there are still top-line number questions that are relevant to beginning the transparency that's required for the American people to ask legitimate questions. Since 9/11, of course, there's been an explosion in spending, and we have 17 different agencies that are doing work. How are we to know whether they're duplicating work, whether they're bumping into each other, whether we're getting our money's worth, whether they're doing a good job? In the beginning of transparency is giving that top-line number of all of these budget agencies. The 9/11 Commission, which included some very well-respected national security people, including Lee Hamilton, believed that this is a very important step. And I just want to quote Lee Hamilton because he sort of sums up the argument. America needs competent and effective intelligence gathering agencies, and Congress must exercise prudent and diligent oversight to assure the American taxpayer it is getting what it's paying for. And the first step toward accountability and oversight is public disclosure of the top-line budget numbers of all our intelligence gathering agencies. We've got a pretty good cross-section of Congress on that. Congresswoman Lummis, and me, Jim Jordan, Jim Sensenbrenner, Representative Burgess and Gowdy, Representative Van Hollen, Representative David Price, and I've got a list of the 64 co-sponsors that I'll leave here with the committee. So the question is, are we going to have at least elemental transparency applied to the top-line expenditure? It's taxpayer money. Many in the National Security Agency will take, I think, a reflexive position of opposition to disclosing anything, but is that necessarily good for the long-term credibility of intelligence gathering agencies and the confidence they need in the American public? So our request is that you make this in order, allow Congress to have a debate and a vote on this in connection with the budget. And I thank my colleague, Congresswoman Lummis, who's been a great advocate on this bill.
Thank you very much. We'll defer next to the gentleman from Arizona, the gentleman, Chairman Franks. Mr. Chairman, you're recognized.
Well, thank you, Mr. Chairman. Mr. Chairman, prior to the President entering into an interim agreement with Iran related to their nuclear weapons program, our office drafted legislation to lay out congressional priorities as to what should or should not be in that agreement. Unfortunately, that legislation didn't have an opportunity to be voted on or addressed by the Congress prior to the agreement coming into place. So consequently, Amendment 305 would give Congress the right to hold a non-binding sense of the Congress vote on any U.S.-Iran deal over Iran's nuclear program within the days of the Obama administration formally signing such a deal. The amendment would also provide for Congress to hold hearings on any final deal. And I want to be clear, Mr. Chairman, that in offering the amendment, I want to see any final nuclear agreement between the P5+1 and Iran to succeed for the American people and for the cause of freedom. I do, however, worry that with the interim agreement as our precedent, a final agreement with Iran might retain the element of allowing a continued protocol to protect Iran in their uranium enrichment, or their ability to produce plutonium. And ultimately, this is the entire ballgame. Allowing Iran these capabilities in the interim deal was a breathtakingly short-sighted thing, but allowing them to retain these capabilities in any final deal could have dangerous consequences that really beggar my ability to articulate. We must be reminded that as long as Iran retains domestic uranium enrichment or plutonium production capabilities, it will ultimately retain the capacity to produce nuclear weapons-grade materials and remain a nation with at least a nuclear breakout capacity. Israeli Prime Minister Benjamin Netanyahu said that the U.S. gave Iran the, quote, deal of the century in the nuclear program negotiations. Even Saudi Arabia has voiced strong opposition to the potential deal with Iran. One Saudi official said, senior Saudi official said, on a good day, we're paranoid about Iran. But in the current environment, our fears have only been exacerbated. Mr. Chairman, the United Nations Security Council has adopted multiple resolutions since 2006 demanding Iran's full and sustained suspension of all uranium enrichment-related and reprocessing activities, and Iran's full cooperation with the IAEA on all outstanding issues related to nuclear activities. To date, Iran has violated almost all of those resolutions. Mr. Chairman, if Iran's nuclear aspirations are only for peaceful purposes, the question occurs why they would continually violate these resolutions and hide their nuclear facilities for decades in such a secretive type of compounds. All this amendment seeks is to ensure that this Congress, as representatives of the American people, receive the opportunity to put ourselves on record related to a deal that could have the most profound of implications for generations to come. And I thank the Chairman for allowing me to offer this amendment, and I would yield back, sir.
Thank you very much. Mr. Thompson, I'm delighted to have another Eagle Scout up here. I sometimes need some help. I see we've been joined by the chairman of the Scouting Caucus, the gentleman from New York, but I'm delighted that you're here. And the gentleman from Pennsylvania, the Eagle Scout, is recognized.
Well,
there's actually at least 3 of us in the room. These guys are impressive. Gentleman's recognized.
Thank you, Chairman. This my amendment's number 148, and so Chairman Sessions, members of the committee, thank you for allowing me an opportunity to testify on my amendment, which will institute a preliminary mental health assessment for all incoming military recruits. Since last year, several studies have been released which further illustrate the need to evaluate the mental well-being or the wellness of individuals prior to joining the military. A recent Army study found that, quote, nearly 1 in 5 Army soldiers enter the service with a psychiatric disorder, and nearly half of all soldiers who tried suicide first attempted it before enlisting. In March, Representative Tim Ryan of Ohio and I introduced the bipartisan H.R. 4305, the Medical Evaluation Parity for Service Members, or MEPS Act of 2014, which is the exact language of this amendment. The small but consequential change to current law will bring mental health to parity with physical health during the entrance screenings. A preliminary evaluation will also have the purpose of serving as a baseline to identify changes in behavioral health, including traumatic brain injury and/or post-traumatic stress injury throughout an individual's military career. Today we have individuals that are leaving the military and being denied access to services, healthcare services, because they're the injuries they're leaving with are being deemed to be a result of something that was pre-existing, whereas this would provide that baseline. So there are two functional, obviously, the health and well-being and and obviously making sure we have a baseline to determine truly what is service-related in terms of injuries that are experienced when those brave Americans serve our country. Protecting individual privacy was taken into the utmost consideration with putting this amendment together. And since introduction, the MEPS Act actually has garnered over 35 bipartisan co-sponsors and the support of over 40 major military veterans and health advocacy groups. And with this in mind, I would ask the committee to find this amendment in order for floor consideration. I'd be happy to take any questions you have.
Thank you very much. We appreciate your thoughtfulness to come to the committee today. We also would recognize the gentleman from Iowa, my dear friend, Mr. King. Gentleman's recognized.
Thank you, Mr. Chairman. I appreciate being recognized, and I'm asking to actually speak a little out of order and address the Denham 58 amendment. Sometimes because we're able to see what's going on in here, I was able to come over here, and it occurred to me that as he offered this amendment last year, it was ruled in order by the Rules Committee, and then the jurisdictional debate took place, by my recollection, on the floor, where, if I'm correct on this, it was withdrawn. It occurred to me that it'd be better to make this argument here before Rules than it would be to wait till the potential that it might get to the floor. But I wanted to remind the committee of the jurisdiction of the Judiciary Committee, and that is specifically that all matters relating to subjects within the jurisdiction of the standing committee shall be referred to those committees. And the jurisdiction of the Judiciary Committee includes, number 9, immigration policy and non-border enforcement. So that jurisdiction is clear. And I would also make some arguments against the amendment itself and encouraging the Rules Committee to not rule it in order. And that is this, that if someone is going to sign up into the United States military, they have to be a lawful permanent resident or American citizen or misrepresent themselves. That's one. Second one is they take an oath to uphold the Constitution. You can't misrepresent yourself and then take an oath to uphold the Constitution and have both of those statements be true. And then the third is that we've always had enough Americans to serve in the United States military. About half the population of today was the population we had going into World War II. And there were 16 million Americans that put on a uniform to defend our country. So that's roughly 30 or more million Americans today. That's a long ways from where our military is. There are millions of Americans to draw on if we need to fill up our military. But in fact, we're shrinking our military. And as a downsizing of the military, it means that our standards go up. It's harder and harder to get into the military, harder for American citizens to get into the military. So this isn't a readiness amendment, as was, I believe, represented before this committee. It is an amendment that deals with immigration, and the jurisdiction of the Judiciary Committee should be asserted. And so I'd ask for the opportunity to be recognized to make the statement before the Rules Committee, and I appreciate your consideration of the jurisdiction of the various committees, and I'd urge the Rules Committee to find the Denham Amendment number 58 out of order. I thank you, and I yield back.
I thank the gentleman for his testimony. I would defer to switch my position and defer to the gentleman from Louisville, Texas, Dr. Burgess, for first question. Gentleman's recognized.
Thank the Chairman for the recognition. I do want to acknowledge that I have supported Mr. Welch's underlying bill, and I do believe that transparency is important. I would disagree that this is elemental. I would say it's rudimentary transparency. Elemental implies some degree of purity, but this is rudimentary transparency, and I think we should be for that. So I appreciate him bringing the amendment here today, and encourage the committee to consider its support, and I'll yield back.
Gentleman yields back his time. The gentleman, Mr. Montgomery. Does gentleman, Mr. Polis, have any question? Does not. Gentleman from Utah is recognized.
Maybe, Ms. Lummis, I could ask you, you have an amendment that deals with 130. Ms. Elmers was here just a moment ago, also having an amendment that dealt with the C-130s. As you have talked to him, can you just tell me the basic reason for the Air Force's decision in the first place, i.e., when we were talking about A-10s, they desperately wanted to keep A-10s, they just didn't have the money for it, so they had to find the lowest priority. Is this one of those other elements in which it was a case of low priorities, in which case the root problem is not necessarily the C-130 or the age of the C-130 or the National Guard work, it is simply that we are underfunding significantly our military commitment, and that becomes the root problem. Is that what they were told? If the money had been available, would the C-130s still be working with the National Guards?
Mr. Chairman, I don't have an official score from CBO, but I have an estimate that the elimination of the C-130 Air National Guard Active Associate Unit this year would save $13.85 million. And so my amendment, even though I don't have a score, but I have a decent estimate, includes an offset that would reduce the operations and maintenance funds within the overseas contingency operations by that amount, $13.85 million.
But the issue is not the efficacy of the program or the efficacy of the Guard. The issue is simply it's a budget drill. The decision to reduce them was driven by the fact that there is not money put into this budget that ought to be there.
Mr. Chairman, that is my understanding, but I don't have independent confirmation. I simply know that our Adjutant General in Wyoming is concerned that this Congress asked for a report. The report indicates that we should keep the integration of active and reserve and the Guard. And in spite of their recommendations, this proposal will do just the opposite. So I have to believe it's money related.
I want to put that out simply as kind of a basis as we go through here. We're going to have some of their amendments that deal with helicopters from the Army. We have an amendment in there in the base bill that deals with the A-10 issues. In all these situations, the decisions that were made were a basis of overall funding levels. And that one of these things is it's not because these programs are useless or because these programs are not effective. It's because we simply had to go through a budget process to try and find more money in some place. Could I also ask Mr. Franks, you talked about, was the amendment that you presented the one about the vote of disapproval?
I'm sorry, sir, please.
Was the amendment, that one of which you spoke, was the vote of disapproval amendment?
Yes, of course, the vote could go either way, and it's important to note,
well, we could actually write it so it goes the correct way, couldn't you?
Sure.
Okay, I'm sorry, go ahead.
But, Mr. Bishop, it's important to note that this is not an attempt to second-guess the President. This is an attempt to add a layer of accountability to the discussions that could take place, knowing that this would be before the people.
The question I really had is, because I have not looked at it, is there a time limit that was written in the amendment, as in when that has to take place?
It's within days after the, I'll get that information for you.
All right. I'm sorry. And I haven't looked at it. I should have looked at that myself. I didn't know that one. I apologize. Yield back, Mr. Chairman.
Gentleman yields back his time. Gentleman from Florida seek recognition. Gentleman's recognized.
Mr. Franks, while I understand what you just said to Mr. Bishop regarding offering up an added layer, how do you perceive that is to be received by the P5+1 that are in ongoing negotiations? And can you not see how measures that we take can interfere? Now, mind you, the United States may be a driving force, but in the P5+1, there are more interests in the world involved in this negotiation than just the United States. And therefore, I have a concern, whether you perceive it or not, or intend it or not, to be second-guessing the administration. It will be perceived that way by some, and I'm one of those that feel that way. So give me the justification for your idea about you knowing more about whatever a deal might look like than the people at P5+1 that have been in negotiations and are near an opportunity to undertake to do things, both if they reach a deal and if they do not. And that's what I think you're missing when you come forward this way. I'll yield to the gentleman for any response.
Well, Mr. Chairman, Mr. Hastings, I would just suggest to you, sir, that I respect your point, but the Constitution itself lays out, even when the President signs a treaty, that he is subject to ratification in the Senate.
No question.
We've always recognized the importance of being able to have congressional input on things of profound significance to our country. And it just seems to me that when we're dealing with potentially a jihadist nation placing their finger on the nuclear button and potentially plunging the entire world into the shadow of nuclear terrorism, that rates something consequential enough to be able at least call for the Congress to have some ability to at least register their perspective or opinion.
What would make you think we wouldn't do that anyway? We've had resolution after resolution, and I supported most, if not all of them, dealing with the sanctions having to do with Iran. So if, for example, there's a skewering in any way, this particular Congress especially seems hell-bent on anything that they can do to block this administration's undertaking.
Well, sincerely, I don't suggest to you that I'm not a partisan opponent of the president. That would sort of be ridiculous. But I nevertheless think that the point is worth noting that the entire plethora of UN resolutions that was passed have been ignored by Iran, and in each of those most of those resolutions, they required this ability or this requirement for Iran to dismantle their uranium enrichment program and not to be able to produce plutonium. Under the interim agreement, that's actually a protected protocol. And this is a pretty significant departure. So I would say to you that the world opinion, if it is reflected at all by the UN, has already been contradicted by this administration.
Well, let me come at you another way with it then. The IAEA has more access today because of these ongoing negotiations than they have ever had. And let me make it very clear to you, I'm adamantly opposed to Iran achieving a nuclear status that would allow not only for the danger in their near abroad, but they also have missiles that can impact our interests, as well as perhaps potentially at some point this country. But the simple fact of the matter is, we have already exercised some pretty extraordinary sanctions, and those sanctions are having an impact that might cause them to go to the next level. It does seem that IAEA thinks that they have abated their enrichment process, at least for the moment. And the question then, you argue, I would think, that they would have breakout capacity at some point. But the simple fact of the matter is, if you have Russia and the European Union and the United States sitting in an arena with these people and talking, it may very well come to a point where we avert that possibility of their having a nuclear weapon. And I, sir, for one, don't think that your proposed disapproval resolution at this time helps that process at all.
Well, Mr. Chairman, Mr. Hastings, let me just point out that this allows the Congress, if they choose, within 15 days, as Mr. Bishop's answer, within 15 days, to hold hearings or a vote. It doesn't require them to. And so if indeed, as you postulate, that the President comes up with something that we all believe is reasonable.
Mr. Franks, it isn't just the President, it's the P5+1. The United States is a driving force, but Putin is at that table, and Germany is at that table. You understand? So don't just dump it all in one arena. And I might add, don't you one time think that everything that is going on in these negotiations is not being watched by Israel, by Saudi Arabia, by the United Arab Emirates, and by China, and by other people. I don't want to, I'll talk with you personally about it in the interest of time. Yield back my time.
Yeah, first of all, I agree with you that Putin is at the table. It's important to note that the Russian Federation has assisted Iran in many of their capabilities that have moved them towards a breakout capacity. They are now at that breakout capacity. That's not something that could precipitate. That's something that exists now. And secondly, the Prime Minister of Israel, I mentioned in my commentary here that they, yes, indeed, are watching. And they said that the interim deal that the President signed with Iran was the deal of the century for them. They were not very pleased. So to put those, well, and Mr. Chairman, just let me just close it. If this turns out to be a good thing, we're all happy. But if it doesn't, it seems to me that the Congress should have the ability to register their perspective.
Appreciate the gentleman's comments. Gentleman yields back his time. The gentleman from Orlando, Florida is recognized. Gentleman does not seek recognition at this time. Mr. Franks, I was visited by some constituents from Dallas, Texas today who I believe mirrored your piece of legislation that you have. And I just wanted you to know that I heard from them about their ideas, and it's my intent to make sure that I read your legislation. Obviously, we're going to have to look at it as an amendment, but I want you to know that I received feedback from members of the community in Dallas that I represent, and they almost mirrored at least your comments about the ideas about having feedback related to that. Is the gentleman, Mr. The committee appreciates, does any other member seek recognition at this time? The committee this afternoon received information that has rocked us, and that is that our colleague Louise Slaughter's husband passed away this afternoon. And Mrs. Slaughter, as you know, is not just an active member of this body, but she serves as the ranking member. And Bob was up here on a regular basis all the years that I've been here. This is year probably 17 that I've been up here. Bob always came up with a smile on his face, and I think had a lot of enthusiasm that Louise demonstrated. And I wanted to defer, if I could, to the gentleman from Massachusetts for any comments he'd like to make about Louise and Bob Slaughter. Gentleman's recognized.
Well, thank you, Mr. Chairman, and I join with you in honoring a great friend and a great man, Bob Slaughter, who we all have come to know over the years because he was a regular presence here in this committee. And Bob had a great sense of humor. He watched the Rules Committee either in person or on C-SPAN religiously. He was a man with a great sense of humor. He would remind me that when I'm on C-SPAN, I need to have my tie up and my button because it doesn't look good otherwise. I didn't always take his advice, but he was an incredible person who was curious, who I think would have made a great member of Congress himself. Took great pride in Louise's service here, and I'll just conclude by saying, we all have our battles up here in the Rules Committee, but we spend an awful lot of time together, and so we're all part of a family, and so when something like this happens to someone we care about, we serve with, it brings a great sadness to us all. So I appreciate you taking this time to honor Bob and also to keep Louise in our prayers. Louise and Bob were married for decades. They had 3 daughters and 7 grandchildren. So our prayers are with Louise and her daughters and her grandchildren, and we'll be there for Louise, for whatever she needs. But I appreciate you taking this time to and if I could maybe just ask for a moment of silence, I would appreciate that, Mr.
The committee will commemorate a moment of silence in honor of Bob Slaughter and Louise. Thank you very much.
Mr. Chairman.
Thank you, Mr. Chairman. Does anyone seek recognition on this subject? Gentleman from Colorado is recognized.
Well, I think Bob would have appreciated the humor in saying we've lost about half of our viewing audience with his passing. You know, just yesterday, Louise commented I was wearing a bow tie. As some of you know, I've done that from time to time. She said, "Oh, it looks just like Bob wears." Just shows for all of us how fleeting life is and how we should treasure every moment with friends and family and loved ones and make the most of every moment. And of course, Bob's memory and legacy will be strong in all of us who got to know him here in the late nights at committee. Again, one of the small viewing audience over television, and oftentimes one of only 2 or 3 people in the room during midnight meetings as well. I see there's many more here, of course, as we approach dinner time. But I remember a number of times under your predecessor, Mr. Dreyer, of course, and when this committee was meeting in the wee hours of the morning, and as cheerful as ever, and as awake of ever, sporting his bow tie, was Bob Slaughter in the audience, and we will remember him fondly. Yield back.
Thank you very much. The committee thanks you for being here, putting up with our explanation of not only our colleague who would have been here, been most active, and Peter, you might have had some more help here. There's no telling, but you've come and been here today with us. I want to thank each of you, not only for taking time and for the hour or so that you gave out of your day to sit and listen to others, but I want to thank you. We will very clearly and carefully look at the amendments that you brought forward to us. This panel is now excused. Thank you very much. Yes, sir. Sure. We would now move to panel number 5. The gentlewoman from Kansas, Congresswoman Jenkins, the congressman from Missouri, Mr. Cleaver, the congressman from New York, Mr. Bishop, the congressman from New York, Mr. Tonko, and the gentleman, an Eagle Scout and the chairman of our scouting caucus, the gentleman, Mr. Collins from New York, would be asked to join this panel also. I'm delighted that each of you are here. I know you've been taking a good part of your afternoon, not only to join us, but perhaps you've seen that 1, 2, 3, 4, 5, I was expecting one more. Mr. Cleaver, Mr. Bishop, Ms. Jenkins, Mr. Tonko. Oh, Mr. Tonko is not here. Mr. Congressman Nolan, we'll have you here. It's his first come, first serve. Must be present to win the prize. So, Rick, we will teach him a big lesson here. Thank you very much. Each of you have probably known that what we're attempting to do here today is to receive your feedback and the benefit of your knowledge, not only who you represent, but your ideas. But we're dealing with several hundred amendments, and we would ask, to the extent that you can, there's a list right there in front of Mr. Bishop that will allow you a chance to make sure you can refer to your amendment by the Rules Committee designation of a number. That will allow us, if we wish to refer to that. So we've got a yellow marker there where you can mark yourself off when you see your amendment, but that will allow us to once again stay up with you. Congresswoman Jenkins, I don't know whether you've had a chance to prepare yourself accordingly, but we're delighted that you're here, and thus the gentlewoman would be recognized. And by the way, anything you have in writing that you would choose to enter in the record without objection, that'll be done. Gentlewoman's recognized.
Thank you, Mr. Chairman, and I will add my condolences to our ranking member, Ms. Slaughter, and will keep her in my thoughts and prayers. I will direct you to, I believe it's Amendment 135. As you all know, the National Defense Authorization Act is an important piece of legislation which directs our nation's defense leaders and authorizes our armed forces to protect our nation. It's an important tool for Congress in our role as oversight, which is the role that my amendment pertains to today. In 2008, Congress passed legislation to suspend public-private competitions at DoD through the OMB Circular A76. The moratorium remains in place today. In 2009, OMB issued a memorandum which regulated the move to insourcing at the Department of Defense. Today, nearly half of the federal government owns and operates thousands of activities that are commercial in nature. They're functions that are not inherent or unique to government, but rather they can be found in small and Main Street businesses across the nation. Not only are these federal agencies duplicating private businesses, but many engage in unfair government competition with the private sector. My amendment seeks to place a moratorium on the insourcing of previously contracted activities within DoD. Exceptions would be made, number one, if the activity was inherently governmental and thereby should never have been contracted in the first place, and number two, if DoD would employ a reverse A76 to itemize specific cost saved to the taxpayer should the DoD be able to perform the commercial activity more efficiently for the taxpayer. According to OMB, the act of conducting this competition alone can generate savings of up to 10 to 40% on average. At the state and local level, this is a bipartisan issue that's been it's resulted in billions of dollars in savings. Not only is there potential for monetary savings, but there can be improvements in quality of services performed, thus better providing a better value to the taxpayer. My amendment strikes a balance. If the service is inherently governmental, it should not be contracted out. If it's a commercial activity, the federal government owes it to the American taxpayer to get the most value, the most efficiency, and the best service available. We also owe this to our war fighters who ensure they are receiving the best possible services as they protect us. This can't be assured without the use of fair and competitive practices. I would like to point out my amendment is supported by the Business Coalition for Fair Competition, the American Legion, as well as the National Veterans Small Business Coalition and the Competitive Enterprise Institute. Mr. Chairman, there are numerous small businesses, veteran-owned businesses or minority-owned enterprises that could benefit from this amendment. Some have either lost a government contract due to insourcing or have been unfairly denied a contract because no competition took place. The DoD is the largest contracting agency in the federal government, so it is a reasonable place to start reversing this trend. With a debt of more than $17 trillion, calls for reductions that will erode the end strength of our military and a stagnant private sector job market. We must find ways to reduce spending and find efficiencies at DoD while boosting job creation in our communities. This amendment is an opportunity to vote for small business, break up federal government monopolies, ensure more efficient services, empower the warfighter, maintain adequate funding to DoD for its core mission, and bring fairness to DoD. And thank you. I yield back.
Thank the gentleman. We'll continue down the line. Mr. Cleaver, the gentleman first recognized.
Thank you, Mr. Chairman. Let me preface my brief comments by just saying that this amendment is not opposed by anyone. I'm sure we could find somebody, but at this point, there's no one who is opposing it. It's bipartisan. Every member of the Missouri delegation and one member of the Kansas delegation who is in the same metropolitan area, Congressman Yoder. This Amendment 79, also known as the World War I Memorial Act of 2014, it redesignates Pershing Square in Washington, D.C. as the National World War I Memorial, and will designate the Liberty Memorial at America's National World War I Museum in Kansas City, Missouri, as the National World War I Museum and Memorial. It would also make a few necessary adjustments to the originating commission bill, Public Law 112-272. And as you know, this summer marks the 100th anniversary of the start of World War I. The United States formally joined the war in April of 1917. During that time, more than 4.7 million Americans served, and those brave men and women, of those brave men and women, more than 116,000 soldiers made the ultimate sacrifice. It is our job, I believe, to honor their memory and show our appreciation to the veterans of the Great War for their service. Many veterans of our country, including the families of members who fought in World War I will be at Memorial Day programs next week. And I think it would be a bold and beautiful statement if members of this House could say that finally we have, in fact, created a memorial to World War I. As you know, World War I is the only war that we did not build a national memorial or monument. The District of Columbia did. And this legislation, this amendment, would designate Pershing Park here in Washington, D.C., with the support of the delegate from Washington and the National Park Service and the World War I Centennial Commission and the National Guard Association and the VFW, which is national located in Kansas City, not far from the museum. And so it's been 100 years since the start of World War I, and to this date, we have no national memorial to honor that period in our history. So I'm asking that this amendment be found in order so that we can recognize the great sacrifice made by these brave Americans. Thank you for your consideration.
Thank you, sir. Appreciate it very much. Mr. Bishop, every time I see you on third base. Not everybody was...
Not because I've gotten a hit that's gotten me that.
Well, I didn't mean to suggest that, but I enjoy looking up at you at the baseball game on a regular basis, and perhaps this year I'll be on.
I'm getting older there.
Well, I'll let you talk about that. I think you're getting better. Gentleman from New York is recognized.
Thank you, Mr. Chairman. My amendment seeks to address a growing health issue among our nation's veterans returning from Iraq and Afghanistan. Many of our brave men and women who served in Iraq and Afghanistan were exposed to the toxins associated with open-air burn pits, and they are now presenting a variety of very serious illnesses and complications that has been caused by that exposure. It's estimated that there are some 30,000 of our nation's veterans who might be suffering as a direct result of their exposure to burn pits. This is an issue that our Congress has dealt with on a bipartisan basis. We first essentially banned those burn pits once the Congress learned that they existed. Most people didn't know they existed. And we then voted on a bipartisan basis to create a registry of all of members of our armed forces who served on bases where they were exposed to these burn pits. And I believe that my amendment would be the next step, and that is to create 3 centers of excellence across the United States to study, diagnose, and treat illnesses related to burn pit exposure. This amendment is the base bill that I've offered is H.R. 2510. The amendment is modeled after the successful framework that we, on a bipartisan basis, have put in place for the Defense Centers for Excellence for Psychological Health and Traumatic Brain Injury. It would create a competition for these 3 centers, although I will say that there are 3 hospitals across the country that have taken the lead in studying this issue, and they've done great work. And I will also say that the work that they've done has not been appreciated or fully accepted by the Veterans Administration. The Veterans Administration current policy states that exposure to burn pits does not cause long-term health consequences, and that is a conclusion that is not shared by the medical community, and it is a conclusion that's not shared by the veterans advocacy community. So my own view is that this issue left unaddressed has the potential to become the Agent Orange of the Iraq and Afghanistan wars. We all know the serious, serious issues that resulted from exposure to Agent Orange, and frankly, we're still dealing with them. So I'm hopeful that the Congress can come together once again to stand behind the men and women who have been exposed to these toxins. And we're talking about very serious illnesses. We're talking about several different types of cancers. We're talking about constrictive bronchiolitis. We're talking about serious gastrointestinal discomfort. And my bill is supported by the VFW, by the American Legion, by AMVETS, by the Iraq and Afghanistan Vets of America, and by the 2 principal private organizations associated with burn pits, something called Burn Pits 360, which I believe, Mr. Chairman, was founded by a woman in Texas, and the Sullivan Center, which is here in Northern Virginia. So I think this is a really, really important issue. I think it's certainly an issue that at least our colleagues should have the opportunity to weigh in on, so I hope you rule it in order. Thank you very much.
Ms. Bishop, thank you very much for your testimony today. Appreciate it. The gentleman that's been much discussed today, the gentleman, the chairman of the Scouting Caucus, gentleman, the Eagle Scout from New York, is recognized.
Thank you, Mr. Chairman, and fellow Eagle Scout lifelong member. I'm here today testifying on behalf of a bipartisan amendment number 69, co-sponsored by myself and Democrat House Armed Services member Derek Kilmer of Washington State. The amendment is composed of H.R. 2981, the Transfer Act, Technology and Research Accelerating National Security and Future Economic Resiliency Act. We call it the Transfer Act, along with the manager's amendment, which passed unanimously in the House Science, Space, and Technology Committee markup this past December. My office has worked with the Science Committee to craft this legislation, which addresses what the committee has heard time and again, that there is a valley of death, a place where innovative new ideas die because more work is needed on proof of concept or prototyping. The Transfer Act would accelerate the commercialization of federally funded research and technologies by establishing a grant program as part of the STTR, or Small Business Tech Transfer Program, that would support these proof of concept research and other innovative transfer activities at universities, research institutes, and federal laboratories. The program would help lower the risk of research and development projects in a pre-competitive manner and provide a stronger basis for commercialization and job creation of these research activities by small business. There are no new costs associated with this amendment. The existing STTR program, which provides grants to small businesses who are partnered with a research institution at a level of 0.4% of the extramural research budgets of 5 federal agencies. Give or take, that's about $300 million a year that is awarded through STTR grants. This amendment would take 12.5% of that money, approximately $40 million per year, and designate this to research institutions that would help advance the proof of concept and prototyping. The Department of Defense, which awards more than half of these grants, has the largest of the 5 participating federal agency research budgets, which is why my staffs work closely with the House Armed Services Committee and the DOD in crafting this amendment. We've also worked in conjunction with the House Small Business Committee, where I chair the subcommittee on technology. The Transfer Act has wide support from outside organizations, the Association of American Universities, Tech America, and many more in the scientific and small business community. So I appreciate the time of this committee and hope that you will consider ruling that this bipartisan amendment, the Transfer Act, will be in order. Thank you.
Thank you. Mr. Nolan?
Yes, thank you, Mr. Chairman. I've got a statement here and some supplemental information that, in the interest of time, I won't read. I simply want to say that my amendment would help prevent future waste of taxpayers' money in projects that are going to be Afghanistan. And as you may or may not know, we spent over $100 billion. There's a bipartisan group of us that have been meeting with the Inspector General, and he's got 250 investigators, and quite frankly, he can't find where most of the money has gone, and can't find many of the projects that have been completed. Just one example, the Kajaki Dam, over $300 million has gone into this. 50 million young American men and women lost their lives. For every one that's killed, there's a half a dozen lost an arm or a leg or suffered traumatic brain injuries. And we've got to find a way. We just simply have to find a way to get a handle and get control on this. So what my amendment does is prohibits funds authorized for construction in excess of $500,000 from being expended if the government cannot audit and physically inspect the projects. It does provide a waiver there that if the Defense Department and the agencies involved can show a plan that where they can keep control of these monies and of these funds and submit that plan to the Defense Authorization Committee, they can go forward. But please understand now that the Afghanistan has been certified as the singularly most corrupt nation in the world. It has also been certified as the #1 supplier of heroin to the world, supplying more heroin to the rest of the world than all the other countries in the world combined. It's an incredibly corrupt narco state, and those are just the hard facts. And it breaks your heart to see, you know, what the brave young men and women have done, and to see these funds being absconded by scoundrels. And part of the problem is that much of Afghanistan is a cash basis economy. And I just want to show you, this map shows in the blue here the areas that were controlled by the United States several years ago. The second map shows the very few areas that are being controlled now. So if you have a project in one of those areas, you've got to show up with a truckload full of $100 bills. Well, you can imagine the prospects for corruption on something like that. And, you know, we've all read these reports. Maybe this committee would know better than some of the rest of us. You know, the CIA's dropping off suitcases and duffel bags full of $100 bills. And, yeah. What is the what?
What's the third map?
The third map shows those areas where we actually would have some control and ability to audit the project and inspect the project. And you can see throughout most of the country we have no ability to do that. And they're all cash projects. So I think we control like less than 18% of the country now. So it's a prescription for just a terrible, scandalous waste of money. So my amendment is attempted, doesn't affect existing projects. It affects projects going forward. And if the agency can't certify that they can put in place some ways to audit and inspect the project, then the project shouldn't go forward unless the agency, not the contractor, the agency can show a plan for audit and inspection and submit that to the Armed Forces Committee here in Washington for their examination as well. It's an attempt to try to get a handle on all this terrible, tragic waste of Treasury. It has bipartisan support. There's a group of us that have been working with this on a regular basis, and it won't stop anything, but necessarily, but it will stop it if we can't substantiate that there's a way to audit and a way to inspect where our taxpayers' money is going.
Mr. Donald, thank you very much. Each of you have had a great chance with us today. I'd like to defer now to the committee for any questions they might have. Gentlemen, Mr. Bishop's recognized.
I only have questions for two of you that are here. First of all, Mr. Cleaver, I found this one interesting only because we had a hearing in my subcommittee on this issue. So you worked with Mr. Poe. Oh, was Mr. Poe on this one before? Okay. And so this would make, if I got this right, the Liberty Memorial in Kansas would be the World War I Museum, Kansas City.
Yeah.
World War I Museum and Memorial.
Yes.
And then Pershing Park here in Washington would be the
National World War I Memorial.
World War I Memorial. And an effort to put something on the mall is not part of this effort.
That's right. The National.
We do anything to redesignate what the District of Columbia Memorial. Is there anything in here that would redesignate what the District of Columbia World War I Memorial will be called?
No. No, it does not.
Okay.
No.
Actually, I like the amendment because you take something out of my jurisdiction that I don't have to. Yes, thank you. All right. This is good. Ms. Jenkins, I do have some questions that deal with your bill, especially, you know, when you were at Weber State, you remember Hill Air Force Base down the road. It has a great deal of impact on Hill Air Force Base in my district. So let me just ask a couple of questions, because the comparison in here is the phrase inherently governmental. Do you have a definition of inherently governmental?
Yes, I believe it's in law. And some activities it refers to include the Secret Service, the acquisition workforce, the contract.
What you're starting to quote to me is 2 pages of stuff, because
Right.
there are votes going on. Let's not go through all 2 pages
Right.
of it.
It's defined in law.
However, it is defined in other places in law, and there is also unclearness of what inherently governmental actually does mean. And that's why the military has their own process in going through that procedure. Your amendment would change that. One of the processes in those 2 pages that scares me is because at the end of that process of what is inherently governmental are the words that it may be, what is inherently governmental may be reviewed and modified by the appropriate office of management and budget officials, which means rather than making that decision in DOD where it's appropriate, all of a sudden you make that decision over in the White House, in the executive branch, and that is in the language to which you are referring with what is inherently governmental. It's one of the reasons why this particular amendment was discussed last year under a different sponsor and defeated in the committee, was defeated on the floor, and this year a similar amendment for new constructions was actually passed on a bipartisan vote in the committee. Do you have a definition of what core workload is?
Core workload?
Core workload.
No.
Do you have a definition or understanding of what working capital fund means?
No.
Right. Okay, here's the problem I have with this. There are a couple of things. Number one, you demand a new cost comparison mechanism in Section 2 of your amendment. There is already a cost comparison mechanism in the code, 10 U.S.C. 2463. Why you have an additional cost comparison mechanism is redundant at best and defies understanding of why you would like to do that. But in the other portion in which you're trying to deal with what is inherently governmental, you do not deal with what is the core workload, which becomes extremely important, and also the working capital fund. Working capital fund is the workload that goes to the depots. If, once again, I could give you some advice, if you would carve out the depot work, which comes from working capital fund, it's not appropriated money, and deals with that core workload, then I wouldn't have any problems with the amendment that you presented. But since it confuses those 2 terms, that presents a huge problem for what would be a core workload in a working capital fund, which is what the depots do all the time. When we went through the process through sequestration that dealt with furloughs, one of the problems we had in depots is that they were furloughed, even though they weren't furloughed, they weren't receiving their money from appropriations, they were receiving their money from the working capital fund, and therefore should not have been furloughed in the first place. All these things are mixed up, and this, Mr. Chairman, is one of the reasons why these type of issues need to go through the committee. The standing committee understands these issues, they understand what this process is, they have staff to deal with it. When we try and do an end run around the committee and insert these type of amendments on the floor, we are not dealing with the expertise that's necessary to define what these terms are, and it creates problems. That's why I said we did have a discussion of this in the committee. It was presented. It did have a bipartisan vote that passed that did with these kinds of procedures in the future. What this amendment would do is basically negate most of that work and throw everything into a case of turmoil, because it does not necessarily define what that core workload is. It does not deal with what the 50-50 law, which is on the books, deals with, and it does include a new cost comparison mechanism, and all these definitions can be modified at will by the White House, by the Office of Management and Budget, not through the Department of Defense, which is why I have extreme problems with this particular amendment. And I'm sorry, I will be voting against this amendment as part of the rule, and I can't do anything otherwise. If, once again, you would like to revise this and exempt the depots, I don't have a problem whatsoever, because the depots do all their work through the working capital fund, not through direct appropriations. I'll yield back.
Gentleman yields back his time. Gentleman from Florida is recognized.
The vote, I won't ask any questions, but I do want to thank Ms. Jenkins for joining me and Frederica Wilson in offering up a resolution that some of you supported commemorating the Brown versus Board of Education decision. And while we were unable to get it on the floor for suspension, Ms. Jenkins helped us to get it, a letter that's supported by several members in Congress before the National Historical Museum in Topeka, Kansas. And so I just want to thank her personally and publicly. All right.
Thank you very much. Chair would like to announce to members that we are on what we believe is 2 votes, the first one being done now. I anticipate we will work through that. But if you're a member that's sitting here waiting for the next panel, I would encourage you to go down and vote now and come back immediately as the committee will continue its process. Gentleman from Florida is recognized. Gentleman does not seek time. Gentleman from Orlando, Florida is recognized. Gentleman does not seek time. Okay. Looks like we're done with the panel. Thank you very much. I appreciate it very much. This panel is now excused. We will now convene our next panel, and I know that we have Mr. Larson, that who I was pleased to have join us. I know that the gentleman, Mr. Rohrabacher, is here. The gentleman, Mr. Larson, has been announced. The gentleman, Mr. Lynch, is here. The gentleman, Mr. Mulvaney, is here. And the gentleman, Mr. Cardenas, is here. And so we will move forward with that at this time. Gentlemen, thank you so much for taking time, working us into your agenda for the day. I recognize your time is important, and yet you have taken time to be here, and so we recognize that you are doing so with ideas that represent your district, your party, and yourself, and I'm delighted that you're here. What we're trying to do is follow through, Mr. Rohrabacher, with the process where we're hopeful that each of you will see in that sheet of paper that's ahead of you that designates each of these amendments to the Rules Committee number, so that as you talk about your amendment, you will be able to recognize that off that page. And gentlemen, Mr. Young would be asked to join this panel. We're delighted, Mr. Chairman, that you are here and with us, and the ability that you have to designate what you're doing with that would be appreciated. Mr. Rohrabacher, I'm going to let you go ahead and go first. I would normally go to the gentleman from Alaska first, my dear friend, but I'll let him have time to catch up here. Mr. Chairman, what we're trying to do is to get you to look at that sheet of paper so that you're able to designate your amendment with the Rules Committee number so that we're able to work through that. And I know this will give you a chance to do that. Gentleman from California, Mr. Rohrabacher, is recognized.
Turn on your mic.
Yes, there it is.
Thank you very much.
Thank you, Chairman Sessions, members of the committee, and I appreciate this opportunity to make my case for my proposed amendments to H.R. 4435. My first amendment, number 105, would condition all aid to Pakistan on the release of Dr. Afridi, who is the Pakistani doctor who helped the United States locate, track down, and eliminate Osama bin Laden, the mastermind who helped slaughter 3,000 Americans on 9/11. The role that Dr. Afridi played was, of course, verified publicly by Secretary of Defense Leon Panetta. Leaders of the Pakistan have imprisoned Dr. Afridi since 2011 for helping us bring to justice this murderer. It is shameful that our government continues to subsidize a corrupt and murderous clique that runs Pakistan while they thumb their nose at us by putting this mass murderer, or by putting the man who helped us get this mass murderer in jail. Since 9/11, the United States has given Pakistan over $28 billion in aid. That flow of money should stop until their imprisonment and torture of this hero ceases. That's the First Amendment. Amendment 106 would likewise apply to Pakistan. The amendment would require the Secretary of Defense to certify before we give money to Pakistan that they are not using it as part of this Pakistan's military is using it to murder their own people and repress people minority groups in their own society. Numerous NGOs, as well as our own government, have written reports about the abysmal human rights situation in Pakistan. Perhaps no group is more targeted than the Baluch community. While they aspire to express their legitimate political desires, the government of Pakistan uses its internal security forces and weapons and from the United States of America to imprison and kill Baluch activists. Some of them simply disappear. Repression of minority groups is systematic. Their targets include Christians, Ahmadists, Shia Muslims, and Sindhis as well. While money is fungible, every dollar we give Pakistan enables that government to abuse the rights of its people. My amendment number 107 is a sense of Congress that Dr. Afridi, who I've just mentioned before, is an international hero, certainly is an American hero, and should be released from prison, from his plight in the dungeon immediately. There is no legitimate reasons for his continued imprisonment. The House should be on record for that, and in fact, the House should have been on record a long time ago demanding this man's release. Amendment number 108 authorizes no less than $5 million to carry out the research, development, and test and evaluation of an aerial wildfire fighting container delivery system that requires that my amendment requires that these activities be carried out using a competitive procedure. As my home state of California and others continue to be ravaged by wildfires, we must give business opportunities to compete for funds and, where we can, provide the equipment of our military to help fight these wildfires in a very innovative way, and that's what this amendment would do. Amendment 109 directs the Secretary of Defense to carry out a study on impediments to deploying advanced small modular nuclear reactors on military installations and naval vessels. In particular, it asks them to look at the non-light water reactors, which is of course, the light water reactors are a 50 to 60-year-old technology already in common use around the world today. This technology that we're talking about has potential to provide clean and safe and reliable energy to military installations throughout our country, and just as importantly, may allow them to disconnect themselves directly and entirely from the rest of the grid, understanding that the impediments to deploying these type of advanced and safe nuclear reactors will help us in Congress decide, if we can have this type of a study, decide whether or not if we should be moving forward in this direction. Amendment number 110 is a sense of Congress that the United States should promote greater cooperation, and I would emphasize that, to promote greater cooperation with our allies in Asia, especially regarding to maritime and naval affairs. We're talking about Japan, South Korea, India, the Philippines, and other democratic nations in Asia who all share a common problem, and that is the threat of aggression by the Chinese Communist Party and the People's Republic of China. This is especially true in the South China Sea, where we need to make sure that Congress is giving the threat posed by the Chinese Communist Party and the People's Republic of China the attention it deserves, and this amendment would be a way of doing that. And finally, amendment number 111 is a sense of Congress regarding excess defense articles. This military gear that we're talking about, we have no longer use for, but can still be of great use for other nations that are facing the threat of violent radical Islam. Uzbekistan and India are both countries that share our strategic interest, and like us, they face a threat of violent Islamicism. We need to help them resist that threat by encouraging them to take part in existing programs that make excess U.S. defense articles available for sale or transfer to these other nations. So thank you for giving me this opportunity to testify, and I think they're worthwhile for consideration, and I appreciate your attention. I yield back.
Appreciate the gentleman very much for being here today and for his time that he's spending with the committee. And I'd like to ask the gentleman, as long as he's voted, would stick around for the committee to offer any opportunity. You know what? I think we're still on the first vote. Is that a correct? That's a correct statement so far. Good. Good. The gentleman from Alaska, the dear friend of this committee, former chairman of the Transportation Committee, Natural Resources Committee. The gentleman is recognized.
Thank you, Mr. Chairman, member of the committees. I have 3 short amendments. I will spend most of my time on a very short period of time on Amendment 115. This amendment corrects language that the Senate airdropped into 2010 National Defense Act conference. As a result of the airdrop language, Native 8A firms were the only group focused to go through a heightened justification and approval process for the sole source contracts. This extra process has significantly and unfairly affected Native contractors. In fact, a recent GAO report showed a 60% decline in revenue from these contracts. This decline has resulted in a loss of jobs, reduced benefits to Native Americans, has led to a large amount of unintended discrimination against the Native community owned by these firms. My amendment does revert the airdrop provision in the question back to the language originally passed in 2010. This new language ensures that all contracting requirements are fair and balanced and do not single out any specific group and apply to all federal contractors who seek sole source contracts. In closing, this is really the 2 finer, less amendments. One is F-35s. Mr. Chairman, Amendment 116. Alaska wants the F-35. Some people don't want it. I just want the Pentagon to make sure that when they consider where to station them, the proximity to the mission, the training capability, and the ability to take and deploy these vessels at the right time, the right place, the quickest possible. Amendment 117, and merely asks the Air Force to conduct a business case analysis to establish the active association with the Alaska National Guard's 168 Air Refueling Wing. The Alaskan Guard estimates that this association could save the Air Force as much as $18 million per year. And none of these really cost any money. In fact, they do something good for my state, and I'm here to represent my state. And with that, Mr. Chairman, I do not have any other thing. Gladly answer questions.
Thank you very much. I appreciate very, very much you taking time to be with us today and representing the great people of Alaska. Ms. Larson, welcome to the Rules Committee. I'm delighted that you're here. By the way, your spontaneous address of a bunch of Texans last year still widely discussed across the state of Texas. And I appreciate you taking time as you were.
I expect a draft for president anytime soon after that very enthusiastic speech that I gave.
Well, just do remember this: we're on the backside of those primaries, so we're delighted the gentleman's here. Gentleman's recognized.
Well, I thank the distinguished chairman and members, my colleagues on both sides, and my dear friend Judge Hastings. And the forbearance that the committee has, and especially the amount of time that you give to the members. I'm here on behalf of Tom Rooney and myself. We have a nonpartisan amendment that we hope will be embraced en bloc, but we wanted, because so many on this committee, including yourself, Mr. Chairman, share a deep and abiding concern about those who have disabilities, and especially those men and women who are serving in our armed service and find ourselves in this situation. I'll cut right to the chase. A young woman from my district got up at a meeting I was at for autism and said, talked about the case of not one, but 2 of her children who are in the need of a specific remedy called applied behavioral analysis. This is a remedy that has been approved by OPM as medically necessary and insurable that all other federal employees are entitled to, save for those that are in our armed services, irony of all irony. So here's a person in the field, a woman at home with children, and unable to get the benefits while her husband is sacrificing on our behalf. I know this tears at the heartstring of everybody in this committee, and this is, I said, nonpartisan. This is entirely moral and about the right thing. I want to credit my colleague Tom Rooney, who on the floor 2 years ago, and committees are under a lot of pressure, especially when the green shades come out and everybody's talking about what we have to do with respect to offsets and everything else. These are all workable issues, and men of great determination and will can make this happen. We've provided for those within the bill. But I think it was Tom Rooney that said it best. He said, Buck, looking, speaking to our chairman of the committee, my brother's over in Afghanistan. My sister-in-law's home. They have a son with autism. They need this. And that's what the bottom line is. And it's not only autism, but it's other disabilities. And it's cost-effective in the long run. And all of you know and have been through this process enough to understand that sometimes presented with the short-term goals that we have to face and then presented with a 10-year offset, the numbers can look big. But there is nothing here that we can't get through. And the applied behavioral analysis actually reduce costs over time. But more importantly than that, and I know you all know this, is the relief that we provide to those men and women who serve our country so gallantly, and especially their spouses who are left at home with the problems left on their doorstep. We're a better nation than that. That's why we voted this en bloc before. And I'm confident, knowing the distinguished members of this committee, I hope you'll take our consideration to do that as well. Thank you. It's, for the record, amendment number 143, Mr. Chairman, and I thank you.
Thank you very much, Mr. Larson. The gentleman from South Carolina, Mr. Mulvaney. Mr. Mulvaney, thank you very much. I know you've taken a long bit of your afternoon. And
happy to do it. You know, I
so
enjoy
the gentleman's
the process.
recognized for 30 seconds.
You know, I enjoy the process.
I do need to make sure that members, if you have not voted, you ought to go do that so that we will continue and we'll get to the next panel. The gentleman is recognized for his time.
Two amendments, Mr. Chairman. Number 269. Number 269 deals with the design build process for small business contracting with the Department of Defense, something that we have worked on in the Small Business Committee and on the subcommittee that I chaired in the last Congress, and the work of which has been continued this Congress under Subcommittee Chairman Tom Rice. Simply streamlines the process so that small businesses have more of an opportunity to bid on government contracts. The second amendment is number 307, which seeks to define the nature of the overseas contingency operations budget versus the base budget. To avoid these conversations we seem to have every single year of what should be in the base budget versus what should be in OCO, and try and bring some clarity to that issue on a permanent basis. I hope that both of them will be ruled in order. I do understand from my staff that number 307 regarding the OCO definitions has the approval of the committee and would be considered en banc if I would so consider, and I would be interested in doing that. With that, I yield back. Thank you.
Thank you. Mr. Cardenas, you recognize.
Thank you very much, Mr. Chairman. Appreciate the opportunity to present before this committee. My amendment ensures that we're prepared to face the cyber challenges of today and tomorrow by expanding our understanding of the economic impact of cyber intrusions and identifying ways we can protect our intellectual property. My amendment also ensures that we are effectively training, recruiting, and managing our cyber workforce. My amendment, Amendment 271, has been revised. My revised amendment would authorize the Secretary of Defense, in consultation with the Administrator of the Small Business Administration, to promote an outreach and education program to educate small businesses on cyber threats, to develop plans to protect intellectual property and their networks. Let's look at the news as recently as this morning. The New York Times reported that 4 companies lost confidential files, technological secrets, and records, and other data. All 4 had something in common besides data theft. Each was in the middle of pushing back against China's unfair trade policies by seeking help from the World Trade Organization and our Department of Commerce. The Justice Department has indicted 5 Chinese military personnel of the cyber attacks. Companies in the United States, whether they are in trade disputes with China or not, are in fact in danger. These are military hackers sponsored by the Chinese government. Our government must respond to help protect our business interests here in America and throughout the world. We need to identify concrete steps that we can take to ensure that we are doing everything that is possible to protect our intellectual property. Protecting our intellectual property is an economic matter, as it is one of national security as well. According to a report by National Cybersecurity Alliance and Symantec, small businesses are not prepared to defend against cyber attacks, even though nearly half of all targeted cyber attacks are aimed at companies with fewer than 500 employees. It's imperative that we educate and work with the small businesses, like the many in my district, that contract with the Department of Defense to ensure that they have sound plans to defend their networks and intellectual property. Small businesses are increasingly becoming the target of cyber criminals as large companies increase their protections, so we need to arm the small businesses with the information and technological assistance they need to create effective plans to thwart these attacks and intrusions. This is a common sense amendment that addresses issues that are critical to ensuring the security of our cyberspace and our economic well-being now and in the future. I urge the Rules Committee to find these rules, my amendment in order. Thank you very much, Mr. Chairman.
Thank you for appearing. Mr. Lynch, you're recognized.
Thank you. To you, Mr. Chairman, and the members of the committee, I appreciate you considering the Lynch-Bustani Amendment number 48 to the 2015 National Defense Authorization Act. This amendment is very simple. It would attach the text of my bill, H.R. 2185, the Veterans Day Moment of Silence Act, to the current bill. It calls for 2 minutes of silence each Veterans Day when all Americans can come together to honor our veterans, past and present. It's as simple as that. I want to thank my friend and colleague, Mr. Bustani, this amendment, for co-sponsoring this amendment, as well as the Benditz family in my district who first approached me with the request for a national moment of silence to honor our veterans. I thank the Rules Committee for the time and the opportunity to speak on this amendment, and I hope you'll rule it in order, and also I ask that all points of order that may lie against it be waived. Thank you. I yield back.
Madam Vice Chair, would you seek recognition?
No, sir.
Mr. McGovern?
You have no questions.
No questions. Okay. Thank you all for appearing. We appreciate it. You're excused. So panel number 7 is Mr. Kading, gentleman from Massachusetts, and Ms. Jackson Lee from Texas. Y'all find a seat. Thank you both for appearing. Ms. Jackson Lee, you're recognized.
Let me thank the Rules Committee members, and might I say that I'm very saddened to hear the loss Mrs. Slaughter has experienced today. I have 3 amendments. I'd like to start first with amendment number 65 that is jointly co-sponsored by myself, Congresswoman Barbara Lee, Congresswoman Frederica Wilson, on the Hokabaran and the tragedy of the missing girls. I spoke with Secretary Hagel today on the work that he has been doing on the assets that have been utilized to help in this now regional problem. 2 meetings today, just a brief meeting with him, and share these thoughts, and then a meeting with about 12 different ambassadors from Africa who mentioned that this is a regional problem. And so my amendment is simple. It requires that we, the Congress, have a report to address the issue of the nature and extent of the crimes against humanity. It will allow the Defense Department to also assess the regional impact and the impact on the African Command, and it will be an informational roadmap that will help us begin to look to, if you will, face this horrible, thuggish terrorist group, Boko Haram, and the impact that it has had in Africa. I will yield for a moment, if I might, I'll finish my other amendments, if I might. Ms. Lee is here to speak on the amendment as well. Would the chair prefer me to just speak about my other two amendments and then yield to Ms. Lee?
Ms. Lee, you're just here on this one amendment. Then you're recognized.
Thank you, Madam.
So let me thank Congresswoman Jackson Lee for offering this amendment, and I hope the committee will make this amendment in order. This amendment, she just explained, but I think what I want to emphasize is the fact that now more than 4,400 men, women, and children have been slaughtered by Boko Haram. And it's about time that the United States get on record condemning this ongoing violence and the systematic human rights violations in a way that this amendment will allow. It's really tragic that we haven't had a focus on what is taking place in Nigeria, that it took the tragic kidnapping of so many young girls to call our attention to this, but I'm really pleased that Congresswoman Jackson Lee continues every step of the way to remind us that we have to insist that the United States be engaged with this and insist that the government of Nigeria, as well as the UN, the African Union, the entire country, the entire world come together to really make sure that the civilized world stands with the people, in solidarity with the people of Nigeria. And so now is the moment to get this passed. I hope we do it in a bipartisan way, and hopefully this will signal to Boko Haram that the United States of America, the Congress and the administration wants to say in no uncertain terms that we first condemn these crimes against humanity which have been perpetrated over the years, but secondly, we want our girls back, and we want them back right away. So thank you very much again, and thank you, Congresswoman Jackson Lee, for this amendment.
Thank you for appearing now. Gentlelady from Texas recognized on her other amendments.
Let me thank the gentlelady both for her history in this area and for coming and supporting as a co-sponsor along with Frederica Wilson. Let me just finish on this amendment, Mr. Chair, and just simply say this is not boots on the ground. Many of us know this is defense authorization. There is an African command, and I think it will be very helpful for the Congress to be knowledgeable about the collaborative efforts that have been made, the training efforts that may be made to deal with this question regionally. So I would ask my colleagues to support this amendment. I think it is an effective informational tool and statement, as my colleague has said, in something that has been going on for years. But as I heard the ambassadors say today in the meeting that I was in, how pleased they were that the United States is making this stand, this sort of public stand, on this growing, if you will, plague on the regional areas, Chad, Niger, Cameroon, Nigeria, and other places. So I thank you very much. I thank you for assisting me in this. My other amendment deals with the issue of contractors who are utilized for the gathering of intelligence and or for intelligence matters. And it's a simple amendment. The Secretary of Defense has been modified. It's modified number 186. The Secretary of Defense.
Ms. Jackson Lee, could you give the number?
It's a modified number 186, and it's been resubmitted, and I believe that we've been engaging with the committee. It directs the Secretary of Defense to conduct a study to ascertain the extent to which civilian contractors are used in the conduct of intelligence activities and the type of information to which such contractors are exposed or have access to. We have worked together with the Intelligence Committee. We're producing a bill that deals with megadata. This is also working together with those who collect intelligence, in this instance, the Defense Department. This is not going over Mr. Snowden, but it is a reflection that he was an employee of a private contractor. I believe it's crucial for this Congress to have information about the conduct of those contractors in a way that makes it easier for us to find the construct that will make this work, protecting national security and, of course, utilizing private contractors who maybe have sophisticated technology that is needed. So this is a simple amendment, gives us information, and hopefully that we can provide the guidance that is necessary to avoid some of the mistakes that have been made previously. This final amendment deals with post-traumatic stress disorder. I opened and helped open a post-traumatic stress disorder center in my district. collaborating with the late Congressman Murtha. This is an amendment that was accepted by the Defense Authorization last year. It is amendment number 68, Mr. Chairman. It deals with PTS funding for increasing it by $5 million. It reflects on what PTSD is and gives the extra training. It acknowledges that sometimes it is a hidden disease. If you see a suicide bomb, an IED, or an insurgent obliterate your comrade, you're not injured, but you see that occurring, that may have a devastating impact. And so it is important that as American soldiers, we realize that they are trained to suppress their agonizing grief, and that PTSD is not always conspicuous even to the soldier. And so I would ask my colleagues to support this, provides extra resources, extra staffing, and certainly our soldiers deserve it. I finally will say to you that last month in April, I, for the second time, went to my home state, Fort Hood, for a tragedy that occurred on those grounds. This particular gunman, though it is not finally determined, confronted mental health issues, and he killed 4 persons and injured 16. So I'd ask my colleagues to consider the Jackson-Lee Amendment number 68, the Jackson-Lee Amendment as modified number 186, and the Jackson-Lee Amendment number 65, supported by Congresswoman Lee and Congresswoman Wilson. With that, I yield back.
Mr. Huizenga, do you want to join this panel? You can. Come on up. Mr. Keating, you're recognized on your amendment.
Well, thank you, Mr. Chairman. I come before you to testify on amendment number 293, dealing with Gold Star parents. I think all of us have had the honor to talk to Gold Star parents and suffered the tragedy in our own districts that made them Gold Star parents. My own grandparents were Gold Star parents. And I think we all have said to them at one time or another, if there's anything we could ever do in any way to be of help, we'll attempt to do that. And that's why I'm here. I had Gold Star parents in my district that came to me with some difficulties that they had. They center around some of the great business opportunities where kind businesses are admirably allowing discounts, and they told me the uneasiness they have sometimes. There's no, in many instances, identification. They have to explain. They're looking for verification. It's a difficult situation, and many of them just say, I'd rather not do that, as well-intended as that was, because it's painful and difficult for us to do it. This provides an identification card that's in place for them. Also, they've talked to me about the fact that when their sons or daughters were alive, they had the occasion to go to the commissaries in the installations and use those commissaries, but now they can't. And they mentioned, is there something that can be done so that they can continue to do that, something they shared as an experience with their son or daughter. This would do that as well. There's already a pilot program in place with the Army, so this is not cutting any new turf. This pilot program would have an identification card for those people, allows them on the Army installations, the Army bases, but it's a pilot program and it's Army. What we're seeking to do in this is to make it permanent through statute and to expand it to the other military bases, the other branches of the military. We still leave DOD the authority to look at the backgrounds and do the backgrounds any way they want to do. We don't want to touch that. We made a point of keeping all the language the same that's there in the code, so we're not tinkering with that. It's pretty straightforward. One of the things I did say to the families was, I'm going to have to check to see if this costs money. As much as we want to do it, we have to do that with everything today. So CBO, I went to them, they scored it, there's no cost to this, which makes sense because the overhead is the same in the commissaries. The food for everyone is at cost, so there's no cost to this whatsoever. But it's something they asked to me, following up on my offer to do that, and something I endorsed and think would be helpful. There's 57,000 families, I think, that would be affected by this at no cost. I hope that you could rule this amendment in order, and I thank you for your time.
Mr. Huizenga, you're recognized.
Thank you, Mr. Chairman. I appreciate the opportunity to come before this committee and discuss my amendment, amendment number 231 to H.R. 4435. The amendment that Representatives Mulvaney, Rokita, and I place before you today is simple, yet it's an important step in leveling the field for the private sector, particularly small businesses, when it comes to equally competing for the Department of Defense contracts against the federal prison industries, also known as FPI, or their corporate name of Unicor. Currently, the Department of Defense and federal departments and agencies, quote, shall purchase prison-made products that meet their requirements and may be available, that is under statute now, through a catalog of products and services which FPI offers for sale. What happens is that Unicor will come in and say, sorry about whatever contract you may have, producing gloves or a service or whatever else. They go in and say, under the law, you must take our product. And suddenly the private sector is shoved out the door. Amendment number 231 repeals this mandatory purchasing requirement by striking shall purchase and replacing that phrase with may purchase. So in other words, we are not eliminating Unicor's opportunity to go in and bid for this, but they just cannot have the mandatory requirement that their contract be taken. Competition with the private sector by FPI is an issue that is important to the nation and near and dear to me in the 2nd District. Back when I was the district director for my predecessor, Congressman Pete Hoekstra, there was a new Social Security Administration office that was being opened in Holland, Michigan. And literally this was a stone's throw away from one of the 3 largest office furniture makers in the world, Hayworth Corporation. We're home to a number of others. In fact, my district has Hayworth, Steelcase, and Herman Miller, the 3 largest, but a number of other smaller ones as well, Trenway. Despite all of this, the Social Security Administration was forced to take prison-built furniture manufactured by FPI and instead of these local manufacturers. In fact, the private companies in the district never even had a chance to bid on this contract or compete for it and compete for that. To add insult to injury, they were late in opening the office because Unicor was late in delivering the furniture when they literally could have loaded up a truck about a half a mile away and driven it over. FPI impacts communities across America in a similar fashion. Businessmen and Representative Rokita's district recently shared a story of losing a Department of Defense contract to FPI. The DOD's request for quotation was an item that the business had produced for 25 years, and the company's price was within 1% of the price that FPI won the contract with, or took the contract with, I should say, even without consideration for taxes, wages, and other costs that burden non-governmental entities. Private businesses compete very well with FPI. However, FPI will automatically be awarded these contracts without open competitive bidding, so as long as they sell the items at a price close to the DOD's expected cost. Federal Prison Industries is not an insignificant operation either. It occupies more than 4 million square feet of manufacturing and service space. This bureaucratically run corporation competes with private sector job creators in over 300 individual products and services. 300 products and services. It is comprised of 5 business segments, including clothing and textiles, electronics, office furniture, recycling, and services, which include call centers and document conversion. It was this issue that brought together some rather strange friends together with my former predecessor, Pete Hoekstra, and Barney Frank, the former chairman of Financial Services, when his district was impacted directly by this as well. In fact, within a few hours' drive of this committee hearing today, FPI is producing awards and plaques and even clothing for our members of the armed services, with labor being paid 23 cents all the way up to $1.15 per hour. As you can imagine, the uproar from the public if we were importing goods manufactured by prison labor in China or in any other country. No wonder our American-grown companies have difficulty competing against this Goliath government-owned corporation. Concerning the abnormally low wages paid to laborers, it's not even required to pay the minimum wage of $7.25. Additionally, the private sector is required to pay the prevailing wage under Davis-Bacon or the Service Contract Act. In addition to the low wages, FPI does not have to pay employees Social Security, nor does it have to pay the employer's side or share of that. It does not pay unemployment compensation or workers' compensation insurance. It is exempt from all federal, state, and local income taxes, gross receipts taxes, excise taxes, and sales tax. It's not subject to the Federal Trade Commission oversight, Securities and Exchange Commission oversight, or the Department of Justice oversight. FPI does not pay fair market value, or in some cases, pay for utilities at all. It's exempt from the standards, inspections, and fines of various local, state, and federal enforcements. And I can go on, but while Congress has attempted to create a level playing field on several occasions, Unicor has continued to maintain unfair access to these federal contracts. So with that, I think we could continue to move on, but this is, at its core, all we are asking for is the opportunity for the private sector to compete so that the federal government, through Unicor and through the federal prisons, cannot come in, use federal prison labor that is underpaid, that doesn't have to adhere to any of the rules and norms that anyone else in the private sector would have to do, and it allows them to allows the private sector to then compete on a fair playing field. It does not exclude Unicor's ability to bid. It just says that they will not have the shall issue or shall take part of their contract. With that, I yield back. Thank you.
Okay, Dr. Fleming, would you like to join this panel and go ahead and make your presentation? If so, yes. I think, okay, well, Dr. Fleming, if you can summarize what you have, we'll get through this pretty quick. How about that? Yeah, you're recognized.
Chairman, I'm concerned about the President's new executive order that he recently signed raising the minimum wage for federal contract workers. It's actually having a direct effect on veterans. Certainly in my...
I'm just thinking about this. Let me hang on just a second. Does anyone have a question of the gentle lady from Texas? Okay, you're excused. Well, I'm going to... She just has something she's got to go to, so I'll excuse her, and then you're recognized to continue.
Thank you. Okay, sure. As a result of the President raising minimum wage on federal contractors, like many things, there can be unintended consequences. Under the executive order, nursing home facilities that have contracts with the VA must now raise the minimum wage for their workers. And as you know, in a nursing home environment, you can't just simply assign one or two employees to one patient and raise their wage to meet that standard. You have to literally raise all the wages in that nursing home environment. Nursing homes operate on a very, very slim margin. So a 30-40% increase in minimum wage has a huge impact throughout, even involving employees who are not directly taking care of those VA patients. As a result of that, in my district, and I'm hearing word from other places too, Illinois and Colorado, that VA patients have been excused from certain nursing home situations. In one case I know of, was sent back home for a relative to take care. And so I'm sure this was not intended by the President, but indeed it's having a direct impact. My amendment would exempt nursing home facilities that have contracts with the VA from the President's new wage rate determinations. The new wage requirements would make these VA contracts unaffordable in a nursing home facility in my district, which I already went through. This is leaving veterans in some cases in precarious situations. There are at least 36 nursing home facilities in the state of Louisiana that have contracts with the VA to provide long-term care for veterans. Nationwide, there are 2,346 nursing homes that have such contracts. As nursing home facilities across the country come to discover the increased labor costs that are coming with the renewal of their contracts, I'm concerned that many veterans will be in the same situation as the ones in my district. So as you see, this is a rolling problem. It's small now, but over the next year, as contracts expire, it will be a growing problem. So I encourage that you maintain in order this amendment to be so that the, veterans, both currently and in the coming year or so, will not lose that important place that they have in nursing homes.
And VA homes are not an option because they're mostly filled. At least in my district they are. That would be a great place to move them, but in most cases they're completely filled, and in some cases, as I say, they're being forced to return home, or in perhaps other situations that maybe are less favorable. So that's really the extent of my amendment, is it would create an exemption for VA contracts.
Okay. Madam Vice Chair, do you seek recognition? No, sir. I have no questions. No one else? Thank you all for appearing today, and appreciate it. You're dismissed. Mr. McGovern, would you like to explain your amendment?
A long time, and I think Mr. Jones spoke in favor of my amendment. Basically, that it basically says that if the president wants to keep us in Afghanistan beyond his stated pledge of getting us out of there by 2014, then Congress ought to vote. We had a sense of the Congress resolution that passed overwhelmingly last year, saying that members of Congress of both parties wanted that. This would actually give us that opportunity. And so I'd like to ask unanimous consent that my testimony in support of amendment number 112 be put part of the record.
Without objection.
I just had one other thing. I think, given the fact that we're still at war, we ought to make sure we have ample time to debate Afghanistan. I would request that we give this ample time. And in addition, Mr. Chairman, I'd like to ask unanimous consent to insert in the record the statements by Juan Vargas and Paul Tonko in support of their amendments.
Without objection.
I yield back my time.
Congressman Webster, thank you very much for ending the hearing. This now closes the hearing portion of the National Defense Authorization Bill. We also have a consideration of H.R. 3361, the USA Freedom Act, and we're delighted to have the chairman of the Judiciary Committee for that testimony therein, and the gentleman from Virginia is recognized. And Mr. Chairman, we're delighted that you're here, and anything you have in writing will be entered into the record at your subject. Jones recognized.
Well, thank you very much, Mr. Chairman. I want to thank all the members of the committee. And the bill before you is the result of months of hard work by members of the Judiciary Committee and staff on both sides of the aisle. And I'd like to commend Chairman Sensenbrenner, Ranking Member Conyers, Mr. Nadler, and Mr. Scott for their tireless efforts in working with me to craft this important piece of legislation. The Judiciary Committee worked with members of other committees, civil liberties groups, and the administration in creating a bill that effectively protects our national security and American civil liberties. The USA Freedom Act passed the Judiciary Committee by a vote of 32-0 and passed the House Intelligence Committee as well. The USA Freedom Act makes important reforms to laws governing the collection of records sought in national security investigations. It increases protections for American civil liberties and privacy while preserving the operational capabilities of our intelligence agencies. This bill ends the bulk collection of records under Section 215 of the Patriot Act, the FISA, Pen Register, and Trap and Trace statutes, and the National Security Letter statutes. It goes further than the President's plan in that it prohibits the bulk collection of all records, not just telephone records. Meanwhile, the USA Freedom Act preserves the government's traditional operational capabilities under these authorities. The government must now base its requests for records under these authorities on a specific selection term defined to preclude indiscriminate bulk record collection. This bill creates a new authority for the ongoing collection of call detail records that is based on the President's March proposal. The government is required to obtain a court order on a case-by-case basis when it seeks call detail records in an international terrorism investigation and leaves records in the hands of providers. The bill also permits the appointment of an amicus curiae within the FISA court to advise the court on a variety of issues including privacy and civil liberties, intelligence, and telecommunications. To increase transparency, the USA Freedom Act permits tech companies to publicly report the numbers of intelligence orders they receive from the FISA court. In addition, the bill contains a variety of expanded or new public reporting requirements and reports to Congress. This bill reaffirms our commitment to our nation's security while reaffirming the constitutional values that make America unique in the world. And I urge you to support this important legislation and allow for its expeditious consideration. Thank you, and I welcome your questions.
Mr. Chairman, thank you very much for being here. I'd like to, if I can, what I would say, tee up this effort. I believe what you're speaking about today and have provided information about is this is a lot of work that Congress has placed in negotiation with the administration through a number of intelligence agencies, the Department of Justice, and others, including the military, on the collection of data as it relates to phone calls. And that today the United States is engaged in and has engaged in the gathering of data, bulk data collection. And that this issue over the last years, short-term years, meaning probably 3 years, has become a subject of questions and information and inquiries related to the administration and intelligence agencies and the collection of data. This that you're bringing forth today appears to be an effort on a bipartisan basis by the United States House of Representatives or the United States Senate. I'll let you respond to that. In reference to that collection of data in a specific way, it is important to note that before the gentleman came here, there were a number of questions that were presented and posed to him by some of the members of the Rules Committee. If at any point you would like those discussions, or Judge Hastings, that the gentleman is available to do that. We're not trying to in any way move a bill that is not very well vetted and understood by the people, the members of the committee on a bipartisan basis, that they can explain themselves, they have a detailed understanding. And I have, in my time this afternoon, become more familiar with this, see the concepts, the understanding, and I am supportive. I might be one of the members, among others, that has in fact been questioning myself and what I think about the collection of data from a perspective of not just a member of Congress, not just as an individual, but also one of the duties and obligations as a member of Congress to effectively be sure that our law enforcement and intelligence agencies have the information necessary for them to protect this great nation and its people from not only an attack, but also the constitutional liberties which are outlined. And, Mr. Chairman, I want you just to come back and offer me the same, yes, that's what this is about, that you have worked diligently, that you are aware of the issues that are leading edge surrounding this. I don't think you have to go through all those issues, but you know, some way that's a nice chat with the committee, pending our chance to not just become familiar with this, but to know that the correct work is being done. And then lastly, whether this is a Senate agreement also.
Well, thank you, Mr. Chairman. You have summarized the circumstances very well. This has been going on for about a year since revelations came about as a result of massive theft of millions of documents by Edward Snowden. I am not an enthusiast for what he did, but in the process, certain things were revealed that became apparent to a number of members of Congress were, in our opinion, contrary to what Section 215 allows for. So that became the subject of a great debate and further discussions and revelations through the news media over the last year. In response to that, Congressman Jim Sensenbrenner and Congressman John Conyers introduced legislation, the USA Freedom Act, a similar bill was introduced in the United States Senate, to your question. The Intelligence Committee, which obviously also has a keen interest in this issue and how intelligence is gathered, did their own work. The Judiciary Committee did a tremendous amount of work as well, with both public hearings and closed hearings due to the sensitive nature of a number of the issues related to this. The committees have, in the last several months, had many discussions. Individual members have had many discussions, and then starting a few weeks ago, things started coming together in a very bipartisan and by committee, if that's such a word, way, to work out how this could maximize the protection of American civil liberties and maximize the ability of our intelligence organizations to do their jobs, but without something that we don't think was contemplated by the law, and that is the indiscriminate bulk data collection that was taking place, in which this bill very clearly prohibits moving forward. The Senate key senators have said good things about this product in the House, but the Senate will act on its own. I'm not aware of any consensus there. But we have worked closely with the chairman of the Senate Judiciary Committee. We have worked closely with the White House and this administration and the intelligence gathering organizations, and we also have worked with organizations with a completely different point of view, like the American Civil Liberties Union, the Electronic Frontier Foundation, and so on. And while certainly not everybody agrees with everything that is in this, I think this is a major step forward and a major accomplishment that's reflected by the fact that the bill not only passed the Judiciary Committee in a completely bipartisan 32-0 vote, but also then was passed through the House Intelligence Committee without any further changes. So there have been further negotiations regarding some of the finer points of this as we have moved to the Rules Committee, and that is the state of play as it arrives here right now.
Mr. Chairman, I'd like to ask one more question, if I can, and that is that you know that I receive regular feedback and discussions with my father, former director of the FBI and federal district judge of the Western District of Texas. Was the federal judiciary consulted through this process up to and including the FISA court and the judicial conference, to where they were able to provide feedback? In other words, we have not written a law that they could not be a part of understanding they would be included.
Early on in this process, I actually went over to the FISA court and met with the chief judge and clerks and other judges in the process, and those discussions, I can assure you, have continued on, and they have had input into this process as well.
Good. I appreciate your help. I want to thank the gentleman for making himself available not only to the committee members, but also for his great work. I will be in support of this. It is my idea that you have said the key words, and that is that we believe we're allowing the intelligence and law enforcement officials of this country to do their job, but that the balance will come with lack of moving forward without this huge bundling of data collection.
Thank you, Mr. Chairman. And with increased transparency, obviously in a world where we're trying to stop horrible things from happening in the United States, there cannot be the kind of transparency people would like in other areas. This is intelligence gathering. This is dealing with serious threats to our country. But increased transparency in how the decisions are made, and with, I believe, increased protection of American civil liberties.
Well, perhaps more importantly, that there's a clear understanding among the three branches of government about the intent of the law and the expectation of performance in that, following the law, that would be expected by the executive branch of government. Thank you very much, Mr. Chairman. Yield to the gentlewoman from North Carolina.
Thank you, Mr. Chairman. I may want to ask the gentleman a question or two later, but I know that Dr. Burgess has some concerns and questions. And since he's always the last one to get asked, I'd like to yield my time to Dr. Burgess if he's prepared. Okay. Okay. All right. Okay. Well, let me just say then to the chairman of the Judiciary Committee that he well knows that I respect his work and his diligence. And while most of us have great concerns about what has happened in this country as it relates to the FISA bill in the past and great concerns about what might happen in terms of any abuse in the future, I want to commend him and the others involved with working so hard to come up with a document, legislation that they hope, and we hope, would solve abuses that have occurred in the past and prevent those from happening in the future. I'm frankly surprised that you and others have been able to work together to come up with a bill to present to us. I was really concerned that we might not ever get to this point again. So I thank you for your efforts.
Well, thank you, Congresswoman Fox. And to Chairman Sessions' point, I think the key to that has been the very close consultation with all of these different parties that I have named, both here in the Congress and those representing both civil liberties concerns and national security concerns. And I think that it is very important that we understand that the very foundation of our country went to this very question. You know, we fought a war of independence. We wrote a very weak federal governing document called the Articles of Confederation. We then came together and agreed that we had to have a stronger government to protect ourselves from outside interests. So we wrote the new United States Constitution. And even before the ink was dry on that, there was an insistence that we also have strong protections of the individual rights and liberties of American citizens. And so close on the heels of that, we got a Bill of Rights. I think that if you follow that model and understand that you can have great protections of civil liberties and the ability to protect ourselves from these kind of threats, people can come together and understand that both of those are of paramount importance and can be protected. And we think that that's what's been accomplished here, and certainly with the wide array of members and views that have been represented in these negotiations. And the people who are participating in this, in addition to myself, you have former Chairman Sensenbrenner and Congressman Randy Forbes, and on the Democratic side of the aisle, former Chairman and now Ranking Member Conyers, as well as very senior members of the committee, Congressman Nadler and Congressman Scott. So we've worked very well. And then we turned around and also said, well, this is obviously of importance to the Intelligence Committee. And Congressman Rogers, Chairman Rogers, and Ranking Member Ruppersberger and others have also had good input into this and been receptive to it. So.
Thank you, Mr. Chairman.
Gentleman yields back time. Gentleman from Massachusetts recognized.
Mr. Chairman, I'd first like to ask unanimous consent to have this statement by Ranking Member Conyers inserted in the record.
Without objection.
And secondly, look, I appreciate you being here. You know, I'm going to review this very carefully. I was one of those who voted against the Patriot Act because I feared the overreach that we have seen in this administration and in the previous administration. That we feared that could potentially occur. And at the time, we were reassured by all the powers that be here, Republicans and Democrats, that there'll be good oversight and don't you worry, and we'll make sure. You know, that's not the intention. And then through leaks to the press, through a whistleblower who exposes things that none of us thought were, you know, even in our worst kind of analysis of the previous law could occur. That you know that basically you know, there was this incredible overreach, and so I'm going to look at it. I'm going to look at. I think it's great that there's a compromise, and there's a lot of diverse people have come together. But, there's some of us who are going to have to look at this really carefully, make up our own minds, because, I think we were misled the first time around. I didn't vote for the bill, but the promises and the reassurances that we were given didn't amount to very much. And I'm not here to defend Mr. Snowden, but I don't know whether we'd be even having a lot of these discussions if it weren't for him and for others who went to the New York Times and other press sources to talk about their concerns about the excesses. So I hope this is as good as you say it is, and I hope that that people who vote for this won't, if we vote for this, we won't regret it. But I got to tell you, I'm going to be very, very careful before I decide how to vote on this. And again, it's not an issue. It's not a Republican Democratic thing, because I had a lot of Democrats that told me don't worry about the Patriot Act, who voted for it as well. It turned out to be, I think, one of the worst things that this institution ever passed in terms of civil liberties. So I appreciate your work. I know Chairman Conyers is a supporter of your effort here, I look forward. I assume this will come up after the DoD authorization bill. Is that so? We'll have a couple of days to be able to review it for those of us who haven't been, on the committee, and appreciate you being here.
And as Chairman Sessions said, if I might add, if you have the desire to speak with individual counsel who have been involved in detail, on both sides of the aisle, by the way, on this. Some of it needs to take place in a SCIF, but we're happy to have discussions with you about those details, because I certainly agree with you that this needs to be examined closely and carefully. I think when you do that, you'll find that this is a great step forward from the standpoint of protecting civil liberties. And I also agree with you that the oversight needs to be ongoing, and it needs to be multi-committee in terms of those who are involved in conducting the oversight.
Because if there was oversight before, it was kept secret from a lot of us up here, because it wasn't until we read it in the newspaper that we even knew there was a problem. Again, at the time of the original debate, some of us raised the prospect that there could be overreach, and we were told, don't worry, the oversight. Well, I don't think the oversight stunk, as far as I can tell. I want to make sure that doesn't happen again. So I appreciate the gentleman's work on this, and we're going to look at this carefully. And I will talk to, if I have questions, I'll talk to the gentleman and to the ranking member, and we'll make sure.
I share your concern. I became chairman shortly before all this blew up, and so I think a lot of members of Congress on both sides of the aisle need to exercise more oversight here. I also think that this bill, in terms of the transparency of how the court works and the injection of an amicus curiae into some of these key decisions to represent interests other than the government's interest, are important additions to this process as well that will help.
Thank you.
I'll just say at the end of the day, though, you got to trust but codify.
Right. I think everybody who's, especially those who were around during the debate on the Patriot Act, ought to take that to heart, because even the author of the bill was surprised at the overreach. And I think when it comes to these kinds of issues, we have to be very, very careful. And I know the gentleman, is aware of that. And again, I appreciate the approach, the bipartisan approach that you have taken, and I will look at this very seriously. Thank you.
Thank you.
It's easy to jump in, and any member could be doing this, but I think this is why we're doing this, is because there was a huge awareness that the law that was passed and what we thought we were doing was not equaling the reality of not only the circumstances of what our intelligence agencies were trying to get at, but also where they were trying to go. And I definitely will tell you it was a mismatch between the three branches of government. So I think Mr. McGovern very accurately stated belief, and you did too, that we've got to make sure we know and constantly stay after this. And I think that's being done vigilantly by members of this body who have expressed desires and been given the authority and responsibility to do that. So I'm delighted that you're here. Thank you very much. Gentleman yields back his time. The gentleman, Mr. Bishop, is recognized. Judge Hastings.
Mr. Goodlatte, thank you very much. Real extraordinary work, in my opinion, that you and our colleagues who worked with you to get to this stage. And I appreciate it. And like Mr. McGovern, I intend to review as much as possible regarding the matter. I do wish to compliment one aspect that I think is really worthwhile, and that is that the alignment of the sunset provisions. I think that is critical. Common sense tells us that this is an area of evolving circumstances that require modification from time to time. And since the sunset takes place in 2017, I think it wise to co-align the sunset provisions. Turning to an area of concern, and I'd be interested to know, was there discussion regarding the appointments to the FISA court? I, for one, I have great confidence in the impartiality or the capability of impartiality of United States Supreme Court justices. But I have an abiding concern for one individual having the power to appoint. And did you all discuss that particular measure when you dealt with the Section 4 reform of the FISA court?
Well, I know there was discussion regarding the method by which the judges are appointed. And as you know, these are Article 3 judges appointed across the country who serve on a rotational basis in the FISA court. It's a unique court and it's a unique experience, but the judges are not unique in that regard. So we believe that the addition of the amicus curiae process and bringing people into the court who do not represent the government's perspective is a helpful way to avoid the problem that you've described.
Well, that's where I was going, was to the amicus provision. Here again, while I agree that the FISA court and the FISA court of review should have, as you have wisely undertaken, the amicus provision, you go on, though, in the language to assert that they appoint 5 persons and then identify the level of experience that should be required, obviously, classified level, top level, would be required in this instance. But then I'm curious, is there, after these 5 individuals are identified, and the novel question that may have given rise to the court determining that there should be amicus, I'm curious as to the rest of their role. Do they brief or argue and brief as the matter is proceeding? And what, if any, tenure exists with reference to those 5? I just raise it for information, not to quarrel. I agree with what you've done, but I'm just curious about that myself as someone that has paid attention to this.
So the answer to your first question is that they will brief, and then if the court wishes to have arguments, they will have the opportunity to do that.
All
And
right.
I would hope that the court would avail itself of that in appropriate circumstances. Your second question.
Tenure.
The tenure. I don't know the answer to that. So the legislation does not specify, and therefore
Yeah.
we think the court would have some discretion in that.
Yeah, and you don't want to have the same 5 people is where I'm coming from. It's difficult enough in this arena, but when it comes to intelligence collection and telecommunications and the experience that's going to be required for the person doing the amicus, I'm always concerned that you will get a handful of people that have this kind of expertise. And after a while, the Stockholm Syndrome can set in. And so I like fresh eyes. I might add, I think that you all have offered up a clear-eyed view of the ongoing concerns that have been expressed by many members and, more importantly, all of America that's paying attention. But toward that end, I just want to share with you just something that I say to people. I no longer make recommendations regarding lawyers because I think it should be prohibited, and it is, and unethical, and it is. But in other days, when people would ask me about lawyers, and they would want to have the most experienced and the person that has the greatest reputation, I would recommend to some people that they get themselves some young lawyers that may not be as experienced as others. And if I could only offer, not as a lawyer, but working here in Washington, when Thurgood Marshall and others were arguing Brown versus the Board of Education, one night at 3 o'clock in the morning, with a lawyer named Frank Reeves and another one named Herbert Reed, I was working with them along with other students at the law school, and I stumbled on a case that became a particularly important one, as it were, in their argument. I only offer that is every now and then a real solid young lawyer should have an opportunity to be amicus as well. They've written actively sometimes on the subject, and that also leads me to hope that in those appointments that people from academia who are less likely to have access to grind that have the experience, I think would be important. But I compliment you on the work, and like Mr. McGovern, I'm going to pay careful attention before I put up a green or a red light. I thank you very much. I yield back, Madam Chair.
Thank you, Mr. Hastings. Mr. Woodall, you're recognized.
Thank you, Madam Chairman. Thank you, Mr. Chairman, for being here. Can I presume anything from your solitude there at the table? This was a lot of hands went into to baking this particular cake. Yet when it comes here to defend the cake, you are a capable but lonely voice there at the table. Is it the late hour, or is there something else to which I should attribute?
I can't speak for the others. I do know that Ranking Member Conyers submitted a statement. For the
gentleman yield.
Happy to yield.
I think Ranking Member Conyers expected to be here. He has a statement in favor of this. So I think the time didn't work out. So.
Yeah, and you may or may not be aware that former Chairman Sensenbrenner, who is the author of the USA of the USA Freedom Act, is in a very difficult situation right now. His wife has very serious illness.
Again, asking you to speak a little outside of your lane, I'm thinking more about my friends on the Intelligence Committee. I could imagine a bill that the Judiciary Committee could produce and the Intelligence Committee could hate. This is, of course, a collaborative product.
I can only tell you that we've worked very closely with Chairman Rogers and Ranking Member Rupersberger and their staffs, and it's an issue where we feel very strongly that a lot more needed to be done following these revelations about protecting civil liberties. But at no point did I or anybody else, to my knowledge, say, well, we should not be cognizant of these very real threats to our national security. So our position has always been throughout the entire process that not only do we want to consult with the members of the Intelligence Committee, but also with the administration and with these government agencies that are tasked with these responsibilities, so that if we were doing something unintentional that impeded their operational capability in some other area to gather information and keep us safe, that we wanted to know about that and to address it in this legislation. So that took a lot of discussion over a long period of time, but then it also came together very well in a rather short period of time. And even after that, we said, well, we need to have those discussions continue. And those discussions have continued right up as this process continues. And to points made by some of the members that there are additional things that people would like to see done. Both oversight has to be conducted, but also it has to be reviewed on a frequent basis. And we should be open to making changes even before it sunsets. And I agree with the gentleman from Florida that it's good that legislation like this has sunset provisions in it so that we're forced to conduct fairly frequent reviews. In fact, I think the fact that the Section 215, that was the center of this controversy, was going to expire next year helped to put some focus on this, because simply expiring is not a good thing, but using the fact that it's going to expire to motivate people to look at this both from a national security standpoint and a civil liberties standpoint helped to bring about the consensus here and I think good legislation here.
Would my colleague yield just very briefly? Chairman Rogers did offer up a letter that's in our package in support of a closed rule, and he indicates in that letter that it's a bipartisan effort. And sometimes I would urge my colleague to watch members on the floor working, and if you want to see two people that have done a lot of work in addition to our presenter here, you should only see Dutch and Mike and how often they consult to have you know that a lot has gone on in that 1 year period of time before we get to this stage.
Yeah, I did watch that partnership, and I appreciate my colleague from Florida mentioning it. And throughout this very difficult time where the American people were struggling with these revelations, I would have characterized the committee's position as this bulk data is only valuable to us if we have access to it immediately. That we have long been able to petition for these call connections, one number at the time, but that's not what that is valuable. What's valuable is having the haystack, not asking for the needle. As I read Section 101 here tonight in the substitute, it appears to me to return us to asking for the haystack, one piece of hay at the time. Am I misunderstanding what folks have told me was our national security concern, or am I misunderstanding the change that is being made here in the
Well, I think that there are careful measures to protect the operational ability of the NSA and other organizations. I think there are enhanced consideration of some of the needs and ability they have to get data and get it quickly. There are emergency provisions in here that deal with that. But you are correct in observing that this does end all government bulk collection of data, and not just the telephone data that has been the subject of the public discussion here, but any others that the government might do or wish to do in the future.
It's very confusing to me as a fellow who's had a voting card for 3 years. I've voted against the business records extension in each of our opportunities to vote on it, but have been told in each situation in no uncertain terms, in the absence of the haystack, America is at risk. It is very difficult to know when we find collaboration of this magnitude, Judiciary Committee, Intelligence Committee, Democrats, Republicans, the Hill, the White House, all in one place, who is it that is keeping the most watchful eye? Because generally, when you find that many folks who can come together on something, folks had to give up a whole lot to end up there.
On both sides.
On both sides. I appreciate your words to Mr. McGovern that there were teams of folks who had been involved intimately in those discussions who could be made available for specific questions over the next few days. And I appreciate your leadership.
At
your being
Chairman
tonight.
Sessions' request, we've already done that for some members this evening. So anybody who wants to avail themselves of that on the committee, we certainly will make the key people available, both in a secure or not as secure setting, depending upon the questions that you want to pose. And just in responding to your questions, I can only be limited in my answer, but I would say to you that there are still many ways that intelligence gathering can take place about the targeted individuals, including testing key selectors, if you will, against a database. It just will not be a database gathered and stored and held by the federal government. They'll have to go with a court order to the appropriate repositories where that data is held now.
I thank the chairman for his not just long and hard work, but vigilance in his role on our behalf. Madam Chair, I yield back.
Thank you very much. Dr. Burgess, you're recognized.
Thank you, Madam Chairman. Chairman, thank you for being here at the late hour. I appreciated your answer to Judge Hastings' questions about the sunset. But can you just walk us through the reauthorization timelines and procedures for this?
Well, the key date is 2017. So I think the point that Judge Hastings was making, that there are other provisions in the Patriot Act, which, by the way, is a very large piece of legislation, covers a lot more than this one provision, and many were very common sense changes that were needed in the ability of law enforcement and intelligence gathering organizations to share information that became apparent following the attacks on September 11, 2001. But the expiration dates now will match up so that the review will be, if you will, more comprehensive when we get to December 31, 2017, because three other provisions in the Patriot Act will match up with the expiration, the sunset provision in this legislation.
Well, and I, at the risk of getting out of my lane and speaking out of school, when we reauthorized this in February of 2011, I mean, it just seemed like there'd been mission creep between the previous reauthorization of the Patriot Act before and then the reauthorization that happened in 2011. I will tell you, I don't feel as if, and it wasn't just the administration, it was members of the Intelligence Committee of both parties, I don't feel that they kept us apprised of the mission creep as it occurred. And I don't think I was the only member who felt that way, that the revelations when they came down last summer
Mr. Burgess, I know you weren't the only member because I share that same concern.
So it was, to say the least, startling when those revelations came down. So what protections now are what is new about this that is going to provide the additional oversight, the additional protections? Again, it's, I'll tell you, I try to go and review everything that is made available to us at the Intelligence Committee, but I don't recall those letters being made available to us in February 2011, or I don't recall being informed that, hey, you need to come down here and read some stuff because business is not as usual anymore. So how do we, what assurance can I have if I vote for this thing that going forward I would be apprised that there were there was new information that I needed to go and make myself aware of?
Well, several things. First of all, there was definitely a difference of opinion about what Section 215 allowed. And that difference of opinion was not widely discussed and shared when we held an oversight hearing on this after these revelations, and I asked the heads of these various intelligence organizations why they had not shared with the Congress, and quite frankly, I think with the American people, their interpretation of what Section 215 allowed them to do. And I also told them that I was quite surprised that it didn't start with the Obama administration, it started in the last Bush administration, that this program had been able to operate without widespread public knowledge of it for several years, and asked them, did they not think that at some point this would be made known to the public? And their response to me was, in my opinion, disappointing. Their response was, well, we tried. And of course, the reason they tried was they didn't want the people that are the targets of this information, people who could be a threat to the United States, to know their methods. However, this is such a massive program and such a massive operation that to think that it wouldn't at some point become public, I thought was extremely short-sighted on their part. But what was really damaging was that it was made public by Edward Snowden and not by the United States government. So if they had a legitimate position to sell, it was lost when they lost the trust of the American people due to the way that they learned about how this all transpired. So the first thing is the law now makes it very clear that what they claimed they had the authority to do, they no longer have the authority to do.
And that's a really key point. If someone wants the bulk data collection to end, then they would have to support this legislation. Otherwise, it does not end for a year, correct?
That's correct. Secondly, this creates greater transparency in the process by which the FISA court makes decisions, not decisions about whether a specific person can be the subject of a request for certain data based on a court order, because obviously if you're trying to stop a terrorist attack, you don't want that specific terrorist to know we're gathering data about them. But in terms of the overall decision-making process of the court and the inclusion of an amicus curiae with a different interest in what they are going to be seeking to protect, and it not only would be related to things like the civil liberties of Americans, which is obviously of paramount importance, but it also would be people with technological skills and understanding of things that would help to aid the court in understanding what an intelligence organization is asking them to approve. They ought to have more expertise in that court to do that. So that's a second level of assurance. But within the Congress itself, I do believe that there is a responsibility beyond just the Intelligence Committee for more oversight. And so it would be my expectation that while I have the honor of serving as chairman of this committee, we will also conduct that type of oversight as well. So and there are probably more things too, but those are three things that come to my mind immediately about things that we need to do to assure that something like this doesn't happen again. But I share your concern that there was mission creep and that it was going on over a period of time, and people were interpreting what they could do in such a way that they didn't need feel a need to defend it publicly, and we want to make sure that that doesn't happen again.
Well, I pray that you're successful in that endeavor. Of course, it was bad enough to have the revelations last summer of Mr. Snowden, but 2 or 3 months before that, we had whether you can call it an intelligence failure, but the Boston bombing occurred, and there were warning signs that were ignored, and you'd think if you're collecting every bit of every information that's coming across the pipe, even in this country, you'd have figured that one out. And I still don't understand, and the explanations that have been given to me by the Department of Homeland Security and Department of Justice really have not been satisfactory. So you had a situation where it didn't thwart the attack, and then you find out after the Snowden revelation that it really is far more than anyone ever thought it was, at least us in the rank and file. I got to tell you, that left us with a pretty unsatisfactory response as far as supporting this type of activity. I do, I thank you for doing this, and I think ending the bulk collection of data is clearly something that has to happen. I share Mr. Woodall's concern that, yeah, if we're dismantling the haystack, it may put us at risk again. But at this point, things have been so damaged. I don't know how you regain the credibility without taking the steps that you're outlining. It's tough that it seems like it's coming at us awfully fast. I have that sense. I know other people on the committee may not agree with that, but I feel like it's coming awfully fast. I hope we have the opportunity to evaluate things. I understand we have a briefing tomorrow morning, so that's great. But I also know we got to end the bulk collection of data, and you have outlined now a path for us to do that. For that, I'm grateful. Thank you, Madam Chairman. I'll yield back.
Thank you, Dr. Burgess. Mr. Chairman, I believe there are no further questions, and you are free to leave.
Thank you, Madam Chairman.
Thank you. Mr. Gohmert, before Mr. Gohmert begins, I would like to, without objection, put a statement in the record from Congressman Steve King concerning H.R. 3361, the USA Freedom Act. You're recognized, Mr. Gohmert, for your presentation. As the chairman would say, feel free to submit your written comments and summarize if at all possible. Thank you very much.
Thank you. I will summarize, but to address a couple of points that have already been made about the bill, it did take a lot of work from a lot of people. I applaud the efforts. I had fresh eyes on the Patriot Act when I came in as a freshman in 2005, and I had two big concerns. One was that Chairman Sensenbrenner did not want any sunsets on the bill. He had been responsible for getting them on the bill initially, and before the markup, 25 minutes of back and forth between the chairman and this freshman, and finally 5 minutes before the hearing, another Republican said, you know what, I really think I'd like to vote for sunsets, and then another, and then another. And that was one of a number of concerns I had. And we saw that without sunsets, we would not have gotten the IG report, I don't believe, that revealed there had been 3,000 or so national security letter violations inappropriately sent out. One of the concerns I saw back then that I kept asking the Bush Justice Department intelligence about is part of Section 215. We were told over and over, look, this is all to do with foreign agents, foreign governments, international terrorism. That's what this is all about. And under 215, I said, but here it says that you can get information for an investigation to obtain, and the numbers aren't here, but it's helpful to use them. Number one, foreign intelligence information not concerning a United States person. Okay, that's fine. Or, disjunctive or two, to protect against international terrorism, or, another disjunctive, three, clandestine intelligence activities. And I said back then, what is clandestine intelligence activities? That could be anything. I'll look it up. Intelligence, if you peep over a fence, if you inquire on the internet, gee, what's this about? What is clandestine intelligence? Because it doesn't say foreign, it doesn't say international. And I was assured over and over, look, you've got bigger fish to fry. Of course foreign applies, because that's what this act is all about, foreign. That's what it's about. And I also noted there are other places in the law that it mentions against international terrorism, another section about pin registers and trap and trace devices. It says to obtain foreign intelligence information not concerning a United States person, or to protect against international terrorism or clandestine intelligence activities. And then in what's required in an application, it says you have to certify that it's to protect against international terrorism or clandestine intelligence activities. And I kept saying, there's no foreign in that clandestine intelligence activities. So let's just insert that. Well, after I won the battle on getting sunsets on at least 206 and 215 back during the extension, I didn't keep pushing that. I took the assurances that foreign had nothing to do with this. But when I brought this up as an amendment in committee, we were told, look, this has been very ticklishly discussed and negotiated behind closed doors. Any change whatsoever, no matter how bipartisan, will mess up our deal. How could a bipartisan amendment mess up a deal? Zoe Lofgren and I don't often agree, but she said, I heard the gentleman, talking about me, in a classified briefing ask for information, and it's never been provided, and I support his amendment. Other Democrats followed suit. Other Republicans followed suit. There was widespread support. The amendment passed. And in fact, Ted Poe told me just downstairs, look, you get your amendment in order. I want to speak on that amendment. That amendment needs to be part of the law. But then we had another amendment come up and then we had to break for votes. And I had another commitment when I got back. The first thing they had done is take up a voice vote to revote my amendment. It was voice voted out, and it was not part of the bill before you tonight. And I'm telling you, the more that people fight to keep out foreign out of this part of the Patriot Act, the more dedicated I am to getting it in. If it pertains to American citizens, then go through the regular criminal law. We have RICO. We've got all kinds of things for dealing with American citizens. This was to deal with international terrorism, even if it's a lone wolf, if there's a connection there. And certainly the Tsarnaevs had that connection. They could have used the foreign connection. It radicalized. The Russians told us that. My amendment just goes through, and everywhere you see clandestine intelligence activities, it adds the words to protect against international terrorism or to protect against clandestine intelligence activities conducted by a foreign power or an agent of a foreign power. If it's an American citizen and they're an agent, then fine. That needs to be in there. That was a gaping hole when it was reapproved back in 05, 06, and it's still a gaping hole. And I plan to keep talking about it, whether my amendment's in there or not. It needs to be fixed. And it was a bipartisan agreement to fix it in committee until the voice vote, first thing after the votes.
Mr.
Thank
Bishop,
you.
do you have any questions? Mr. McGovern.
I don't know. I actually agree with you. But that won't mean much on this committee when it comes to a vote. But look, I mean, I think we've been misled too much on this, and I think I think this is one of these bills where you need to dot the I's and cross the T's, because if you don't, you may be in trouble. But in any event, I appreciate your point.
Thank you, Mr. McGovern. Mr. Woodall.
Thank you, Madam Chair. Just as a point of clarification, your amendment didn't end up in the committee mark, nor did it end up in the amendment to the amendment that represents the bipartisan.
That's right. I'm sorry. Mine was originally amendment to the manager's amendment. Okay. So yeah, what we took up and marked up in committee was the manager's mark. So this was an amendment originally to the manager's amendment. So it got voted in at first, and then by voice vote right after we returned for the floor, and not all of us got there quick enough. It was voted out.
I thank you. Thank you, Madam Chair.
Mr. Hastings. Thank you very much. Dr. Burgess.
I just want to thank the gentleman for bringing the amendment. I felt the same way. This was to deal with foreign terrorists. And when I spoke of mission creep, Chairman Goodlatte, what I was referring to was somehow it evolved into monitoring every single communication between United States citizens, which was not my understanding when we reauthorized in February of 2011. So I appreciate you bringing this, and I think it is critical that your amendment be made in order, and I hope the committee will consider that. And I yield back.
Thank you. Thank you, Mr. Gomer. We appreciate your coming. This will conclude the hearing section, hearing portion of our meeting. We will be taking a recess for a minimum of 1 hour, but you will get at least a 30-minute notice for reconvening. So while we don't know the exact time, I think you may be able to plan on an hour and a half between now and the time we meet again. But we will give you 30 minutes notice when we will be reconvening. Thank everybody. See you a little later this evening.
Hey, how you doing? Do they come back and will they be voting on each bill? They will be voting on the rule. So, and I think it will be one rule for both bills. So yeah, they'll just come out with reporting out the rule. So there might be some amendments offered to the rule, but basically once they come back, it should be a pretty relatively quick process. And so the amendments to the rule, are they voted on individually, or are they just voice voted? There's an agreement. What happens is the rule for NDAA will have all the amendments listed in it that are going to be in order, and then they'll just vote on the rule itself. Now, if the Democrats want to offer an amendment that was not included in that rule, they can do that and offer an amendment to the rule. So we would vote on that. So it doesn't mean we're going to vote on every individual amendment. It'll be whatever amendments the Democrats offer. But 7 that are on there now, right? Yeah. Right. So, but that's it in terms of what Republicans are going to be. No, the rule will include roughly like, I'm not sure exactly how many we're going to make in order, but roughly like another 150 amendments.
Oh, okay.
Yeah.
All right.
The only reason we did 7 yesterday was just to get the process started.
Okay.
The main bulk of this rule will be making like over 100 amendments in order to NDAA.
And then, but each of those is not voted on individually.
Right.
I
What
got
I'm
it.
saying is,
Okay.
yeah, they.
And so, but will that be published before it's voted?
No. What they do is they'll hand out the rule, vote on it, and then I can get you like a copy of it.
Okay.
And then we'll eventually.
Well, I just want to make sure that Dems will not be on that list. Based on what you said.
Yeah, you just want to make sure that it's not. Off the record. Yeah. I mean, I don't think it is.
And thank you very much for joining us for the delay to get our work done tonight. The chairman will now be in receipt of a motion.
Mr. Chairman, I move the committee grant a rule providing for further consideration of H.R. 4435, National Defense Authorization Act for fiscal year 2015 under a structured rule. The rule provides no additional general debate. Section 2 of the rule makes an order only those further amendments printed in Part A of the Rules Committee report and amendments en bloc described in Section 3 of the rule provides that the amendments printed in Part A of the report may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part A of the report or against amendments en bloc as described in Section 3 of the rule. Section 3 of the rule provides that it shall be in order at any time for the chair of the Committee on Armed Services or his designee to offer amendments en bloc consisting of amendments printed in Part A of the report, not earlier disposed of. Amendments en bloc shall be considered as read, shall be debatable for 20 minutes, equally divided and controlled by the chair and ranking minority member of the Committee on Armed Services or their designees, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule provides one motion to recommit with or without instructions. Section 5 of the rule provides for consideration of H.R. 3361, the USA Freedom Act, under a closed rule. The rule provides 1 hour debate with 40 minutes equally divided and controlled by the chair and ranking minority member of the Committee on Judiciary, and 20 minutes equally divided and controlled by the chair and ranking minority member of the Permanent Select Committee on Intelligence. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute printed in Part B of the report shall be considered as adopted and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to recommit with or without instructions. Finally, Section 6 of the rule provides that the Committee on Appropriations may at any time before 5 p.m. on Tuesday, May 27, 2014, file privilege reports to accompany measures making appropriations for the fiscal year ending September 30, 2015.
The committee has now heard the motion from the gentlewoman from North Carolina, and I would defer to the gentleman from Florida for an explanation of the rule. Gentleman, Mr. Nugent is recognized.
If I can find it, there we go. The rule provides for consideration of the USA Freedom Act under a closed rule. It self-executes the Sensenbrenner substitute amendment, which is carefully crafted by partisan compromise between judiciary and the intelligence committees. The rule for NDAA makes in order 162 amendments, roughly evenly split between Democrat and Republican sponsors. The rule provides for standard en bloc authority. Lastly, the rule contains authority for the Appropriations Committee to file a report on the THUD bill over the Memorial Day holiday. These are two very important measures. The rule allows for them to go forward.
The committee has now heard the motion from the gentlewoman and an explanation by the gentleman from Florida. Is there further discussion or amendment? Gentleman from Massachusetts recognized.
Mr. Chairman, I'm looking at the rule, and I can't find my amendment. And I'm a little bit surprised. As I mentioned to you on the phone, I'm trying to figure out which hoop I didn't jump through. I was told originally that we had an issue with germaneness, and I spent basically the entire day yesterday working with the parliamentarian to make sure that it was germane, and it was indeed germane. In fact, I changed my amendment several times to be able to comply with the rules of this House. And I went out on my way to try to make sure that it was not only a bipartisan amendment, but that it reflected kind of the diversity of opinion in the House of Representatives on the issue of Afghanistan. The ranking member of the Armed Services Committee, Mr. Smith, does not believe that we should end our involvement in Afghanistan at the end of 2014. He believes we ought to continue. I believe we ought to end it after 2014. So but we had this kind of very unique and broad coalition behind this amendment, which basically was a restatement of what we all promised that we were going to do based on last year's bill, which was a sense of Congress resolution, which said that if the president wanted to keep troops committed in Afghanistan beyond 2014, that members of this House ought to have a vote. It was broad bipartisan support on that sense of Congress resolution. Even the chairman of the Armed Services Committee voted for it. Maybe he didn't know what he was voting for, but he voted for it. And the fact of the matter is that all this amendment does, it doesn't prejudge what we should do, what we shouldn't do. It just simply says that if we want to continue the longest war in American history beyond 2014, Congress ought to vote, not be indifferent. And I look through this rule, and I find one amendment related to Afghanistan on an amendment, by the way, that we know will not pass, and that only has 10 minutes. So on the longest war in American history, with all that our men and women in uniform have sacrificed, with all that we have invested in this war, 10 minutes on an amendment that we know is not going to pass, but we have time for 50 votes to repeal the Affordable Care Act. I don't get it. I mean, what else was I supposed to do? I'm a member of this committee. The chairman knows that this issue has been near and dear to my heart for some time, and I don't, for the life of me, understand the controversy in allowing people to vote. If people want to stay, they can vote to stay. I know a lot of my colleagues who will vote for this amendment if it were made in order who want to stay. There are some of us who don't want to stay. Now, maybe the new president of Afghanistan will wow us and we'll all want to stay. But, after all this time, we don't even, I'm not even given the respect to have a vote, and I would like to know what I should have done differently in order to, it's germane, it fits, bipartisan, what else could we do? I'm on the committee. What else could I have done?
I appreciate the gentleman's discussion, and as the gentleman knows, when we had the discussion, when he called me and then I called him back, that in fact I do respect you. And as a matter of fact, you and I are even friends, and we're up here on a regular basis. I also discussed with the gentleman that a year ago that I felt like it was very important to have a vote at that time as a resolution. I believe there are times when people need a vote, Republicans and Democrats, when it really does allow a member or a group of members to be able to have a vote based upon their conscience, what they really believe, and that opportunity to do that. I was straightforward with the gentleman, told him I would go talk to Mr. Smith, and in fact I did. I went down and spent time, and Mr. Smith not only reinforced what you said, but mentioned to me very directly that he would be in support of having this be made in order. I did not include it in order based upon some more conversation that I've had, and by and large it gets down to we are now at a point where the president and this administration is winding down their involvement in Afghanistan. Last month, for the first time, there were no combat deaths in Afghanistan. I visited Afghanistan last week, just 3 days ago, and was on the ground in Kandahar. Granted, that was not at a war zone, but in Kabul. And in Kabul, it's where the embassy is, and things are a little bit different. But the sense that they had there, and that was shared by others, yes, Republicans, or that what we're trying to do is to allow this president, this administration, without trying to embarrass them one way or another with a vote that could be seen as against the president or against the war, as you and I talked about, because it would require members of both parties to vote for it. And I have made a decision that I believe it is best to let this president work through the circumstance, work through his commitment to the American people,
We have an understanding. We know what the president said. The president know what he said. But at the last minute, something could go wrong.
And if I
And rather than trying to wrap his hands up, so that's why I made that
With reclaim my
determination.
time, and maybe the gentleman misunderstands my amendment. There is nothing in here that ties the president's hands.
Well, there's a vote that would be required
Wait,
by both the House and the Senate.
Right, after the president determines what his policy is going to be, then there is a period of time in which he has to inform the Congress as to what his policy will be, and then we vote. And I appreciate, everybody's desire not to embarrass the president, but, it's hard for me to take that argument that seriously when we have select committees on Benghazi and 50 votes to repeal the Affordable Care Act. All I'm simply saying is that I believe that the American people are entitled to know where their member of Congress stands on this war when the president, whenever he does, it will be next year. This vote won't happen until next year.
That's correct.
And again, we don't know who the next president of Afghanistan is going to be. It may be somebody we all like. And maybe it makes sense to keep forces there. But I will tell you, as somebody who has talked to the parents of soldiers who have lost their lives in this conflict, as someone who has talked to countless wounded soldiers who continue to be wounded, by the way, in Afghanistan, as somebody who has talked to people, in our State Department, and people who are on the ground over there, that, they are horrified by the fact that they don't think any of us pay attention to what's going on over there because we hardly mention it. In this defense bill, the most we have is 10 minutes of debate on an amendment that we know is not going to go anywhere. That is our total effort to talk about the war that we're now involved with. And I just want to say, for the record, look, I mean, if out of deference to Louise Slaughter, and which he's going through today, I'm not going to sit here and call 300 votes, but I'd like to be honest with you, because this issue is that important to me, and to a lot of people I represent. I cannot believe that we're in this situation where this is just being tossed aside because somebody's decided for whatever reason, that we're not all grown up enough to be able to debate and vote this, but it really is awful. And I think it demeans this process, and that we have the defense authorization bill coming to the floor. The biggest issue is the war, and we're not talking about it. I don't get it. Maybe I'm missing something.
Well, if the gentleman yield, I don't believe the biggest issue is the war. I believe the war is on a glide path that the president has indicated, and that the combat death circumstance shows where we are pulling back. The president is actually trying to remove American soldiers from being on the battlefront, and I believe the biggest issues are how we're going to size our military. I'll be straight up, and I think everybody in here is wishing we would get out of the war. I don't think there's any question about that. But in that, there's a sense of following some glide path that somebody who's actually in charge of this, as the military is, with the advice and consent of the commander-in-chief, and we're simply saying we believe it's following a process, we believe that that process is working, and we think that the president is, in fact, trying to pull out. I believe the biggest issue is how we're going to deal with the military and giving them the resources and the flexibility to mirror and run their business around the globe.
And I appreciate your point of view on this, and I certainly respect the president, and I voted for the president, and I support the president, but I don't blindly support the president. And on this issue, it's not about supporting the president. If you want to support the president, you can vote to support the president when he comes up with a policy, which he hasn't done yet, and we all can evaluate and debate it. Then we can vote yes or no. But I'm going to take the issue. When we're at war, and we have men and women in harm's way in war, that is the most important issue, and that has to be a bigger issue than it's been. And just because only a small sliver of our population, are fighting that war, and their families are paying the price as well, doesn't mean that, it could be put in the background. This is an important issue. It deserves more than 10 minutes. And after all these years, that we can't even vote on what we said we wanted to vote on last year, I find that appalling. But having said that,
I think
you run the show, and I'm going to, you're going to, make it possible for us not to be able to have this debate, and so that's that.
Well, I will defer to the gentleman, and I do want to recognize what I would say.
What you were about to say, I yield to you, Mr. Chairman.
Thank you. What I would say is that I believe at this point, the president, I didn't say that I'm trying to, that I would be for the president or against the president. I believe that he is attempting to do the things that he said he wanted to do. Zero combat deaths in the last month. He's moving that direction. I was just with a huge number of troops. I heard their attitudes. We've got an election that is going on. As you alluded to, these two major candidates have both indicated they want to sign the agreement with the United States. I don't want this or any other matter to come into or be an issue.
Well, I guess the question was...
So that's what the Republicans are trying to suggest.
I think what the Republicans are saying by not making this in order is that we, the Congress, do not matter in this debate.
Well,
and I think that's really unfortunate.
And the gentleman's entitled to his opinion, but I do respect the gentleman. I did take the gentleman's call and call him back, and I did further try to work the issue further. And I do appreciate the gentleman's discussion right now, and gentlemen from Florida.
Mr. Chairman, to enhance Mr. McGovern's final statement regarding the appearance that Congress does not matter in these circumstances having to do with war. We didn't declare war pursuant to the United States Constitution, and nor have we, in many of these interventions, undertaken the kind of responsible debate that I believe that war powers are called for. And what we've really done over the course of a 30-year period is give our powers to presidents of the United States who have defined powers in the Constitution. And in this instance, we didn't really vote for being there 10 years. Now we can't vote to get out. Let me tell you a couple of things. Firstly, I'm not prescient. I don't know everything, neither does anybody. But the simple fact of the matter is some of these things are common sense. We cannot and will never be able to make American-style democracy be implanted into states, sovereign states and nations who do not want that for themselves. Now, before we went into Iraq, quite some years ago, I was on Crossfire when Robert Novak was alive. And I forget the leathery-faced fellow that was his liberal opponent, but both of them attacked me, saying that I was out of my mind about the fact that Iraq was going to be a failure. I'm not talking about who caused it. I'm not talking about weapons of mass destruction. I simply am saying that it was clear to me, based on just common sense and paying attention, that Iraq was going to be an immense failure. They both told me, I remember Bob Novak, and I debated with him at least 3 times on that program. I remember him saying, oh no, they will be waving flags welcoming America. Now, to show you how foolish it is, here we are now kind of ignoring Iraq. John Murtha and I argued that we should have enduring bases in Iraq, and I still believe that was something that should have been on the table. I don't care who the president was. And it took me 2 years to find out how many enduring bases that we had there. And we had 14, and we could easily have left 2. And there were reasons, and Afghanistan was one of the reasons. And what may take place in the Middle East, particularly as it pertains to Israel, was the second reason that I made that argument. Now the place is blowing up. And you see this day 17 get killed. Next day 71 get killed. And in the meantime, the same people that I told them that would call the shots in Iraq, Iran, are calling the shots in Iraq. And more, it's becoming an al-Qaeda haven, just as is Libya, just as is Syria. And I'm telling you, the volatility in that area will spill over. Now, someone made the argument, I believe Barbara Lee. We're not making any friends here. I want to go to Rick Nolan's, probably ignored by most in this place, and give added support to Jim McGovern's request that we at least cast a vote on this measure, giving rise to the President having to give us an understanding as to what's going on. On Rick's maps that he provided for us, in 2009, America and our allies controlled 68% of the total area of Afghanistan. Fast forward to 2014, we control now 21%, and a large portion of that 21%, where you, Mr. Chairman, and your colleagues who visited, and I applaud you for doing so, went. Here's what the problem is, and what I make a prediction as I did with Iraq. Whatever day we lift out of this place, the day following that, the Taliban are going to return in force. The al-Qaeda that we went there for, rightly, are going to be back. And it's just going to be a matter of time before that takes place. In the meantime, we should not spend one other American nickel in a place like that, nor should we spend added blood of the young people that we so much all admire. The simple fact of the matter is, I sat here and I counted them. There are 69 locations where construction, and this is on Mr. Nolan's map, where construction is going on to the tune of millions of dollars. Now, it would be one thing if we didn't need money in Texas, and if we didn't need money in Florida. But here we are going to continue to spend money in a rat hole, and everybody in here knows that it's a rat hole. I don't care which one of them people are elected. The simple fact of the matter is we're not going to be any better off when their election concludes than we are today. The day that we should have left Iraq was long since ago, rather than us being there foolishly throwing money down the drain. Now, I'll make that prediction, and I hope all of us live through the next 4 years, and I'll be back here saying to you that I told you that the Taliban would be back. That doesn't require an awful lot of thought. All that requires is just common sense to understand that we didn't win that war. The Russians didn't win it, and they lost 150,000 people, and they didn't win that war. Neither did Genghis Khan, who had the strongest forces going at that time, and he got lost in that rat hole. And now we are not going to give a member of this committee who made a reasonable request that those of us who would like to vote on this matter should have that opportunity. I don't know what all of the American people think, but I do know that most people are war weary. And I also know that all of us on this committee and throughout the rest of Congress and all of our constituents are suffering. I remember going with David Dreyer to Iraq. And the thing that consistently stays with me is the identical amount of money that we spent on a water plant in Iraq was $12 million that I had been trying for 7 years here in this Congress to get for the Everglades area, $12 million. And there we were seeing a shell of it all blown up in pieces and copper taken out of it, and our money going down that rat hole. You can't tell me you couldn't make Jim. You may not have made Jim's motion in order. And don't tell me, Mr. Chairman, because you don't want to embarrass this president. We've done every damn thing we can in our power in the Republican Party to embarrass this president. Now, I'm not a big supporter of his. I supported Hillary Clinton before this election. And I clearly am not in the loop as it pertains to the president. But the simple fact of the matter is, it's not a question of whether we embarrass him in this war. We didn't do the same thing in Iraq. And how dare we come in here time and time again and up here at midnight, and we can't give a member of this committee a vote that I believe substantial numbers of people, and it may not pass, but at least you put it on the record. I'll tell you why you didn't do it, and I'll tell you why the leadership didn't do it. And you and I know how this game is played. They didn't do it because they're afraid. We're getting ready to go into a vote in 2014, and you don't want to have your members on record saying how they feel about this, so every one of you is a scaredy cat. And Jim ain't and I ain't. And you hear me what I say when I tell you I'm not a Barack Obama lover. So the simple fact of the matter is I do believe that we have wasted trillions of dollars in this country on wars that we should not have been in. And now we are going to talk about doing it again. And in the meantime, when we should have done things, we didn't do them. And now you have places like Syria and Libya exploding all over the place. Refugees cast to the wind all over the place. Internally displaced people. And here we are up here around trying to go spend some more money in this place and complete these projects. For what? When I can't get money for the Everglades, you can't get money for your drought in Texas. And I'm spending money over here. I'm watching people that take our money and put it in banks all over the world, and we're supposed to be proud of that? No, bring our children home. There's no reason to leave them in this situation. And I have so much more I want to say. Maybe I will speak on the rule. I normally don't. I didn't seek an amendment. Mr. McGovern, myself, Louise, and Jared Polis don't seek amendments the way that many of our members do. And that's another thing we need to stop here. We need to stop members from abusing the parliamentarian's office and allow that we tell them you have to have limitations. There's only much physical work that people can do. And we shouldn't permit that on a continuing basis, and we probably should not permit me and Woodall and all of us to talk so damn long. But the simple fact of the matter is, cheer it if you will, you're still scared to vote on this matter. You are afraid too, so cheer. Cheer, damn it. Cheer. I yield back my time.
Gentleman yields back his time. Does gentleman choose to have any further?
I have an amendment.
Gentleman's right.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for my amendment, number 112, which would complete the transition of U.S. combat and military security operations to the Afghan government. It would also require a presidential determination and congressional vote to continue U.S. deployment in Afghanistan after December 31st, 2014. And I just want to read from the amendment here, just so when people say we're trying to prejudge things, all this vote would do would say we have to have a vote. In fact, the way the amendment reads is that in the event the United States Armed Forces remain deployed in Afghanistan after December 31st, 2014, then no later than March 31st, 2015, the President shall send to Congress a determination describing the purpose and expected duration of such deployment and the projected number of troops to be deployed. No later than 30 days following the receipt of that determination, Congress shall enact a joint resolution to improve the content of the President's determination. So I'm not asking for someone tomorrow to say, absolutely we have to end this, or absolutely we need to continue it. This is a pretty thoughtful amendment. It basically says, we'll give the President time to come up with his policy, and then, next year, after a considerable period of time has passed, we have to determine whether or not that was a wise choice. I don't understand for the life of me why that in any way embarrasses anybody or puts anybody at a disadvantage or jeopardizes any negotiations. It is what we're supposed to do. And so I would urge my colleagues to vote yes on my amendment.
Now heard the motion, discussion, and the motion from the amendment from the gentleman from Massachusetts. Further discussion. Those in favor signify by saying aye.
Aye.
Those opposed, no. No.
Ask for roll call.
Gentleman asks for a roll call vote.
Ms. Fox?
No.
Ms. Fox? No. Mr. Bishop? Mr. Bishop, no. Mr. Cole? Mr. Woodall? No. Mr. Woodall, no. Mr. Nugent? No. Mr. Nugent, no. Mr. Webster? No. Mr. Webster, no. Ms. Ross-Lehtinen? Mr. Burgess? No. Mr. Burgess, no. Ms. Slaughter? Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
2 yeas, 7 nays.
The amendment is not agreed to. Further discussion on amendment?
Yes, Mr. Chairman.
Gentleman from Florida is
Mr.
recognized.
Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendments by Representative Smith, Lee, Polis, Lofgren, Barber, B-A-R-B-E-R, Cartwright, Heck, and Schneider, numbers 355, 169, 229, 248, 270, 279, 283, and 294, and I ask that they be accepted as an en bloc set of amendments.
Now, with the motion from the gentleman from Florida about the en bloc amendments to seek their support for being in the motion. Those in favor signify by saying aye.
Aye. Aye.
Those opposed, no. No. Noes have it, noes have it. Further discussion or amendment? Seeing none, the vote will now be on the motion from the gentlewoman from North Carolina. Those in favor signify by saying aye.
Aye.
Those opposed, no.
No.
The ayes have it, the ayes have it.
Well, yeah, that makes a difference.
The motion is agreed to, and the gentleman from Florida, Mr. Nugent, will be handling this for Republicans.
Mr. Polis for the Democrats.
Mr. Polis will be handling this for the minority Democrats. We do not expect to have another meeting this week. I want to thank the committee for their hard work, for the staff who has worked overtime, and for the opportunity for members of Congress to be able to see our work on the floor tomorrow. We are now through with our work for the week. If we could go.